Madam, memo photo hoda? Sir, memo ಕೊಡ್ತೀವಿ. Madam, start.
Thank you so much.
Reshma sir.
Can we make a submission?
ಅಲ್ಲ ಸಬ್ಮಿಷನ್ ಅಲ್ಲ ಮೇಡಮ್, ಇದು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದೆ. ಹೇಳಿದ್ದು ಬರಲೇ ಇಲ್ಲ ಮೇಡಮ್, ಇದು ಹೇಳಿದ ನಂತರನೂ ಬಂದಿಲ್ಲ ಮೇಡಮ್. ಅಲ್ಲ ಇದು ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಬರಲಿಲ್ಲ ಅಂತ ಅದೇ ಹೇಳ್ತಾ ಇರೋದು ಮೇಡಮ್. ಎಲ್ಲ ಆಗಿದೆ ಅದು ಮೇಡಮ್, ಲಿಸ್ಟ್ ಆಗಿ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ, ಮಾಡಿ ಬರ್ಲಿಲ್ಲ, ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಲಾಸ್ಟ್ ಟೈಮ್. ಪೆಂಡಿಂಗ್ ಮೀಟರ್ ಈ ತರ ತಲೆ ಬಿಸಿ ಮಾಡಿದ್ರೆ ಹೇಗೆ ನೀವು? ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೆ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ದು ಮೇಡಮ್.
ಲಾಸ್ಟ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೆ.
Sure. Yes. ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ತದೆ ನಮ್ಮ ಕಡೆ.
See, there may be some other call Prashant. You can see it. Oh, Dalak ke tarikh ka. Madam. Madam.
What up, sir, ma'am? What up, sir, ma'am? Last month ಅಲ್ಲಿ 26 ರಿಲೀಸ್ ಆಗಿತ್ತು, ಸಾಹೇಬರ ರಜೆ ಇತ್ತು. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಂತ ಮಾಡಿದ್ರು, ಆಮೇಲೆ ಬರಲೇ ಇಲ್ಲ ಮೇಡಮ್.
Madam, memo for posting 480.
Vacating staying. Vacating.
Madam, settlement submission. Madam, settlement submission. ಇವತ್ತು 2 ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬಿಡಿ, ಬಂದಿದ್ದಾರೆ. ಹಾ ಮೇಡಮ್, ಪಾರ್ಟಿ ಸಾಚೆ
ಸರ್ ಕುಮಾರ್ ಅವರೇ ಕೊಟ್ಟಿದ್ದೀನಿ,
ಪೆಂಡಿಂಗ್
ತಗೊಂಡಿದ್ದಾರೆ,
ಸ್ಟೇ ಆಗ್ಬಿಟ್ಟೈತೆ.
ಫಾಲೋ ಮಾಡ್ಕೊಡಿ.
ಮದುವೆ ಮಾಡಕ್ ಹೋದ್ರೆ ಕೇಸ್ ಐತೆ ಅಂತ ಹೇಳ್ಕೊಡ್ತಾರೆ.
ಸೋಮಶೇಖರ್ ಸರ್, ಅಲ್ಲಿ ಗ್ಯಾರಂಟಿ ನಿಮ್ ಕೇಸ್ ರದ್ದಾಗುತ್ತೆ ಅಂತ ಗೊತ್ತು. Lord. When will they come inside the court? When will they come inside the court? ಯಾವತ್ ಬೇಕು ಅಂತ ಕೇಳ್ತಾರೆ. ಆಯ್ತು ಕೊಡಿ.
Lord, may I mention?
Sir, AG sir, yes. Unmute.
Yeah, I'm unmuted myself. Yes.
No, I'll just finish this and come.
No issue. I'll wait.
Yes, yes.
Lord, may I?
ಎಲ್ಲರೂ don't what one voice ಇದ್ರಲ್ಲಿ ಬೇಕಾಗಿಲ್ಲ. Think separate voices ಬರಲಿ. Yes. Wait, sir. Reporting settlement ಎಲ್ಲ ಕೊಡಿ.
Lord, may I mention one matter?
My lords, this is the PMLA matter where the
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಸೆಟಲ್ಮೆಂಟ್ ಆಯ್ತಾ ಎಲ್ಲ ಕೊಡಿ. ಸೆಟಲ್ಮೆಂಟ್ ಎಲ್ಲ ಕೊಡಿ. Wait, settlement whenever you want, give it. Very good. So what? So what? ಆಯ್ತಾಯ್ತು. ಯಾಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ? ಸ್ಟೇ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ? Before me. Yes. It will come. Matters which have not reached will come on Monday. That's all. Of the coordinate bench. Because in my court, nothing not reached. Come. Kodi. Give it, madam. No, it will come, madam. ಯಾಕೆ ಸ್ವಾಮಿ? 200 ಜನ ಮಕ್ಕಳು ಓದ್ತಾ ಇದ್ದಾರ. ಎಲ್ಲಿ ಸ್ವಾಮಿ? ಅಬೇಟ್ಮೆಂಟ್ ಸೂಸೈಡ್ ಕೇಸ್ ಅಲ್ಲ ಅದು. ಏನು ಎಲ್ಲ 200 ಸ್ಟೂಡೆಂಟ್ಸ್ ಮೇಲೂ ಅಬೇಟ್ಮೆಂಟ್ ಇದೆಯಾ? ಮತ್ತೆ ಪ್ರಿನ್ಸಿಪಲ್ ಅಲ್ವಾ? ಯಾಕೆ ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ? ಓ, ವೆರಿ ಕನ್ಸರ್ನ್ಡ್ ಅಬೌಟ್ ದಿ ಸ್ಟೂಡೆಂಟ್. ಕೊಡಿ. ಎಸ್. ಟುಮಾರೋ ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಇಲ್ಲ. ಸ್ಪ್ಲಿಟ್ ಅಪ್ಗೆ ಏನು ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ. ಬರ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಆರಾಮಾಗಿ ಬರ್ಲಿ, ಏನ್ ಪರವಾಗಿಲ್ಲ. ಸ್ಪ್ಲಿಟ್ those who have escaped trial we will not show indulgence. Wait sir, ಏನು ಅರ್ಜೆನ್ಸಿ? ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಕೊಡ್ಲೇಬೇಡಿ. ವೇಟ್. ಎಸ್. ಪೆಂಡಿಂಗ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ. ಗಿವ್ ಇಟ್. ಎಸ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವ ವರ್ಷದ್ದು? ಟುಮಾರೋ ಇಟ್ ವಿಲ್ ಕಮ್. ಮೇಡಮ್ ನಾಳೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇಸ್ ಹಾಕಿ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
Pending matter, vacating stay na? Stay ilva? ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಏನೂ ಆಗಲ್ಲ. ಸರ್ವಿಸ್ ಲಾ ನನಗೆ ಹೇಳ್ಬೇಡಿ, ಏನೂ ಆಗಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್, ಏನೂ ಆಗಲ್ಲ ಸರ್. ಬೇರೆ ಕಡೆ ಇದ್ರ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಕಂಪ್ಲೈ ಮಾಡಿ ಬರುತ್ತೆ. ಮಂಡೇ ಬರುತ್ತೆ.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕಸ್ಟೋಡಿಯಲ್
ಮಂಡೇ ಸೀನಿಯಾರಿಟಿ ಪ್ರಕಾರ ಬರುತ್ತಲ್ಲ. ಮಿಲ್ಕ್ ಟ್ಯಾಂಕರ್ ಎಕ್ಸೈಸ್ ಆಕ್ಟ್ ಅಲ್ಲ, ಏನು ಆಲ್ಕೋಹಾಲ್ ಮಿಕ್ಸ್ ಮಾಡಿದ್ರಾ ಮತ್ತೆ? ನೋಡೋಣ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ ಮಂಡೇ ಬರಲ್ಲ. go and comply ಸರ್. ಇಟ್ ವಿಲ್ ಕಮ್, ಲೀವ್ ಇಟ್. ಮೆಮೋ ಏನು ಕೊಡ್ಬೇಡಿ, ಮಂಡೇಗೆ ಬರುತ್ತಲ್ಲ. ನೋ ಟುಮಾರೋ, ಅಂಡ್ ಡೇ ಆಫ್ಟರ್ ಮಂಡೇ. ಡೇಟ್ ಏನಿಲ್ಲ, ಬರುತ್ತೆ ಬಿಡಿ. ಎಸ್, ಮೆಮೋ ಮೇಲೆ ಡೇಟ್, ಮೆಮೋ ಹೋಗಲ್ಲ, ಇಲ್ಲಿ ಕೊಟ್ಟರು ಹೋಗಲ್ಲ, ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರ್ ಕೊಟ್ಟರು ಹೋಗಲ್ಲ, ಕಂಪ್ಲೈ ಮಾಡಿದ್ರೆ ಬರುತ್ತೆ. ಎಸ್, ಇಟ್ ವಿಲ್ ಕಮ್, ಲೀವ್ ಇಟ್. ವೈ ಸರ್, ನಿಮ್ಮ ಮುಂಚೆ ಕಂಪ್ಲೈ ಮಾಡೋರು ಪ್ರೆಸಿಡೆನ್ಸ್ ಬೇಡವಾ? ಅಲ್ಲ, ನಿಮ್ಮ ಮುಂಚೆ ಕಂಪ್ಲೈ ಮಾಡಿರೋ ಪ್ರೆಸಿಡೆನ್ಸ್ ಬೇಡವಾ? ನೀವೇ ಹೇಳಿ, ಬೇರೆ ಅಡ್ವೊಕೇಟ್ಸ್ ತಗೋಬಾರ್ದಾ ಹೇಳಿ? ಏನೋ ಒಂದು ಮೆಥಡ್ ಫಾಲೋ ಮಾಡ್ತಾ ಇದ್ದೆ, ಎಲ್ಲ ಬರ್ತಾ ಇದೆ ತಾನೇ ಈಗ. ಅಯ್ಯೋ, ಸೋ ವಾಟ್ ಸರ್, ಯು ಕಂಪ್ಲೈಂಟ್, ಇಟ್ ವಿಲ್ ಕಮ್ ಅಕಾರ್ಡಿಂಗ್ ಟು ಸೀನಿಯಾರಿಟಿ. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, it will come sir. Who assured? 3 days alla. Not in this court. You can go and tell, not in this court. Not in a court where 500 matters are moved. Vacating, give it. Vacating 2025. Vacating stays ಕೊಡಿ ಎಲ್ಲ. ಎಲ್ಲ ನಿಮಗಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇದೆ, ಅದಕ್ಕೆ ಪ್ರೆಸಿಡೆನ್ಸ್ ಆಮೇಲೆ ಬರುತ್ತೆ. ಕೊಡಿ. ಏನ್ ಸೋ ವಾಟ್ ಸರ್? 2 men
ಅಂತ ಬರ್ದಿದ್ದೀರಾ?
So
ಮೇಡಮ್, ಇದು ವೇಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಂತ.
So what's the urgency? It will come, leave it sir, give it. Yes, no problem, give it sir. It will come, go and comply. Yes, go and comply sir. No tomorrow, go and comply. Yes, settlement ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ. Aged person is not a ground. Anything else? That also is not a ground. What's the matter? That is the matter. Yes. Why warrant?
Warrant has been issued because he has not appeared for the recording of plea.
Why you did not appear?
My application for BC, the Honorable Trial Court, is saying it should be through a government hospital only.
Correct. Don't doubt about it.
No, he's ready to get it done.
Get it done. Get it done.
Private hospital we are ready, but court is not ready.
Government hospital ಕೊಡಿ.
ಅಲ್ಲ, ಅವರು ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಳ್ತಾ ಇರೋದು ಪ್ರೈವೇಟ್ ಹಾಸ್ಪಿಟಲ್.
ಏನ್ ಟ್ರೀಟ್ಮೆಂಟ್ ತಗೊಂತಿರೋದು? ಆಯ್ತು, ವಿಲ್ ಆಸ್ಕ್ ದಿ ಕೋರ್ಟ್ ಟು ಕನ್ಸಿಡರ್ ದಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಆಲ್ಸೋ. ಅಷ್ಟು ಬಿಟ್ಟು ಏನ್ ರಿಲೀಫ್ ಇಲ್ಲ. ಅಪಿಯರ್ ಬಿಫೋರ್ ದ ಕೋರ್ಟ್.
ಅಲ್ಲ, the court is issuing repeatedly warrant.
We'll see. Give it Monday.
Lord, may I mention the matter? This is Anjanadri Beta matter. Lord, Lordship had reserved the judgment on.
What do you want now?
Lord, I filed IA number 1 of 2026. The petitioner has been asked to come down from the hill, and he's not being allowed to perform puja despite the stay order working in my favor.
We'll see when you can go up the hill. Give it. Yes.
Lord,
give it.
Lord, the urgency is he's not being allowed to go, and there's a stay order working in my favor.
You worship wherever you are. Don't go to the temple. Yes. You can worship God wherever you are.
Yes. Lord, he's the
Archana. Give it, sir. So at Archana elbekar ಮಾಡಿ.
After I secured an interim order in the civil suit, my lord, after 2 months, they go for 5.
No problem. Give it. Go and comply. Yeah, go and comply, sir.
My lord, the urgency is this, my
ಏನು
lord.
urgency? Bail ತಗೊಂಡಿಲ್ವಾ?
We have obtained bail, my lord. The
then leave it.
complainant is influential person.
No.
Repeatedly calling me for
No problem, sir. It will come on as per its turn. ನಾಳೆ 50, ನಾಡಿದ್ದು 50 already list ಆಗಿದೆ. So don't disturb that. Monday will come.
My lords, to IA to travel abroad, my lords. My
You
lords,
filed an application?
yes, ma.
Give it.
490.
tomorrow, please.
My lord,
Tomorrow.
No tomorrow, sir. Tomorrow, day after tomorrow ಆಗೋಗಿದೆ ಅಲ್ಲ. Monday.
490.
Monday ನೋಡೋಣ ಕೊಡಿ.
499 500 matter, this honorable court has already held that complainant is not an aggrieved person. Personally, no statements are made against
See,
him.
what's the problem? Fresh matter.
Charge ಆಗಿದೆ ಸ್ವಾಮಿ.
Fresh matter.
Fresh court.
Comply ಮಾಡಿ Monday
ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ಮಾಡಿದ್ರೆ Monday ಬರುತ್ತೆ.
FIR is lost against a complainant based on a political vendetta.
ಹಾ, sir.
He's an corporator.
Fresh matters ಇದ್ರೆ please give.
Phillips matters in.
ಹಾ, Monday ಬರುತ್ತೆ ಕೊಡಿ.
Phillips vacating.
Memo for
Vacating stay, give it. Memo for withdrawal.
Withdrawal.
Afternoon, give it.
PMLA case,
Give it. Vacating stay.
My lord,
ಹಾ, ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಅದು ಹಾಕಿ ನಾಳೆ.
my lord, discharge application has been,
Charge ಇದೆ 16th.
ಇರ್ಲಿ ಕೊಡಿ. Comply ಮಾಡಿ.
my lord, discharge application has been,
My lord, this is a PMLA matter
Already
where,
done.
where this honorable court has stayed the predicate offense. The adjudicating authority is not granting me adjournment despite informing that I filed a writ petition.
Predicate offense ಯಾರು ಸ್ಟೇ ಮಾಡ್ರಿ?
ತಾವೇ ಮಾಡಿದ್ದು.
ಯಾವ, which is that?
It is Sarvana Prasad. It was listed last week.
Give it. Why are they repeatedly telling them?
Listed last Friday, my lords. May be taken
ಅಲ್ಲ,
tomorrow,
ಕೊಡಿ,
my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ. ನಾಳೆ ಹಾಕಿ.
Deeply obliged.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಅಲ್ಲಿ ನವೆಂಬರ್ ಅಲ್ಲಿ ಬಂದಿದೆ.
It is my stay, my interim order.
Yes, my lord. In the predicate offense.
And that's what.
ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಅಲ್ಲಿ ನವೆಂಬರ್ ಅಲ್ಲಿ ಬಂದಿದ್ದು ಅವತ್ತು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ತಗೊಳ್ಳೇ ಇಲ್ಲ, ಅರ್ಜೆಂಟ್ ಅಂತ ಆಗಿದ್ದು ಮತ್ತೆ
ಏನ್
ಬರ್ಲಿಲ್ಲ.
ಮಾಡೋದು?
ಅಲ್ಲ, ಡೇಟ್ ಕೊಟ್ರೆ ಮಾತ್ರ ಕೊಡ್ತೀವಿ. ಯಾವತ್ತಾದ್ರೂ ಆಗ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ರೆ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
ಸ್ವಾಮಿ
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ?
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ, ರೀಚ್ ಆಗಲಿ.
ಸೋಮವಾರ ಬರುತ್ತೆ. ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗಿ,
ಇಲ್ಲ.
ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ರೀಚ್ ಆಗಿಲ್ದೇ ಇರೋದು ಸೋಮವಾರ ಬರುತ್ತೆ.
ಅಲ್ಲೇ ಪೆಂಡಿಂಗ್ ಅಲ್ಲಿ ಕೇಳಿದ್ದಕ್ಕೆ ಮೆಮೊರಿ ಇಲ್ಲದೆ ಇದ್ರೆ ಕೂಡ ಹಾಕಕ್ ಬರಲ್ಲ sir.
ಎಲ್ಲ ಹೇಳಿದ್ ಮೇಡಮ್, ಯಾವ್ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ದೇ ಇರೋದೆಲ್ಲ ಮಂಡೇ ಹಾಕ್ಬೇಕು ಎಲ್ಲ.
my lord, discharge application has been,
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ದೇ ಇರೋದು.
ಇಲ್ಲ,
ನೋಟಿಸ್
ಅದು
ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟಿದ್ರೆ ಬರಲ್ಲ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿದ್ರೆ ಬರಲ್ಲ, ಆಗಿಲ್ದೇ ಇರೋದೆಲ್ಲ ಬರುತ್ತೆ ಕೊಡಿ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ, ಅರ್ಜೆಂಟ್ ಅಂತ ಬರ್ದೈತೆ ಅಷ್ಟೇ ಸ್ವಾಮಿ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಇಟ್ ವಿಲ್ ಕಮ್. ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಬರುತ್ತೆ.
my lord,
ಎಲ್ಲ ಪ್ರೀವಿಯಸ್ ಬೆಂಚ್ ಅಲ್ಲಿ ನನ್ನ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ ಅಂತಿಲ್ಲ.
Tomorrow they have finally set up for charge, my lords. The offense is 324 and 3 of, my lords. Urgency.
Comply, sir.
Finally they have set up for charge.
No problem. No worries.
Lords are directed to obtain directions from to the state, my lord. Now, my lord, the IO has issued a 41A notice, my lord. That's, I'm pressing for tomorrow, my lord.
Why?
My lord, notice was not issued by this honorable court.
ಹಾ,
My lord had ordered the state to obtain information.
ಯಾವ್ದು ಕೊಡಿ.
41A notice or
Give
issue
it,
ಮಾಡಿ,
give
they
it.
want to continue.
Tomorrow take.
Tomorrow,
Yes.
my lord,
Friday ಹಾಕ್ತೀನಿ. ಪಾರ್ಟೆಡ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಫ್ರೈಡೆ ಬರುತ್ತೆ.
My lord, SC/ST
69. Petitioner is a student.
Go and comply, sir.
Fresh matter.
Fresh, go and comply, it will come.
It's complaint.
Then it will come.
Request for a date.
Monday ಎಷ್ಟಾಗುತ್ತೆ ಅಷ್ಟು ತಗೊಳ್ಳೋಣ. No, then rejected, yes.
Ethanol matter, my lord.
ಏನ?
Ethanol matter. where
ಅದು ಫ್ರೈಡೆ ಇದೆ. ರಿಸರ್ವ್ ಆಯ್ತಲ್ವಾ ಅದು?
The lordships, my lords, had referred the matter to the contempt bench. OMC,
No, no,
my lords,
that's right.
challenged it before Supreme Court. Supreme Court would set aside the interim order that was passed by this honorable court only with an observation that tender orders have already been issued. And with the direction, my lords, that the
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೋಗಿತ್ತಾ? ಯಾವ್ದು? ಜಸ್ಟ್ MI ರೂನರ್ ಆರ್ಡರ್. ಏನಾಯ್ತು ಅದ್ರಲ್ಲಿ?
now, my lords, the interim order passed by this honorable court is set aside.
ಹಾ,
Only, my lords, on the ground that the tender, the work orders, the purchase orders have been issued.
then what can I do?
With the direction, my lords, to this honorable court to dispose of the writ petition expedition.
ಆಯ್ತು, ಕೊಡಿ, ಕೊಡೋಣ. Next week we'll see. ಕೊಡಿ, ಕಂಪ್ಲೈ ಮಾಡಿ ಕೊಡಿ.
One matter for tomorrow, my lord.
Give it. Memos ಕೊಡಿ. ಯಾಕೆ?
Day of tomorrow posted for arguments. 138 check post.
138 ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
my lord,
ಏನ್ 311 ಅಪ್ಲಿಕೇಶನ್ ಮತ್ತೆ?
Section 45.
ಕೊಡೋದೇ ಇಲ್ಲ ನಾನು.
ಅಲ್ಲ,
my lord,
handwriting export, my lord. Tomorrow, my lord.
No, sir.
my lord, the matter is posted for,
Day of
Violated.
tomorrow posted for arguments.
No
my
problem.
lord, the matter is posted for framing of charges today, my lord. The discharge application has been
Can't help,
rejected.
sir. Monday.
My lord,
In this matter.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. Go and comply, sir. Yes.
My lords, in this matter, the petitioner's cars are seized and he's not even party to the FIR. He's not
No
even
problem.
arrayed
Go
as-
and comply. Give it, yes.
My lord, it may be taken up tomorrow, my lord.
No, sir. Yes. Tomorrow and day after tomorrow full already. For what, sir? Before here, split ಬರುತ್ತೆ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ ಸರ್. No urgency in split cases. You have escaped trial. Why did you escape trial? ಮತ್ತೆ?
My lord, the cars are worth 2.5 crores.
We'll
He's
see.
not even party to the FIR.
What, sir? Car?
Mercedes Benz. 2 cars are being seized.
For what purpose?
My lord, he's not party to the FIR. There was a search conducted in his premises to get the documents belonging to the accused.
All right.
They have not found any documents,
All
yet
right.
they've seized the car. And the car, he's produced all documents stating it's his car, he's not an accused, they've still
Seized and produced before the magistrate?
There's an application pending, my
No,
lords.
no,
but they-
PF agilva?
ಆಗಿದೆ.
ಆಗಿದ್ರೆ 451 ಹಾಕಿ, 497, 505.
My lords, it is pending before it's a speedy disposal matter, my lords.
Speedy disposal, tomorrow take it. Yes.
Lots of less. In a connected matter, my lords.
No date, sir. ಇನ್ನು 15 ದಿನ ಬಿಡಿ, ಆಮೇಲೆ ತಗೊಳ್ಳೋಣ. ಸ್ವಲ್ಪ ಇರಿ, ಏನ್ ಚಿಂತೆ ಇಲ್ಲ. You have escaped trial, so wait. No indulgence to people who have escaped trial. Wherever they have faced trial and got acquitted, you take benefit under their shadow. That we will not. So what, sir? So what? I'll grant you. Before the roster is over, we'll close it. No problem. No, you move it in the first week of April. All right? Yes. Adu ashte, same covered matter. Yes.
Lord, one submission, my lord. With respect to 2 criminal petitions, there was requisition from Honorable Supreme Court to dispose of the matter by
Idalva.
trust matter, my lord. 2 criminal petitions.
Yavudu trust matter?
It's a forged trust deed anta allegation ittu. We had moved for the. I am for
Reserve
the
madidina.
This reserved, my lord. That was requisition to
Yavudu
dispose
kodi?
it
The number kodi ಅವ್ರಿಗೆ.
within January, my lord. It's just a requisition. I understand. Just I'm making
January ಆಗೋಯ್ತಲ್ಲ.
just making submission and bringing it to the attention.
ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ನೋಡ್ತೀನಿ ನಂಬರ್, ವಿಲ್ ಸಿ. ಎಸ್, ಅದು ಚೇಂಬರ್
Proclamation against the petitioner for not paying the PF. The petitioner is completely clear that he is kindly have
proclamation for not surety.
for not paying PF.
Why did you not pay PF?
Some financial difficulty.
Go and comply and come. Yes,
Kindly have written.
we'll see. Tomorrow ಹಾಕಿ madam. 17 matters.
Every time, every quarter when.
It is complied?
Yes.
Objections have been complied?
Yes, sir.
All right, we'll take it, we'll dispose it. Yes. ನಾಳೆಗ 2:30 ಗೆ ಹಾಕಿಬೇಕು. SC/ST ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಅದು ಗೊತ್ತು ಸರ್. ಅಟ್ರಾಸಿಟೀಸ್ ಆಕ್ಟ್ ಏನಾಗಿದೆ? ಪೆಂಡಿಂಗ್ ಸ್ಟೇ ಇಲ್ವಾ? ವಿಲ್ ಸಿ. ನೋಟಿಸ್ ಆಗಿದ್ರೆ ಬರೋಲ್ಲ, ಇಟ್ ವಿಲ್ ಕಮ್ ಅಕಾರ್ಡಿಂಗ್.
Speedy disposal, next week Tuesday.
ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಕೊಡಿ. ಎಸ್, ಕಾಲ್ ದ ಕೇಸ್.
Further hearing, still number 1.
Please, Your Lordship.
Yes, sir.
I will not take much time. I just want quickly sum up certain submissions. And also, I thought, as far as that case, Realme is concerned, a lot of statements and submissions touching upon facts were made.
Yes,
I don't think I'm called upon to respond to it at great detail.
No, legal submissions, yes.
Yeah, except to respond to 1 or 2 submissions. That's about all.
Yes.
So the rest of it is all mostly factual. Of course, Monga argued with say passion and asked the court to get into greater details on facts. I don't think the court is going to get into the factual inquiry at all. So
All
let
right.
me come back to my one submission which I made on section 48B, so that I try to make it little more focused. 48B is about commitment. And 48B came after the inquiry against Amazon and Flipkart was initiated way back in 2020. Now, an argument is made that we lost an opportunity of a commitment. Now, 48B being a subsequent piece of legislation, having regard to the importance, if necessary, of a pre-inquiry procedures where the commission can bring somebody to heels. And somebody says, I am on my heels on my own, and therefore pardon me and give me a little of indulgence. So that can happen only if after the provisions came into force. Most importantly for our purposes, 48B subsection 2 an offer for commitments under subsection 1 may be submitted at any time after an order under subsection 1 of 26 has been passed by the Commission, but within such time prior to the receipt by the party of the report of the Director General under subsection 4 of 26. Now, this scheme is considered in the regulation, Commitment Regulation 2024. How will it really work? That came into force on 6th of March 2024.
Yes, sir.
And Regulation 3 talks about, Sub-Regulation 1, 3 talks about the details of the information which will be contained in the application. Then Sub-Regulation 2, the commitment application submitted anytime after so-and-so. It's virtually a repetition of subsection 2 of section 48B. Then comes 3. A commitment application shall be filed within 45 days from the receipt of the order passed by the Commission under subsection 1 of section 26. You can't alter the scheme of the regulation. So the argument, look here, we have not, before the receipt of the Director General, there is always room for a commitment application, I think falls flat on the basis of a very clear reading of Sub-Regulation 3. Both is prospective and you can't have any other way of reading this. So for today, it's just not, no scope whatsoever for an argument on commitment, which is a subsequent piece of legislation on different considerations. I don't think the court will try to say Sub-Regulation 3 will be reread in accordance with the facts of this case. Thus, having done, there are, I also want to come back to section 41 and also section 41 for a minute.
Yes.
Because I think this case raises a very important question.
Yes.
The question is, if the object and the purpose of the scheme of the Act is to ensure that there is an effective and a healthy competition and an effective regulation of anti-competitive indulgences. The word indulgence is the correct word, I suppose. So anti-competitive indulgences have to be properly regulated. I think the Commission must, the Commission must have a certain flexibility in its undertaking the inquiry and to as expeditiously as possible to come to a conclusion, is there a real indulgence or not? So the arguments made in sum and substance, according to me, is we would like the court to read into as many provisions of the Act, as many rights and duties and obligations, which I think do not really exist there. The only fundamental principle running across the scheme of the Act is, please give an opportunity to somebody who may be investigated to say, come and say, please preserve your records. Please preserve your records. You are being called upon to assist the Commission in an inquiry in which you may be treated as an opposite party. I am deliberately using the word opposite party only because it's been repeatedly used by the other side. I want to say the Act does not use the word opposite party or any other party. It only wants to say who will assist the Commission in whatever capacity they are being called upon to assist the Commission. Therefore, 41, read anything in 41 to have this conceptual distinction between two different set of parties. And therefore, to then further bring in certain sense of obligations and duties to be discharged by the Director General in the course of investigation will be to completely frustrate and stultify the orderly process of investigation under the Act. So then I come to the MRF judgment, which has been relied upon both in railway and other cases. The judgment compilation has it, which has been submitted by us. Begins at page 469.
Judgment compilation. Yes, sir.
We always cite precedents to say how one small fact can make a world of difference in the ratio. Lordships know that very important principle. And then we always say, right, let us look at the facts of a particular prism and see how this ratio is, of course, universally applicable. Now, I want to say this particular judgment, cannot have an universal application. One, it is a fact based consideration by the court. And even if it is not so, I understand that the court proceeds on a certain perspective about Section 41 and Section 26. In this case, what happened was that the DG was called upon to make an inquiry against JK Tires. And thereafter, while he went ahead with the investigation, he moved an application before the commission asking for a further permission to inquire into few more persons. At that point of time, the commission passed an order, which a court will find at page 471.
Yes.
I also want to probably flag an aspect here. Internally, in the process of investigation, if the Director General thought that I must have a certain way of processing my investigation, and so that I know how to elicit information from which party, in what way, he may conveniently, for his own purposes, and for the purpose of later placing a report before the commission, call somebody a third party, call somebody an opposite party. But this is for the purpose of convenience of the Director General, not that it is written into the text of the Act at all. Nothing can flow from the Director General saying, I treat you as a particular status, and therefore that becomes inflexible and written as, on stone. So therefore, kindly see how this, at page 471, paragraph 12, on a receipt from the Director General, the commission passes an order here at paragraph 12. In this matter, the commission, with the order dated so and so, had directed to cause an investigation into the matter and submit a report. Now, the DG has moved a note dated 17th of August 2020, proposes to investigate the following tire manufacturers, and so on, so and so. Today, the commission considered the aforesaid note of the DG and observed that in the reference, though JK Tire and Industries Limited alone was impeded the opposite party, it is averred therein that other tire manufacturers had not participated in the tenders floated by the informant. In these circumstances, it is directed to the commission that the DG shall be at liberty to investigate the role of other tire manufacturers who have not been specifically arrayed as opposite parties as may be required for the investigation purpose. In view of the aforesaid, no other or further direction is required to be passed in the present note to the DG, and the commission takes note of the proposal for adding of the aforesaid tire manufacturers. They stand impleaded in the present reference as OPs number 2 and 3 respectively. Now, what the court proceeds, having made an earlier observation in paragraph 11, it makes an observation in paragraph 11. The authority itself has drawn a categoric distinction between a party to the proceedings and a mere participant, being a third party, and distinction thus assumes relevance. I think I stop here for a minute and come back to it. Why this observation probably is not properly premised or rooted in the scheme of the Act at all. Now, kindly turn to page 473. On the facts of the case, what happened was, even the earlier order of 1st of November 2019 was not, for whatever reason, was not shared with this party. Therefore, they had a grievance. That could be a procedural lapse. So we don't have any such fact situation here. So the 26th order has been shared with everybody. Now in paragraph 22, what happened in went into the mind of the court. And before paragraph 22 and paragraph 20, the larger issue that arises for consideration is as to whether the change of status of the petitioner from participant to so-and-so is material, and whether it is contrary to the provisions of the law and the procedure contemplated under the Act and the connected regulations. Now let's skip paragraph, go to paragraph 24. In my considered view, an entity is entitled to know the status under which is present and participation is sought in statutory proceedings. This is a very general statement. It all depends on the context of a law. It could be a criminal law, it could be any regulatory law like SEBI. So this general statement is probably, I think, has arisen in the mind of the court, having regard to understanding that 41 posits that there is a status, third party and opposite party. Then the next sentence, the application of the statutory provision and connected regulations, their consequences, as well as the available protection would vary depending on the status of the party. Again, it's a very general statement depending upon the nature of a law. Thus, unless a party is aware as to the specific provision under its involvement is sought and obtained, it would be in the dark as to the measures available under the law. There is no difficulty on the facts of this case here at all. 26-1 order was brought to their notice. The details which the Director General sought from them put it very clear with them, as good as you are seeing yourself on a mirror. So there's therefore no lack of clarity as to what exactly they were asked to respond to. So therefore, to say that what is observed in paragraph 24 should be treated as a proposition of general and universal application, I think there is some difficulty there. Then the court proceeds on the facts, I think at page 475 to 477. And in paragraph 37, it again, in a manner of speaking, restates what is said in paragraph 11 and 24. Subsection 4 empowers the DG to require a third party, a party other than the party under investigation, to furnish information, produce books. Section 41(4) thus relates to a third party. A clear distinction is thus made between the party under investigation and the party arraigned, as the opposite party in the reference, and a third party to the investigation. Well, if suppose in a given case the DG styling somebody as a third party, but ask for information which only a third party can give, then of course one can understand I am for all practical purposes soliciting an information from you which may not have no implications for you at all. But if I'm asking information which have all the implications for you, that you will be treated as a party to be investigated, then there is no doubt whatsoever, neither in the mind of the DG nor in the mind of the person who receives the notice from the DG.
So it is only information without implication.
That's right. Absolutely. And that's why even in 41(3) it says, I think I want to stress the proposition again. 41 is not a right giving.
Yes.
A right giving proposition. So therefore, if that is correct, then I don't know whether para 37 observation would hold good. Then one more paragraph at page 478, paragraph 39. In the present case, a report dated 17/8/2020 has been furnished by the DG, which has not been furnished to the petitioner.
It's a note, not a DG report. It's that note.
Then we don't have a problem here. Subsection 4 provides for the commission to forward a copy of the report referred to in subsection so-and-so. The term used in 26(4) is parties. Since a copy of the report under 26(3) has not been furnished to the petitioner, it's clear that it is still being treated on par with a third party to the proceedings. So on facts of this case, also again it's clearly distinguishable. But I suppose, without going into the facts, if the understanding of the court that there is something to be written into the statute by reading the status of parties to be treated part of section 41, I think there is something to be seen there. And then paragraph 44, page 479. Section 27, which I have referred to earlier, sets out the scope of the orders passed by the commission and provides for strict penalties. Thus, for a party to be the subject to the rigor of section 27, it must be afforded sufficient opportunity to contest its inclusion, impleadment as a contesting party, opposite party, and will put on notice. The question is at what stage?
12. Yes, sir.
Therefore, the question is therefore at what stage? If everything comes to a conclusion on the report given by the Director General, and the report will be determinative on what the commission will do, well, you have some questions open there. But the report is only a platform or a basis for the court commission to go further in the inquiry. No, we have all those wonderful provisions in the regulations and the act scheme, which says parties can be impleaded, anybody can seek to be impleaded, somebody can make parties. All those provisions are available both in the act and the regulations. So at any given point of time, before the commission commences the inquiry, if the commission perceives that there is a scope for some error which could have crept in the reasoning analysis of the report of the Director General, the commission will halt for a minute and say, let me take a close look. If that opportunity of taking a close look is available here, will the court now, High Court will be converted in some kind of a quasi-commission, pre-commission inquiry stage, or some other very special proceeding? I think my submission will be no. The answer will certainly be no. So in a manner of speaking, the High Court is being asked to step into the shoes of the commission and to possibly find out such holes as the commission may itself find or may refuse to find in the DG's report, and therefore say the commission is no longer competent to go along with the inquiry. It's something very peculiar is happening in this case. And probably it can happen only when big giants like Amazon and Flipkart can shoot from somebody else's shoulders. Now, one final submission on regulation, on section 48. So Real made some submissions on that. As I said, section 48 of the Act. The argument is that, look here, before you proceed to put on the mat the directors or anybody in charge of the proceedings in the company, now the Director General probably should inform them, and then they will probably to then tighten their belts and to find out whether they have something to hide or not. Now let me understand section 48 very differently. 48 is a standard provision in many regulatory statutes, and more importantly in the Companies Act. So the moving what's called the moving brain behind a company. So 48(1) only talks about the liability of the company. 48(1) says where a person committing contravention of any provisions of this Act or of any rule, regulation or order is a company, then ipso facto, without anything more, every person who at the time the contravention was committed was in charge of and responsible to the company, as well as the company shall be deemed to be in contravention of this Act. Both the company and the persons in charge of the company shall be deemed to be in contravention. So when there is a deeming provision here, then comes in subsection 3, a further enhanced situation where the commission will be called upon to find out if somebody is in connivance or at a very higher level of, assisting a anti-competitive agreement. So subsection 3 says, where a contravention of any provisions of the Act, rule, regulation, so has been committed by a company, and it is proved that the contravention has taken place with a consent or connivance or is attributable to any neglect on the part of any director, manager, secretary, so and so, shall also be deemed to be in contravention. Therefore, this is something like where you can't escape the net of your liability and contravention. Connivance, consent are extremely important aspects to be taken note of by the commission in the course of the inquiry. And we often see in many, like a 138 provision, a director cannot escape liability if you virtually, knowingly signed a check and things like that. Therefore, having regard to the scheme of the Act, to say that the director, there can't be a splitting up of inquiries and investigation. Directors must have an opportunity of being told, are you really an accused or not? I ask myself the question, to what heights and to what extent will you kill the scheme of the Act? I ask myself another question. The directors are the puppeteers, right? They operate the puppet. Will they come and say, look here, I must be told as a puppeteer, the puppet has a mind of his own, but the puppeteer should also be told, be careful. The puppeteers and the puppet are one and the same entity. There's no separate mind. It's the puppeteer's mind who operates the puppet. So 48 cannot be a exit route for some directors to come and say, oh, we did not have a notice from the DG that I am a third party or an opposite party. Let me have all those luxuries. So that's one submission. Then I just want to invite the court's attention to the judgment in Cadila. In the compilation, the judgment begins at page 146. Here's the answer. Yeah. May I invite the attention of the court to at page 157, points of controversy. Issue number 4, whether DG could have issued notice to Cadilla's officials under section 48. Point number 4 is begins to be answered at page 181. Cadilla's arguments on this, para 64, Cadilla's arguments on this aspect is that without first recording the company or otherwise of a company, its directors or employees, officials cannot be issued notice for contravention of the Act. In other words, according to Cadila, the CCA had to first record that the company is guilty of an abusive act, after which it can proceed against the directors, etc. The relevant provision is as follows. Then, question number, para 65. So sorry. The question sought to be agitated or urged before another single judge in Tran Mera versus so-and-so, when the court held as follows. I am in agreement with the submissions of Mr. Chandyok. There cannot be two separate proceedings in respect of the company, and the key persons of the scheme or the act of my mind does not contemplate such a procedure. The procedure suggested by so-and-so is both inefficacious and inexpedient, as in every such matter, including the proceedings under section 138 of the Negotiable Instruments Act, a procedure of the kind suggested is not contemplated. The judgment of the Supreme Court in case Anita Hada dealt with proceedings under section 138. Judgment does not deal with the issue at hand. Whether adjudication in two parts contempt so is permissible, judgment opinion is distinguishable. Then para 67. Anita Hada had set to address the controversy whether in one proceeding against the company, its director can also be prosecuted or proceeded again on the principle of vicarious liability. Before Anita Hada, there existed a dichotomy of opinions on the one hand in so-and-so, director could not be. Then it is answered, paragraph 58 in Anita Hada is extracted, page 183. Applying the doctrine of circumscription, we are the considered opinion that commission represented by the company is an express condition precedent to attract the vicarious so-and-so, as well as the company appearing in the section make it absolutely unmistakably clear that when the company can be prosecuted, then only the persons mentioned in the other category could be vicariously liable for the offence subject to the government's petition. So one cannot be oblivious of the fact that the company is a juristic person and his own respectability. If the findings are recorded against it can create a concavity in repetition. Situation, the corporate repetition of the director is indicted. This court is the opinion that the correct interpretation of the law was given in Pranmera, the reasoning of which is hereby confirmed as the reasoning in so-and-so, which proceeds on a correct appreciation of the law. Accordingly, Cadila is given with respect to issuance of a notice director by citing section 48 is without substance and rejected. Therefore, I don't think I need to respond again to this submission that splitting of the case into 40-219-1 and 40-219-2 should carry any substance at all. Because ultimately the question is whether any parties from whom information and documents and materials are solicited are in an anti-competitive agreement. Then for the purpose of convenience and also for maintaining confidentiality between two sets of parties, if the commission says, let me separate the inquiry, we'll say, okay, you are doing something fundamentally wrong. I do not know how I'm going to be before you in the course of inquiry. I wonder how much of these extensions in the reading of the statutory language should be permitted in a matter like this. So splitting of the case is for confidentiality, an argument between the two entities. The D was look into the matter again to say into the matter. So then I think probably in Railway the question about somebody is an affiliate had not already been argued. So question is not what exactly are the sharp lines that would drawn between who exactly is in what kind of a anti-competitive agreement, but what is the nature of the anti-competitive agreement? Is there some anti-competitive agreement? And thereafter come to the conclusion whether what is the role which each party is playing in indulging in anti-competitive agreement. So this will be the framework in which the Director General proceeds. As I said, the Commission is always with all the authority and the power to look at and score and scan closely. If there is something which has gone wrong, let me ask the Director General to inquire into it, correct some errors, or I'll correct the errors myself. So the question is, the Commission is at large always with all the plenary powers. So I don't think the court should probably be called upon to, at this point of time, 5-6 years, and stop everything now. What's that? And I want one small submission, the minor submission. The CCI is an authority by it can't delegate. It cannot subdelegate. It's not subdelegating its powers. So it's only asking the DG to investigate on behalf of the Commission. And if that is so, the question as to what stage and who can come and ask the Commission to add parties is also well laid out in this Act and the regulation. So I've been in Cadila, Excel, Sale, all the judgments answer this question. The opportunity to walk into the Commission's premises is always available, and to say if there is some infraction of justice in the hands of the Director General, I go to the Commission and say, add me as a party, hear me as much as I would like to be heard. So where is the injunction or embargo or the lack of such opportunity? Certainly not.
Yes.
So if there is anything further to be added later, I will put my written note. And I am grateful to
you can file a written note, sir.
I will do that.
Yes, that would be helpful. Yes.
I'm grateful to the court.
Yes.
May it please, my lords. My lords, I will just add to what.
I have not permitted you.
Yeah. May.
No. Yes.
So, my lords, obviously there was a certain arguments which were raised.
It's in a lighter way.
No, I understand, but I will address that question because that question fell from the bench also.
Good.
That should the informant be heard?
Informant should be heard.
Informant
Yes.
should be heard.
Yes.
Because, my
So
lords.
you will be heard.
Yes.
Start.
Yes, my lords.
My lords, the only submission which is I'm reiterating what Mr. Puvaya said on the last occasion, which is that he's not impleaded in our matter, my lords. Therefore,
In general,
matter, my lords,
he is assisting the court in legal submissions. Factually, neither the Attorney General has completely addressed, because factually, it's not the stage to go into facts. It's all legal submissions I'm considering. And
provided
informant has a right to make submissions. If he is an informant, made a party in any other proceeding, fine. In this also, let him argue. I am permitting him. Yes.
I will only add, we are in an age of information technology.
That's what. Yes.
So, my lords, I will not address with the informant party because I've been allowed. My lords, the first question is the entire aspect that learned AG also said. The DG report is out. All the parties will have all the objections, every opportunity before the CCI. And it has periodically happened that the DG report has been reversed. On facts, on law, they said no violation as the case may be.
Yes.
So so the only thing that they have said as far as prejudice is concerned is commitment. Obviously, commitment is prospective, like learned AG also said. I'll just add one more
Commitment,
point.
48B.
48B.
Yes.
I'll just add one more small aspect to that, is that when the lawmakers introduced this commitment regime, they were aware of pending investigation, including this and including others also.
So they would have put in some clause.
Some repeal or savings clause, they would definitely have put it. They did not put that in. So it further fortifies the fact that it was always supposed to be prospective in nature for new investigations. Second part is now stemming from that is the part that an argument was made that a fresh 26(1) order has to be part at once you add the petition. Let's assume, for the sake of argument, on a demurrer, this argument every time they say that 26(1) order has to be part. My lords, 26(1) clearly says matter, like there are loads of judgment which learned AG has also said. Here, what is the matter all about? The matter is not that there's an agreement between Amazon and Flipkart. That's not the agreement which has been discussed under 3.1 read with 3.4, as the prima facie order says. The agreement on the question is agreement among Amazon, the brands and the preferential sellers, and Flipkart brands and preferential sellers respectively. So that is the matter which has been contemplated under the section 26(1) of that, and that is the matter. So for them, if their argument is 26(1) is a jurisdictional fact, I also say 26(1) is the jurisdictional fact because that's the initiation process. The jurisdictional fact has to be read the manner in which the order has been given, and the prima facie order is very, very broad, and that is the matter that is being there. Now, my lords, one more aspect, and that's a very practical aspect. Obviously, Excel Corp says you can add parties, etc. You are dealing with digital markets, my lords. This entire inquiry is about digital markets. When an information is filed or when the commission passes a 26(1) order, they are not aware because the investigator, who are the parties which will be involved. You can change, just hypothetically, today, not in this matter, say company A has an agreement with company B, which is supposed to be the matter, and the matter says like digital market or artificial intelligence. The moment if the argument holds that when you add company C, you need to go back to 26(1), then the hats of the parties will keep on changing. That is not the intent. The intent is whether, for example, you're talking about artificial intelligence. If there's a matter which says, what are the competition law issues in AI, for example? If, for example, you find new party, which may be an opposite party, you go back to the commission, it derails the entire process. Why? Because supposedly that party has a right to offer commitments. They know the matter from day one. So if they would have offered commitments, they could have come, hypothetically, if the commitment regime existed even in 2020, I'm taking that argument. If the commitment regime would have existed in 2020 also, they were aware of the matter. They knew that there is an arrangement. I would have come forward saying, Commission, this is the arrangement. Please say that there is no, and I'm offering commitment regime. But that is not the case here. Today, it's not that even the rights is foreclosed. They can offer settlement also. There are two regimes, commitment and settlement regime. They can offer settlement also. The only difference between commitment and settlement supposedly is that a portion of settlement amount will have to be paid. Now, there have been cases within the CCA also lately in the last 1 year, after not in the commitment or settlement regime, but generally they have said cease and desist order has been passed, but no penalty. So settlement amount is a portion of penalty. CCA may well say that, okay, you don't have to pay settlement amount. Depends on what are the facts.
That stage is yet to come.
That stage is yet to come, but I'm saying
now the submission is, when you add them as OP, 48B is the amendment is in place. Once you add them as OPs, they should get all the statutory rights that are available under the Act. If by the act of the DG, in not adding them as OPs earlier and treating them as third parties, they did not want to exercise their rights. They need not exercise because they were their third parties. Now you bring in as, it is like drawing someone as accused at a later point in time. Now, a statute gives them right to compound, commit, settle, or whatever. If after adding you have that right of compounding and you say no, everything goes before the, now compounding is a process that can be done before the CCI or even before that. It can be done even before that or only before the CCI.
Only before the CCI. You have to offer commitments to the CCI.
All right, commitment before the CCI. At what stage?
So after the 26(1) order is passed within 45 days, that's what the regulation.
All right. Where is the 26(1) order in their case?
My lords, the 26 order, that's what I'm saying. 26(1) order is about the matter. The matter in question is the entire ecosystem. They are a part of the ecosystem.
So you're on the ecosystem.
Yes, my lords, because that's what the wordings of the 26(1) order is in this particular case. Leave alone retail savings because that's I'm making an argument on the demurrer. The 26(1) order, because it is not possible for an information provider or for the CCA on day one to know with whom are these preferential listing arrangements are. So that is the ecosystem which is in place. So they could have come forward, hypothetically, they could have come forward and offered a commitment. That's the matter. It's not a case. My lords, I'm making a very, which Cadila also says, 26(1) order talks about the matter. If the matter, you have to read the 26(1) order the way it is. Matter is the ecosystem. The matter is not Amazon's practice. Its matter is the e-commerce ecosystem perpetuated by Amazon and Flipkart respectively.
Yes.
Now, following that, there's one more argument which was raised, and I'll pause there because that's my limited argument, was that they should have given a right of hearing before being made from an third party to an opposite party. CCI versus SAIL in para 78 and 79, I'll put that in the note, is very clear that there is no right of audience before even commencing an order against an enterprise under investigation. Same logic should apply herein also. And I would raise the bar to such an extent to say that once the investigation has showed, I'm not going to the facts, but principally, once the investigation is showed that yes, you were a part of this entire process, an entire, what the DG has called it, an anti-competitive system, what is the CCI, what can the CCI do? CCI send the DG report for their comments because the DG has found something against you during the process of investigation. They've gathered information, they've analyzed the information. So they've gathered for example, they've gathered from all across the room. Then they assimilated it, they understood that there is something to be looked upon. So now the CCI has got a CCI, send the DG report to them. What is expected of the CCI to do? And they have all the opportunities right now to argue their proposition. So there's no right of audience, even if there's no right of audience when the investigation is started. Amazon, Flipkart did not have a right of audience, supposedly. How can the third parties, when they're impleaded, have a right of audience? So that is my point. Commitment, there was no repeal and savings for pending investigation. Arguendo, it's a matter. So these are my two limited submissions, my lord. Anything? Yes, ma'am.
That's it.
That's a small point because a large part of my submission was Informant is a party, but that.
That's all right. That I've accepted. Anybody else on this side? Nobody's here?
I'm here. I'm here.
Allah, this side.
Oh, that's fine.
On the union side.
Yes.
So both of you are done.
CCI
and
Respondent.
Informant both. All right. Why, sir?
Maharaj, although I was itching to object to Mr. Abir Roy's submissions, the Lordship's permitted.
But they were
and
legal
he's a-
submissions.
Yes. No, and he's an astute counsel on the competition side, Maharaj. My colleague.
Yes.
It's a pleasure to hear him. Maharaj, I have one prayer to make if it receives my Lord's approval.
Yes.
All that is left now, my Lords, is rejoinder. Amongst the petitioner side, my Lords, we will, amongst lawyers, decide, my Lords, that only maybe 3 or 4 of us, rather than all
Correct.
15.
Not all of them. Last time I told you sit across and decide who is going to submit as a rejoinder, and
Please.
not all the 15 councils again saying.
Yes, my Lords. We'll do
Last
that.
time
We'll
also
have a. Yes, my Lords. We'll do a short note on that.
Not all
rejoinder.
did, of course. Few of them adopted it. That's fine. Yes.
And we will, of course, accommodate the lady, my Lords. She will certainly be one of the councils because she's keen,
Precedents,
my Lords.
sir.
Precedents, my Lords, for sure, my Lords. I am a father of 2 daughters, my Lords, so therefore I understand.
Yes.
My Lords, would your Lordships consider giving us one date, my Lords, where we can finish the rejoinder? At my
But on
Lords'
that day, it should be over on that day.
Yes, please, my Lords.
Yes. Well,
My Lord would accommodate us even in the post-lunch session. I may actually take about an hour and a half. Rejoin.
what happened to your voice?
My Lords, apparently the court yesterday that I was arguing in turned up into an Arnab Goswami news channel. So I had to
Oh.
shout, Lords. Just lost my entire
Don't worry, you
voice.
need not shout here. Yes.
My Lords, I may have to take about an hour, 15 minutes because learned attorney.
You want to do it today?
No, my Lords.
Ah.
You can come on another date because I won't be able to.
Yeah, correct. That is why.
Yes, my Lords. I'm only requesting if my Lords would keep even the post-lunch session for us on the date that is being
All
set
right.
for us.
That suits the court as well.
They-
We'll keep it at 2:30 on a particular day and finish it through the day.
Whole day, my
I
Lords.
think she's
If,
asking for the full day so that
yes,
they
my
can
Lords.
Full
respond.
day?
Saturday, yes, my
She
Lords.
wants to respond post.
If my Lords, I can,
Full day is
Lords, because
difficult.
my turn will come only later. And I'm
No,
sure Mr.
from
Goyal-
2:30, I can assure you, even up to 7 o'clock, I'll sit and finish it. But full day, then it will be troubling the advocates here.
My Lords, I'm in the hands of Mr. Goyal and
Who is, sir?
If everyone
Yes,
is
please, madam.
agreeing,
I'll,
I'm okay with
I'll fix it on a particular day at 2:30. Even
Please,
if it is
madam.
6:30, 7 o'clock, we'll wind it up that day.
Indeed, my lords, we will be before your lordships.
So if you are, it's a rejoinder submission, it's not for the first time. So if
Correct.
it's a rejoinder submission, rejoinder cannot be lengthier than
My lords,
the
I understand.
preliminary
But some of the
submissions,
submissions
primary
made by,
submissions.
my lord, some of the submissions made by learned attorney didn't deal with the facts.
No, now you don't
but
worry.
those-
Voice, throat is not all right. Will you fix, who sir, yavat bek?
Second April.
18th. 17th.
2nd April. Your lordship court suggesting
No,
2nd April?
in this month, sir. We'll finish it off in this month.
This month.
27th is fine.
My lords, I'm not in it. My lords, I'm traveling back on
My
2nd
lords,
of April.
the
You're
only
back on 2nd
request,
of April.
Yes, my lords.
No, no.
Then
lord,
can
the
we
only request.
have
I'm
this
sorry,
on
my lord.
10th of April and finish it?
10th of
Yes,
April.
my lords.
Yes, please, my
My
lords.
lords.
Yes.
Yes,
10th of April. I'll
When-
try to accommodate you from 1 o'clock itself.
Deeply obliged, my lords.
No, no, I'm.
We'll post it at 10th of April at 1 p.m. and then run through it.
We are very grateful.
That should be fine.
Yes, please.
If I need to respond for 10, 15 minutes, then we'll seek the court's indulgence if possible, if need be.
No,
I don't
on
think
that
I will
day
ever try to
itself we'll
join
finish
that
it.
opportunity.
No, on that day
And,
we'll try to finish it. Yes.
Yeah. And Mr.
And
Buvaya has
you can
promised
always
me-
give your written notes, whatever it is.
We will do that.
You can be rest
I-
assured the order will find everybody's argument and every note.
We have no doubt about that.
Yes,
No doubt.
so don't have to worry.
And then on the lighter side, that will be with the court's own intelligence, not with any assisted intelligence. I know that. And so Puvaya has promised me that he will not take more than 15, 20 minutes.
My lords, I have promised the learned.
I was not aware of this assurance.
No, no. My lords, I have promised to take the attorney to Vidyarthi Bhavan for dosa, my lords, after the hearing. That's
Oh,
what I have
then
promised.
Second?
Or fourth.
Second or fourth will not be suitable for the court?
second and fourth. Fourth is Saturday, sir.
Saturday.
10th is fine, subject to the learned attorney.
Let
I
it
guess
remain-
10th
let
would
it
be
remain on
perfect.
10th. Let it remain on 10th.
Because there are spade of holidays from 1 to, I think 31st is a holiday, again 3rd is a holiday.
Yes, please.
So we'll take it on 10th and try to wind up on that day.
Very grateful.
Yes.
Great. Great.
Yes. Interim orders will continue. Last time when I get copy paste. Appear at the last time. Yes.
Grateful.
ಇವ್ರದ್ದು ಹಾಕ್ಬೇಕು ಅವರು ಬರ್ಕೊಂಬಿಡಿ ಹೆಸರು ಬರ್ಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್ ಹೆಸರು ಬರ್ಕೊಂಡು
Let's continue.
ಶಂಕರ್ ಏನ್ being spoken to
Number 2.
Mike
Well, Lordship, about granting stay about accused number 3 and 4. My lord, the CGP submit that, my lord, charge and has been already framed.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಾ
ಆಗಿದೆ, ನಾನು ಪಿಟಿಷನ್ ಆದ್ಮೇಲೆ ಆಗಿದೆ. ನಾನು ಫೈಲ್
ಹಾಕಿದ್ಮೇಲೆ ಆಗಿರೋದು.
ಇದನ್ನ ಅವ್ರಿಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ, ನಾನು ಕಾಪಿ ಟ್ರಯಲ್ ಕೊಟ್ಟಲ್ಲಿ ನೋಡ್ಬೋದು ಸ್ವಾಮಿ.
2nd February 2026 ಪೆಟಿಷನ್ ಹಾಕಿರೋದು. ಯಾವತ್ತು ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋದು?
ಮಾರನೇ ದಿನನೇ
ಕೊಡಿ.
ನಾನು ಈ ಪಿಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತಾನು ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದನ್ನು ರೆಫ್ಲೆಕ್ಟ್ ಆಗ್ತದೆ, ಅದ್ರ ಇಸ್ ನಾಟ್ ಸ್ಟೇ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಫ್ರೇಮ್ ಮಾಡ್ಬಿಡ್ತಾರೆ.
ಆಯ್ತು, will recall this order. The subject petition was disposed on the score that the charges stood framed as on the date the petition had been preferred. A perusal at the the learned counsel for the petitioner has placed the order sheet maintained before the concerned court which depicts that the charges were framed after filing of the present petition on 3/2/2026. The petitioner had also filed a memo before the concerned court that the petition is pending before the court, notwithstanding the pendency, in the light of no interim order, Charges have been framed. In that light, the order stands recalled. Post the matter tomorrow in the fresh matters list.
Oblige.
ಅದು ಆರ್ಡರ್ ರೀಕಾಲ್ ಆಗಿ ಅಲ್ಲಿಗೆ ಹೋಗಿ ಬರ್ಬೇಕು. ಮಂಡೇ ಬರಲ್ಲ?
ಬರ್ಲಿ ಸರ್, Lordship. Oblige.
Yes.
Fresh matter seal number 3.
Serial number 3. State is filing this petition, my lord. The organization was.
3 ವರ್ಷದಿಂದ ಆಗಿರೋ ಆರ್ಡರ್.
That's correct. The issue, my lord, the organization was banned under unlawful activities.
ಗೊತ್ತಾಯ್ತು, PFI.
Correct.
Building was used for PFI activities.
Correct. The trial court comes to conclusion that there no material exists. And we have produced the material to show that the members who are the association, the trust members.
ಈಗ ಏನ್ ಮಾಡಿದ್ದಾರೆ?
He rejected the all the seizure and confiscation.
You have returned everything now?
That I'm
3
not
ವರ್ಷ
sure.
ಆದ್ಮೇಲೆ ಏನ್ ಉಳಿದಿರುತ್ತೆ?
ಅಲ್ಲ, but that
That we will issue notice ಅಷ್ಟೇ.
because the other
Stay ಎಲ್ಲ
members
ಕೊಡಕ್ಕಾಗಲ್ಲ.
ಆಗ್ಬೋದು.
ನೀವು 3 ವರ್ಷ ಆದ್ಮೇಲೆ ಹಾಕಿ ಪೋಸ್ಟ್ ಮಾಡಿಸಿದ್ದೀರಾ. Emergent notice to the respondents returnable by the 18th of April. Served? ಯಾವ್ದು ಸರ್ವ್ ಆಗಿದೆ ನೋಡಿ. ಸರ್ವ್ ಆಗಿದ್ರೆ ತೀರ್ಮಾನ ಮಾಡೋಣ, ತೊಂದರೆ ಇಲ್ಲ. The respondents are served on 6th February 2024 itself, but have not chosen to represent themselves. List the matter on next Wednesday admission, 18th, 23, sorry, Tuesday, 17th. We'll close it on that day.
Number 4.
Sagar. Milords, I filed an application, Milords, under 173(8), Milords. That, Milords, is not disposed of, Milords.
Further investigation.
Further investigation, Milords. Complaint specifically says that, Milords, I was carrying 50,000 cash, and, Milords, forcibly, Milords, I was made to sign on blank papers. Now, charge sheet is filed, Milords, excluding, Milords, those two.
173 further ಮಾಡ್ಲಿ ಬಿಡಿ.
After framing of charge, trial court may
Charge frame ಆಗಿದೆಯಾ?
Milords,
Charge frame ಆಗಿದೆಯಾ?
Yes, Milords, yes.
Trial has commenced?
Milords, a trial, Milords, has not yet commenced. Milords, at that stage, Milords, what has happened is, Milords, CW1, Milords, summons was not
Whatever,
served.
charge frame ಆಗಿ trial commence ಆದ್ಮೇಲೆ no warrant to further investigate.
At least not by the trial court. They have to.
If the court just feels so moto, ಅದು ಗೊತ್ತಿದೆ, that power is not available. But that is not tested before me. Anyway, this.
No, all that I would request is, Milords, your Lordship, may kindly direct, Milords, disposal of this application, Milords. If the.
No, that will be a direction.
No, for on
something contrary to law.
No, Milords, in accordance with law, Milords.
Vinubai Kodi. Where is Vinubai judgment?
Milords, that I was seeking only for consideration, Milords.
Oh, no, 2019-18 SCC 1.
Yes, Milords, I've read that. Milords, what has happened is, Milords, witness summons, Milords, is ordered. Milords, witness summons, Milords, is not at all served on me.
No,
Milords, proclamation is taken.
That's a different thing. 3-judge bench is clearly held. Application under subsection 8 of section 173 is or 156(3) even is maintainable only till the stage of framing of the charges. Once charges are framed,
Milords, the victim, Milords, would get to know, Milords, the charge frame, Milords, once, Milords, the summons, Milords, reaches him.
Yes. Hanganta amel, then there will be no end to trials. If we set the ball in motion like this.
Milords, witnesses say that, Milords, 50,000 is taken. In spite
That's a
of that,
matter
Milords,
of trial, sir. What charges are framed or whatever. What, you are not happy
There
with
is
the
no-
frame.
there is no
You are
charge
not
framed.
happy. You are not happy with the way the charges are framed.
charge that charge that ought to have been framed. Milords,
You
is not.
should challenge that and not 173(8) application.
Yes.
If you are really aggrieved the way it is, that is permissible. And
Reserving that liberty, Milords.
I don't reserve liberty. It's up to you.
Milords, I'll do that, Milords. Then.
ನಿಮ್ಗೆ ಅಡ್ವೈಸ್ ಕೊಡೋದಲ್ಲ ಲಿಬರ್ಟಿ ಬೇರೆ ಕೊಡು.
No.
Yes, I gave that advice only because victim should not feel that victim has been rendered a short end of the stick.
Now, subsequently, Milords, if I were to file a petition, Milords, this pendency of this, Milords, I'll plead that, Milords.
No, you withdraw this and
challenge the charge sheet. 363 ಗೆ ಹಾಕಿದ್ದಾರೆ ನಂಬರ್. 363 ಗೆ.
ಮಿಸ್ಸಿಂಗ್
ಅಲ್ಲ,
Child.
ಅಡಲ್ಟ್ ಕಿಡ್ನಾಪ್.
ಅದನ್ನ ಮಾಡೋದ್ ಬಿಟ್ಟು 173(8) ಮಾಡ್ಕೊಂಡು ಕೂತ್ಕೊಂಡು what is all this? You should know what to do.
Yes.
After arguing the matter at length, the learned counsel of the petition seeks leave of this court to withdraw the petition and reserve liberty to approach this court in the event of need, reserving such liberty, the petition stands disposed.
Deeply.
ಅದನ್ನ ಮಾಡಿ.
Yes, yes.
363 ಮಿಸ್ಸಿಂಗ್ ಅಡಲ್ಟ್ ಬರುತ್ತೆ ಅದು. ಮತ್ತೆ ಅದನ್ನ ಚಾರ್ಜ್ ಮಾಡಿದ್ರೆ ಅದನ್ನ ಮಾಡ್ಬೇಕು. ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರು.
Stolen witness.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರು.
Yes, sir.
Yes. Disposed.
5 charge was framed on 18/7/2025.
Already ಬರ್ದಿದ್ದೇನೆ.
ಹೌದು, ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿರಲಿಲ್ಲ.
There is no representation ನಿಮ್ದ.
No.
ನಿಮ್ದಲ್ಲ ಸರ್. All cases are yours?
No.
Yes.
Last time my colleague was here, I was not here.
That's all. Don't worry. Yes. This court on 4/3/2026 had passed the following order. The learned additionalist, there is no representation. There was no representation on the said date. There is no representation today. In that light, on the learned additionalist PP submits charges have been framed long before the filing of the present petition. In the light of the judgment of the apex court in the case of Meenakshi Bala, there will be no warrant to interfere at this stage of the proceeding. Petition stands rejected, reserving liberty to the petitioner to urge all the contentions before the concerned court at the appropriate time. Next.
For the petitioner, my lords. Petitioner is the assistant jailer, my lords.
Assistant director?
Assistant jailer.
Jailer,
my lords.
ಏನ್ ಬಂದಿದೆ ಒಳಗೆ?
No, my lords, yeah. He was on the training, my lords, when the FIR was lodged. The FIR against 2 persons who came to the court, my lords, and while escorting.
Now, is the allegation that the drugs have come into the prison?
Yes, my lord.
When you were on duty, yeah?
Yes, I was on duty for 3 months in Vellore, my lords, not here.
ಅವಾಗ ಗಾಂಜಾ ಬರ್ಲಿಲ್ವಾ?
No, my lords, I am not aware at that time. And allegation is that I have received 5,000 rupees cash from the accused and from.
For what? To transport materials into the prison?
Not transport, my lord. My
Or
allegation.
to facilitate?
No, my allegation against me is that I have facilitated 5,000 rupees to the accused in the prison, not this accused, for other accused persons. That too prior to my, I was in duty, my lords. For 3 months, I was deputed in the duty for training in Vellore, my lords. The FIR is registered against the accused and the other persons, my lords, in the month of June, my lords. I was in the month of May, from May to August, I was in the duty, my lords. And also, my lords, there is no sanction order against me to prosecute, my lords. Under
Sanction for what? Accepting bribe?
197.
Accepting bribe?
No.
Accepting bribe?
Prosecute me.
ಅಲ್ಲ, ಯಾವುದಕ್ಕೆ sanction?
My lords, to register an FIR, my lords. I am a government servant.
Register sanction ಬೇಕಾಗಿಲ್ಲ. Cognizance ತಗೋಬೇಕಾದ್ರೆ sanction. Cognizance ತಗೊಂಡಿದ್ದಾರಾ?
No, in this case, my lord, he is accused number 18. Initially, he filed a writ petition 2710/23. He got a stay in that matter. Investigation was not done with respect to him. Charge sheet was filed keeping investigation pending against him. Now, on 9/3/2026, that writ petition came to be withdrawn.
Oh, correct.
So, investigation has not been completed against him.
Investigation ಮುಗಿಸ್ಬಿಡಿ.
ಹಾಕಿದ್ದಾರೆ ನನ್ನ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿಲ್ಲ.
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇದೆ. writ petition ಮುಗಿದ
ಅಲ್ಲ, ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿಲ್ಲ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕೋಆಪರೇಟ್ ಮಾಡಿ. I will.
He cooperated investigation, my lord. My lords.
Already cooperated. You have cooperated with the criminals.
No, my lords.
Cooperate with the investigating agency.
My lords, real culprits are not been caught hold, my lords.
Real culprits.
Yes.
ಯಾರು?
So many accused are there, my lords, was facilitating the prohibited items to be entered into the prison. When I was not in the duty, I have submitted the record shows, my lords. Kindly come to page number 117, my lords. I was not here in the duty, and the prison department itself.
Sirajuddin, that's a matter of investigation.
Yes.
Let them investigate. Investigation ಮಾಡಬೇಡಿ ಅಂದ್ರೆ ಹೆಂಗೆ?
Another co-accused, similar jailer has been quashed, my lord.
Similar jailer.
Similar
jailer, similar allegation.
Similar allegation, my lord.
ಅಲ್ಲ, ಅವ್ರ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು, ಸ್ಯಾಂಕ್ಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ಲಿಬರ್ಟಿ ವಾಸ್ ಗ್ರಾಂಟೆಡ್.
Cognizance ಬಂದಾಗ all right. If there is no cognizance, while taking cognizance there is no sanction, we will quash it.
Yes, my lord. That is.
ಅದು ಎಲ್ಲಿ ಬಟ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿಲ್ವಲ್ಲ ನಿಮ್ಮಲ್ಲಿ? ಬಟ್ ಯಾರಿಗೂ ಅವ್ರಿಗೂ
Page
ಕೊಟ್ಟಿಲ್ಲ.
76, your lordship, page 76.
Cognizance ಇಲ್ಲ.
ಅಲ್ಲ, page 76 ಅಲ್ಲಿ there is an endorsement.
ನಿವೇದನೆ ಇದೆ, ಗೊತ್ತಾಯ್ತು. Yes.
We are not investigate against him.
No, but others ಗೆ cognizance ಇಲ್ಲ ಅಂತ.
Sanction ಇಲ್ಲ ಅಂತ ಹೇಳಿ.
Sorry, sanction ಇಲ್ಲ ಅಂತ.
We will take sanction.
But it is rejected already.
Not rejected. Sanction was not there. This court has given liberty for us to obtain a sanction.
Same thing, same order will pass.
Yes,
for against him, we
But
are not
investigation ಆಗ್ಬೇಕು, cognizance of sanction.
My lord, this is abuse, my lord. Abuse. in
Abuse
process of-
ಯಾಕೆ sir?
ಯಾಕಂದ್ರೆ, my lord, I was not there. I produced the document, my
I'll
lord.
produce it before the
I have
investigating
produced, my
officer.
lords. I have produced, my
Now
lords.
there is no investigation conducted in your case. You produce everything before the
I was
investigating officer.
marking, because I was granted bail, my lords, I was marking my attendance within 50. every
Marking
15
your
days.
attendance is not cooperating with the investigation.
I have submitted all the documents. my
No
lords.
problem. I will give them 15 days time. They will investigate you. ಇದ್ರಲ್ಲಿ ಕಾಗ್ನಿಸೆನ್ಸ್ ಇಲ್ಲದೆ ಇರತ್ತಾರ ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ಬಿಟ್ಟು ಮುಗಿಸೋಣ ಅಷ್ಟೇ. ಕೋಪರೇಟ್ ಮಾಡಿ.
15 days.
This has to be because successive, it becomes a
ಮಾಡಿ.
successive.
Yes.
This one, he has to file fresh petition after filing charge sheet. Otherwise it becomes.
I have filed fresh petition after filing charge sheet.
ಚಾರ್ಜ್ ಶೀಟ್ ಬೇರೆಯವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ, ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿಲ್ಲ.
ನಮ್ಮ
Will
ಹೆಸರು
permit,
ಹಾಕಿದ್ದಾರೆ. Accused
will
number
pass
8.
this order. The learned counsel appearing for the petitioner submits that submits plethora of factors which would touch upon the merit of the matter. Investigation against the petitioner is not done in the light of the fact that a writ petition calling in question the crime was pending adjudication before this court in which an interim order of stay was operating. Therefore, against other accused, the charge sheet is filed and against one of the accused on the score that there was no sanction to prosecute, the proceedings are also quashed. In that light, to resolve the quagmire, I deem it appropriate to direct the petitioner to participate in the investigation and direct the respondents prior to filing of the charge sheet, place the investigation material before this court. List the matter on 18th April in fresh matters list. ಅಷ್ಟೇ. ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿ.
ಮಾಡಿದೀನಿ.
ಮಾಡಿ.
From the first date.
ಅದು ಯಾರ್ಯಾರ್ದು ಏನೇನು ಹೇಳ್ಬೇಕೆಲ್ಲ ಹೇಳಿ.
Duty, I am also not going to duty also, my lords. I have been transferred ಇಲ್ಲಿಂದ ಗುಲ್ಬರ್ಗ ಅಂತ I am not going.
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೋಸ್ಕರ ಬರ್ತಾರೆ ಬನ್ನಿ.
No, my lord, ನಾನು ಇಲ್ಲೇ ಇದ್ದೀನಿ.
ಸರಿ.
Cooperate with the investigation.
ಕಂಪ್ಲೀಟ್ ಕೋಆಪರೇಟ್ ಮಾಡ್ಬಿಡಿ. ಆಮೇಲೆ ಅದನ್ನ ಫಾಲೋ ಮಾಡಿ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್.
Publish.
But we should get to the truth. What is happening in the jail?
Everybody knows.
ಈಗ ಫುಡ್ ಸಾಲ್ವ್ ಮಾಡಿದ್ನಾ?
ಆಯ್ತು, ಸಾಲ್ ಆಗಿಲ್ಲ.
ಹಂಗೆ.
ಸಾಲ್ ಆಗಿಲ್ಲ madam.
ಈ ಆಗುತ್ತೆ. I have given so many directions.
Only one page, my lords.
I have been told, my lord, that I met the IDG prisons. He says that the rice, though the amount is 95 rupees, rice is provided as Sona Masuri rice, not an ordinary rice.
ಹೌದಾ?
Yes.
Lord, my best suggestion to the prison authorities, Indira canteen install ಮಾಡಿದ್ದಾರೆ. ಅದನ್ನ ಅಲ್ಲಿ ಇದು ಕೊಟ್ಬಿಟ್ರೆ, ಕಾಂಟ್ರಾಕ್ಟ್ ಕೊಟ್ಬಿಟ್ರೆ it will be best. ಅವ್ರದ್ದು ಏನು ಪ್ರಾಬ್ಲಮ್ ಇರಲ್ಲ. 45 rupeesಗೆ 15 rupees per day one meal ಕೊಡ್ತಾರೆ ಇಲ್ಲಿ ಇಂದಿರಾ ಕ್ಯಾಂಟೀನ್. 45 rupees the governmentಗೂ ದುಡ್ಡು ಉಳಿಯುತ್ತೆ, prisoners ಗೂ ಒಳ್ಳೆ ಊಟ ಸಿಗುತ್ತೆ.
ನೋಡೋಣ.
My lords, in page number 117, my lords, already the prison department has issued notice that I have been on deputed and I was in the duty, my lords.
ಅಲ್ಲ ಅದೆಲ್ಲ ಕೊಡಿ ಅಲ್ಲಿ. ಪೆಟಿಷನ್ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಲ್ಲ ನಾನು. ಎವ್ರಿಥಿಂಗ್ ವಿಲ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮೆಟೀರಿಯಲ್ ಬರಲಿ, ಬಂದ್ಮೇಲೆ ಮಾಡುವ.
Lordship said that quashed ಅಂತ ಹೇಳಿದಿರಿ. Quashed with liberty, my lord.
ಅಲ್ಲಿ ಕ್ವಾಸ್ಟ್ ಅಂತ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚಸ್ ಕ್ವಾಸ್ಟ್ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ. ಕ್ವಾಸ್ಟ್ ರಿಸರ್ವಿಂಗ್ ಲಿಬರ್ಟಿ ಟು ದಿ ಸ್ಟೇಟ್ ಟು ಕಂಟಿನ್ಯೂ ದಿ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆನ್ obtaining sanction. ಅಷ್ಟು ಆ ಸೆಂಟೆನ್ಸ್ ಹಾಕಿರಿ. ಎಸ್. ನೆಕ್ಸ್ಟ್.
Second FIR.
ಏನಿದು 3?
This is been accused persons.
Official Officer Cooperative Society, Karnataka, my lord. Where one of the site which is.
ಇದು ಸಂಪತ್ ಅಪಿಯರ್ ಆಗಿದ್ರಲ್ಲ?
ಇವರು ಇದ್ದಾರೆ. Not just I have two submissions. One is not in page 19, not in my petition 1208. What is the first FIR? Not registered. Not by the society.
Same complainant,
Different complainant. Different complainant. Then, my lord, the allegations is, my lord, that under a MOU, sites, my lord, are transferred in name. I am the beneficiary. My lord, I have paid 2.5 crores for this site. In the proceedings, my lord, before the authorities, not in writing, my lord, we have given that we are ready to not give back the reconvey, my lord, the entire property.
Reconvey the entire property.
In writing, my lord, it appears, yes.
ಆಮೇಲೆ ಇವ್ರದ್ದು
now that my lord, since they may have to, my lord, return my money.
We'll see. We'll answer that. 7 ಅಲ್ಲಿ ಯಾರು ರೆಸ್ಪಾಂಡೆಂಟ್ಗೆ? 7 ಅಲ್ಲಿ ನೀವು ರೆಸ್ಪಾಂಡ್ ಆಗಿದ್ದೀರಾ?
7.2, madam.
Who is the complainant there? Some Gangadhara. Hey, that's ARCS.
I'll take notice.
You
sir.
take
I'll
notice.
take notice.
The learned additional SPP accepts notice for the second respondent as well. The learned counsel for the petitioner, P. Prasanna Kumar, submits that in writing before the ARCS, the petitioners had indicated that they would reconvey the site back to from where it came,
Please.
which and the consideration of 2.5 crores that passed should be returned to them on that. Notwithstanding the same, the crime is registered as a submission. The learned additional SPP to secure instructions on that and make submissions.
There's one issue, site. When they said site, I also thought it's a site. Site, the dimension is 22,000 square feet.
Iವ್ರದಾ?
21,000.
ಇಲ್ಲ ನಮ್ದೆಲ್ಲ ನಮ್ 9,000.
So they say it because of
So far
odd
as I am
site.
concerned, it is one. No, I think everybody will reconvey. It is not that it is being done.
They said it's a hard site and nobody was willing to purchase. Therefore, it is sold. When I looked into the dimension, it is 21,000 square feet, half acre.
ಅಲ್ಲ ಅರ್ಧ ಎಕರೆ ನಾನು ಸೈಟ್ ಅಂತ ಬರ್ದ್ನಲ್ಲ ಮತ್ತೆ.
20,000.
Is categorized not as site by the site number. That undertaking is already given.
ಅದೇ ಸೈಟ್ ಇಸ್ ಔಟ್ ಆಫ್ ಸೈಟ್. ಎಸ್ ಆಯ್ತು ಮಿಕ್ಕಿದ್ದು. ಸೊ ವಾಟ್? ಎಸ್ ಜಗದೀಶ್ ಆಗಿಲ್ವಾ ಅದು? ಯು ಆರ್ ದೇರ್?
7.2 for the impleading.
7.1. 2.1 ಅಲ್ಲೂ ಕೃಷ್ಣ ಕುಮಾರ್. Yes, then it has to go back if procedure is not followed under 175(3).
Your Lordship can remand it back.
That's the only option.
From the stage where it was referred to.
From the stage allene.
Yes.
From that stage only it has to go back, no choice.
Yes.
ಈಗ next 7.2. That's same FIR.
Same crime. 7 and 7.2 are
ಅದು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್.
One issue, not 3 cases.
ಅದು ಆಲ್ ರೈಟ್, ಅದು ಪ್ರೈವೇಟ್. ಇದ್ರಲ್ಲಿ ಆಗಿರೋ ಫ್ರಾಡ್ ಗೊತ್ತು ಅದಕ್ಕೆ.
ಅಲ್ಲ 7.2 is same crime number.
ಅಲ್ಲ is it this also a private complaint?
No. Crime number.
7 and 7.2. It's not a private complaint.
Correct.
Why should that go?
No.
Yes.
Only 7.1 has to go.
7.1 will send it back from the stage of 175(3). Yes, sir. ನೀವು ವಾಪಸ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ನಿಮ್ದು ಎಷ್ಟು? ಅರ್ಧ ಎಕರೆ, 1 ಎಕರೆ?
Oh, but you will have to give my money back.
ಮೇಡಮ್ ಆ ಪೆಟಿಷನ್ ಕೊಡಿ. ಇವ್ರದ್ದು 7.2.
Here the police.
Oh, that's all right. That's a matter of investigation ಆಗ್ಲಿ ಬಿಡಿ ಇದರಲ್ಲಿ. 7.2 ಅಲ್ಲಿ investigation ಆಗ್ಲಿ. Why shy for investigation? Yes. Let investigation go on in 7.2. All that before the investigating officer you tell. Let the investigation go on. Idan matra vapas because the courts in settle ಮಾಡ್ತೀರಾ?
Not in 7.2, my lord. The allegation here is of forgery. Stamp paper was
Forgery
forged.
stamp paper.
And the site was never theirs, first of all, to return it back. They're coming forward.
That's
to
the
do
issue.
that. Yes.
They are going to give back the site. I am the developer. I will convey it back to the society.
Stamp paper was
Stamp
purchased.
On my request
2
is.
years later.
And the certificate was backdated.
ನಿಮ್ದು will see. Our instruction ತಗೊಂಡ್ ಬರ್ಲಿ.
Please.
7.2 investigation will go on. No. 7.2 investigation should go on.
Same FIR.
So what?
Both are reading same.
Let
same
that investigation
Yes,
go
ma'am.
on.
Yes, ma'am.
This is a complaint
Correct.
to the jurisdictional police.
Yes.
ಅಲ್ಲಿ ಕೋರ್ಟ್ ತಪ್ಪು ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಇವ್ರಿಗೆ ಯಾಕೆ ತೊಂದರೆ ಆಗ್ಬೇಕು? That's a court's mistake, sir. We have been repeatedly telling courts are even creating litigation for the accused, leaning towards the accused and passing orders. ಏನ್ ಒಂದ್ ರೀಸನ್ ಒಂದ್ ಲೈನ್ ಬರೆಯೋದು ಅಲ್ಲ ಅದು ಗೊತ್ತಿಲ್ಲ ದಟ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ವಿಲ್ ಕಮ್ ವಿಲ್ 7 point whole hog I will permit investigation in all the things if this is the thing only instructions in Prasanna Kumar's case and in these 7.1 will go back to that stage and 7.2 will be rejected for investigation. Let the investigation go on. That's all right, sir. That's the matter to be investigated. It's a forged document. That is the allegation, sir. It's a document of forgery is the allegation. That investigation will go on. Yes. ಒಂದೊಂದಾಗಿ ಕೊಡಿ ಒಂದಾಯ್ತಲ್ಲ 7.1 ಕೊಡಿ. The petitioner is before this court calling in question registration of a crime in crime number 83 of 2025 registered for offences punishable under section 420 read with 34 of the IPC. The heard so and so. Facts enumerated are as follows. The second respondent is the complainant alleges that the petitioner, the first petitioner developer developing lands and farming sites allotted the sites in favor of the society, the second respondent, society to which the second respondent is a member. The allegation further allegation is that the first petitioner through his son, petition number 2, sold the site number 120 which belongs to the society allotted in favor of the private complaint, allotted in favor of the complainant to a third party. On this score, the learned magistrate took cognizance of the offence and referred the matter for investigation under 175(3) of the BNSS to the jurisdictional police to conduct investigation and submit a report. The order of the learned magistrate reads as follows, page 15 and 16. The order nowhere indicates that the rigor of 173(2) is followed, which should mandate that the jurisdictional police should be heard before referring the matter for investigation. In the light of the said procedural aberration, the inevitable conclusion will be obliteration of the order, obliteration of the crime that is registered pursuant to the order of reference and remitting the matter back to the hands of the concerned court to pass necessary orders after following the procedure as obtaining under 175(2) of the BNSS and take and regulate its procedure thereafter. Is ordered according. Other close back to that stage. Now, E case 7.3. 7.2, sorry. 7.2 come after investigation, or else I'll render all my finding. Yes, the petitioner, after arguing the matter at length, seeks leave of this court to approach this court in the event a final report is filed against him, which would go against him, reserving such liberty. The we're closing it.
Even serial number 7 is also arising out of crime number
7
1.
and 7.2 same, is it?
Same. They can come back
ಯಾವತ್ತು
after.
ಹಾಕಿದ್ದೀನಿ
18th month.
18th ತಗೊಳ್ಳೋಣ ಇದನ್ನ ಅದನ್ನ ಹೇಳಿದ್ರೆ ಸಂಪತ್ ಅವಾಗ. Yes, 18th.
Can I request on 17th?
17th, fine. 17th fresh matters. Yes. Yes. ಹರಡು ಎಲ್ಲಾರ್ದು ಹಾಕ್ಬಿಟ್ಟ. Impleading ಯಾವುದು?
My friend has not.
We'll permit impleading. For the reasons indicated in the affidavit accompanying the application, a impleading application stands allowed. The who is the impleading applicant? Respondent number?
Number 3.
The impleading applicant shall be impleaded as respondent number 3 to the proceedings. As the impleading applicant is the informant before the Assistant Registrar of Cooperative Societies. Yes, next. Our early avat close ಮಾಡೋಣ. ಸಂಪತ್ our early close ಮಾಡೋಣ. Yes. Next.
8.
It's a consensual rape.
Promise to marry.
Yes, ma'am.
2 weeks.
ಎಷ್ಟು ವರ್ಷ? ಇದ್ರಲ್ಲಿ ಏನಿಲ್ಲ, ಬರೀ 2 or 3 episodes.
From 2023, Your Honor.
ಏನಿಲ್ಲ 24.
23, Your Honor. Kindly it may please to see the 164 statement in page number 31, ma'am.
ಜೊತೆಯಲ್ಲಿ ಬರುವಂತೆ ಕರೆದಾಗ ಬರಬೇಕು. ಏನಿದೆ?
In page number 31 of the 164 statement.
ಒನ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿದೆ?
In page number 31, ma'am.
ಮನೆಗ್ ಬಂದ್ರೆ ಮಾತ್ರ ಮದುವೆ ಆಗೋದು ಅಂತ ಹೇಳಿದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಅಲ್ಲ ಹೇಳಿರೋದು ಅದೇನೆ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
1.5 ವರ್ಷ ಮನೆಗ್ ಬಂದ್ರೆ ಮಾತ್ರ ಮದುವೆ ಆಗೋದು ಅಂತ ಹೇಳಿ ಕರ್ಸ್ಕೊಂಡಿದ್ದೀರಾ.
ಮನೆ ಕರ್ಕೊಂಡೋಗಿ ಮಾಡಿದ್ದು ಅಂತ ಇರೋದು.
Let the complaint come. Let the complaint, because it is not a straight case of a promise to marry.
ಇದು ಡಿಸೆಪ್ಷನ್ ಫ್ರಮ್ ದಿ ಇನ್ಸೆಪ್ಷನ್.
So consensually or
ಕಾನ್ಸೆನ್ಷುಯಲ್ ಅಲ್ಲ ಸರ್ ಇದು.
the last line, Your Honor.
ಪ್ರಾಬ್ಲಮ್ ಇಸ್ ಪರಸ್ಪರ ಪ್ರೀತಿ ಮಾಡ್ತಾ ಇದೀವಿ.
That's the thing.
ಎನಿವೆ ಬರ್ಲಿ ಕಂಪ್ಲೇಂಟ್. ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ತಗೊಂಡ್ಬಿಡಿ ಸರ್, ಬೇಲ್ ತಗೊಂಡ್ಬಿಡಿ. ಇದು ನೆನ್ನೆ ಬಂದಿತ್ತಾ?
Yes, my lord.
ಹಾ, ಅದಕ್ಕೆ ನೆನ್ನೆನೆ ಕೊಡ್ಲಿಲ್ಲ. ಎಲ್ಲ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಕಾಶಿ ವಿಶ್ವನಾಥ ದೇವಾಲಯದಲ್ಲಿ ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ? ಮತ್ತೆ
ಅಲ್ಲ, ಕಾಶಿ ವಿಶ್ವನಾಥ ದೇವ ಜಾತ್ರೆಯಲ್ಲಿ
ಮದುವೆ ಆಗ್ತೀನಿ ಅಂತ?
ಅಲ್ಲಲ್ಲ, ಮತ್ತೊಬ್ಬ ಹುಡುಗಿ ಜೊತೆ ಇದ್ದಿದ್ದು ಅಂತ.
ಇಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ.
ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆ.
ಥ್ಯಾಂಕ್ ಯು. ಎಸ್, ನಾಟ್ ಎ ಕೇಸ್ ಫಾರ್ ಇಂಟರ್ಫಿರೆನ್ಸ್ ಆಲ್ಸೋ. ಯಾವುದೋ ಒಂದು ಕರೆಕ್ಟ್ ಆಗಿರೋ 69 ಕೇಸ್ ಸಿಕ್ತು ಅಂತ ನೋಡ್ತಾ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅಷ್ಟೇ. ಜಲ್ದಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಿದ್ದಾರೆ.
Charge was framed on 25/2/2020.
25 to
26.
Sorry, before that only charge was framed. Last year only.
25 ಅಲ್ಲೇ ಆಗಿದೆ. In the light of the learned additional SPP submits that the charges have already been framed and the matter is at the stage of evidence before the concerned court. The learned counsel for the petitioner projects that these are consensual acts and trial must not be permitted to be continued in the light of plethora of judgments rendered by the apex court. A perusal at the 164 statement would ಬರಿಬೇಕಾದಲ್ಲ? ಬೇಡ. So in the light of the charges being framed, it is for the petitioner to urge all the contention, produce all the material before the concerned court at the appropriate time. It is needless to observe that the concerned court will answer all those documents or submissions as the case would be, as and when the order would be passed.
Please.
The aforesaid observation, petition stands disposed. Next.
Appearing for the petitioner, my lord, some inconvenience today, my lord. Any
Some?
inconvenience today, my lord, for senior, my lord.
ಯಾರು ನಿಮ್ senior?
Appearing for Devraj, my lord. Senior was engaged in this matter, my lord. Not able to.
ಅಲ್ಲ, ಇವತ್ತೇನ್ ಡ್ಯಾಮೇಜ್ ಮಾಡಂಗಿಲ್ಲ.
Doctor.
Dog.
Complaint after 6 years, my lord. 6 years, my lord.
Piles doctor.
Saying some due to the treatment is facing some difficulty, my lord.
ಓಕೆ, ಇದು ಸರ್ಟಿಫಿಕೇಟ್ ಕೇಳಿದೆ ನಿಮಗೆ ನಾನು.
Tomorrow itself, my lord. Sir will appear, my lord.
Fistula?
ಹೌದು.
Oh. Why fistula doctors have no certificate at all?
No, they have.
ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂದ್ರೆ ಫಿಸ್ಟುಲಾ ವೈದ್ಯಕೀಯರ ಸಂಘ ಅಂತಿದೆ, ಅದರ ಪ್ರೆಸಿಡೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ತಾ ಇದ್ದಾರೆ. ಯಾವತ್ತು ಬೇಕು ಸರ್?
Tomorrow itself.
ಟುಮಾರೋ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆಯಾ?
Been procured, my lord. Senior will.
Friday.
List on Friday. Fresh matters.
Serial number 10 and 10.1, my lord. The same one incident, 3 FIR was registered, 3 different police stations, 3 different persons filed by the complaint. First one registered high-ground PS.
ಒಂದರಲ್ಲಾರು ನಡಿಲೇಬೇಕು.
My lord, first one submission. First high-ground PS was registered in.
ಯಾವ್ದು ಬೇಕು ನಿಮಗೆ?
First one is already filed B report First,
He transferred it to, because they've registered there. So we have filed a B report saying that the investigation will be conducted by the.
ಅದೇ
other
ಕ್ವಿ
police
ರಿಪೋರ್ಟ್ ಅದೇನ್ ನಿಮ್ಗೆ
But,
ಇನ್ನೋಸೆನ್ಸ್ ರಿಪೋರ್ಟ್ ಅಲ್ಲ.
second one Virajpeta police.
ಆಗ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
Third one Madkeri police station.
Let investigation go on. Produce the investigation papers. The investigation paper. The accused number 1 and 2.
Accused number 1 and 2 is the aunt and uncle
Family
of
members
deceased
of the
man.
wife.
Three investigation material kodi.
And accused number
Charge sheet, entire charge sheet, let them withdraw the file.
Charge sheet for challenge ಮಾಡಿದ್ರೆ ಮಾಡಿ.
Please, madam, we permitted to
Do that.
challenge the charge sheet.
Charge sheet ready ಇದೆ.
Please.
File
Answer
CC
is
number
answer, not a problem.
CC 16521 of 26.
Number ಇದೆ.
I permitted to withdraw.
11 CC so and so ಬರ್ಕೊಂಡ್ರ ಅದು ಬರ್ಕೊಡ್ತಾರೆ. Liberty reserved to challenge the charge sheet. Do it immediately.
In 11.1.
11.1 ಹೋಗುತ್ತೆ ಹಂಗಾರೆ.
That investigation can complete.
ಕಂಪ್ಲೀಟ್ ಆಗಿದೆಯಾ?
We'll complete the investigation. We're not completed. Lordship allow us to complete, we'll complete the investigation. Let them come back after.
Argue on merits, my lord, is my lord.
Argue on merits, sir.
That's the petitioners are, my lord, the brother-in-law and mother-in-law of the deceased, my lord. Even in the complaint, my lord, there are absolutely
Same
no
petitioners, huh?
They are the complainant there.
These petitioners in accused number 11, my lord, are the parents.
Still new complainant,
ಅದಲ್ಲ, ನಾನು petitioner accused at CR number 11.1.
ಅಲ್ಲ, who are the petitioners in 11.1?
11.1, my learned friend is a complainant.
No, sir, 11.1, he is the complainant.
So you are the complainant?
No, my lord, 11.1, he is a complainant. I am for the accused, my lord. The accused are the mother-in-law and brother-in-law of, my lord, the deceased lady.
And the husband, wherein husband committed suicide.
Husband committed suicide, it's all right.
Let the investigation happen, my lord.
Yeah, let this maze get,
Petitions, my lord, in the complaint, my lord.
investigation cooperate ಮಾಡಿ. I will direct not to take precipitative action.
Agbo.
Very well, my lord.
The, will not dispose this, but permit you to participate in the investigation.
Please, my lord.
11.1, the matter on a cursory perusal at the original records placed before the court. The court is of the opinion that investigation is necessary to be permitted to be continued. Therefore, the investigation shall continue. The petitioners shall cooperate with the investigation, and in the garb of investigation, no coercive action shall be taken against these petitioners. Records of investigation be placed before this court. List the matter on 17th April. ಅಷ್ಟಲ್ಲಾಗತ್ತೆ. ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಷ್ಟೇ. Yes.
12.
Petition 351
in the meantime.
164 statement ಇದೆ.
Page 36 ನೋಡಿ, ಏನು ಇಲ್ಲ ಅಲ್ಲಿ.
164 statement.
ಯಾರ್ದು?
The complainant.
ಕೊಡಿ ನೋಡಿ.
ವೈಫ್ ಇದೆ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಮನೆ ಹತ್ರ ಆಗಿರೋದು ಅಷ್ಟೇ, ಯಾರು ಇಲ್ಲ ವಿಟ್ನೆಸಸ್. ಅದರಲ್ಲೂ ಸೇಮ್ ಅದನ್ನೇ ಕಾಪಿ ಮಾಡಿರ್ತಾರೋ ಇದೆ ಕಂಪ್ಲೇಂಟ್.
Atrocities Act.
164 on statement.
23 ಪೇಜ್ ನಂಬರ್
161 ಸ್ಟೇಟ್ಮೆಂಟ್ ಅದೇನೆ.
ಪೇಜ್ ನಂಬರ್ 43 ನಲ್ಲಿ ಇದೆ ಸುಮ್ಮನೆ 183.
Atrocities Act.
ಹೌದು, ಮನೆ ಹತ್ರ ಆಗಿರೋದು ಸುಮ್ಮನೆ, ಪಬ್ಲಿಕ್ ಪ್ಲೇಸ್ ಇಲ್ಲ. petitioner is the FDA. my lord.
ಆಗ ನಾನು ಮನೆಯಿಂದ ಆಚೆ ಹೋಗಿ ಯಾಕೆ ನೀವೆಲ್ಲ ಮಾಡ್ತೀರ ಬಂದಾಗೆ ಬೈದರು. ನಾನು 30 ವರ್ಷದಿಂದ ಇಲ್ಲಿ ಇದ್ದೇನೆ, ನೀವು ನನ್ನನ್ನು ಎಸ್ ಮನೆ ಒಳಗೆ in the Atrocities Act ಬೇರೆ ಏನಾದ್ರು ಇದ್ದಿದ್ರೆ ಬೇರೆ ಇಲ್ಲ 504 506 ಇರೋದು ಬೇರೆ. In the meantime, sorry, the petitioner is before the court calling in question the proceedings in so and so. A perusal at the complaint or this statement rendered under 164 of the CRPC, the complaint, the alleged hurling of abuses has not taken place either in a public place or a place of public view for it to become the ingredients of section 31R and S of the Atrocities Act. The issue stands answered by the judgment of the Apex Court in the case of Hitesh Verma versus so and so, 2010 9 SCC 710. In that light, there shall be an interim order of stay of further proceedings with the petitioner till the next date of hearing. Yes.
13.
So the petition, my lords.
2010 ಅಲ್ಲ. Hitesh Verma.
Lords, the
Serial number?
petitioner is accused, my lord.
Yes, sir.
The alleged offences are 504, 34 of IPC, my lords.
Covered ಅಂತ.
Notice of the complainant. Complainant ಗೆ notice of it is covered. Says only permitted.
ಕಂಪ್ಲೇಂಟ್ ನೋಟಿಸ್ ಆಗ್ಬೇಕಾ?
ಹೌದು.
ಕಂಪ್ಲೇಂಟ್ ಇದಾರ?
ಹೌದು ಸರ್.
ಇಲ್ಲ ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಬೇರೆ? One additional SPP, 2 emergent notice. There shall be an interim order of stay of further proceedings with the petitioner till the next date of hearing. Emergent notice returnable by 17th April.
Please, my lord.
114.
Not wife would initially file MC, my lord.
Yeah, wives always file initially.
Not, it was referred to, my lord, mediation.
ಆಮೇಲೆ
She would demand 1.5 crores, my lord, maintenance to settle the issue. Not petitioner is a wing commander, not serving in Indian Air.
The wings are cut now.
Not repay. Not, she would file complaint as against, not my father, mother and myself.
Now the husband is before the
Husband, my father and mother, not police would file B report saying that all the allegations are false because they will not continue to reside not elsewhere.
all the allegations are against the husband ಅಂತ we report ಹಾಕಿದ್ರೆ false ಅಲ್ಲ.
Not the allegations, not of course. Not in the.
See page 21.
Please, not I have seen it. Not I have seen
ಮತ್ತೆ?
it. Not because I am also participating in the MC proceedings. Not she would give an address, not just one submission. In the MC, not that she files. Even in the complaint, not that she has not said. She continues to reside not in the quarters allotted to me, not by the Air Force. Her allegation is on a particular day I assaulted.
No, there is no question of stay. One additional SPP, 2 emergent notice. ಬರ್ಲಿ.
Please.
ಬಂದ್ಮೇಲೆ ಸೆಟಲ್ ಮಾಡ್ಸೋಣ.
Allegation is only oral abuse.
353. The petitioner is before the court calling in question a registration of a crime in crime number 1 of 2026 for offense punishable under section 132 of the BNS, which is 353 of the earlier regime, the IPC. A perusal at the complaint would indicate hurling of abuses, orally hurling of abuses. There is no, the ingredients of section 351, which for it to become an offense under section 353 of the IPC, is ostensibly absent in the case at hand. In that light, there shall be an interim order of stay of all investigation qua the petitioner until the next date of hearing. Is the DP Act ಹೆಂಗ್ ಬರುತ್ತೆ? Are you married?
So I am claiming that I am married. I have a seat.
You are claiming you are married.
Yes, we married the second respondent. And
You married the second respondent.
Please. And I have the photographs for the everything.
ಸರಿ ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಈಗ 74 79 ಎಲ್ಲ ಆಗಿದೆ.
ಆಗಿದೆ. The magistrate note, she did not inform even the police. Allegation that I had trespassed into her quarters. And
Magistrate's quarters.
How? No. She is the second respondent. She is magistrate. I'll place the records, not And
It's deceived her.
ಇದೆ ನೆನ್ನೆ ಮೂವ್ ಮಾಡಿದ್ದ.
the allegation that she has terminated the pregnancy also, not claiming that he is the husband and taken maternity leave even.
ಮದುವೆ ಎಲ್ಲಾದ್ರಿ?
Place.
ಅಲ್ಲ, ಅದು only
ಅರೇಂಜ್ಮೆಂಟ್, ನಾಟ್ ಅರೇಂಜ್ಡ್ ಮ್ಯಾರೇಜ್.
But I'll pass.
ಮೈಸೂರು ಹೋಟ್ಲಲ್ಲಿ ರಿಂಗ್ ನ ಎಕ್ಸ್ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
I'll
ಕೊಡಿ,
pass.
ಒಂದ್ ನಿಮಿಷ.
And admit.
Where is the certificate of marriage?
Hospital records, not all the
Hospital register ಆದ್ರೆ.
termination of pregnancy also she given her name as an husband, his name as an husband. First document.
And he projected himself as somebody. He projected himself as somebody else.
ಮದುವೆ ಆಗಿದ್ದಾರೆ?
ಅಲ್ಲ, that is what she says, my lord, that
medical records.
For the purpose of birthday celebration, she was invited to Mysore.
And she is judge.
Yes. And it was list, this matter is also coming to the very same court. Adhe court.
ಅದೇ ಕೋರ್ಟ್ ಮುಂದೆ
Adhe court is not adjacent next court. And in spite of the interim order, not so far as parents, the charge sheet was filed.
When was the interim order granted?
Interim order was granted on.
Number ಕೊಡಿ, ಆ petition number ಕೊಡಿ.
Criminal petition, Lord, 14345 or 2025.
Tag this petition along with criminal petition 14345 of 2025. List them both tomorrow in the fresh matters list. Friday in the fresh matters list.
And now, Lord, yesterday they moved a application for cancellation of bail.
It is made clear that if the prosecution takes any precipitative action, the bail of the petitioner, the matter would be viewed seriously. All influence ಮಾಡಿ ಮಾಡಿಸ್ತಾ ಇದ್ದಾರೆ bail cancellation.
ಅಲ್ಲ, that's anyway. I'll leave it, my lord. But the only issue that he is actually projected himself as somebody else.
Let's hear the matter. The bail cancellation ಯಾಕೆ? When I'm hearing the matter, ನಾಳೆ ಇವರು bail cancel ಮಾಡಿಸ್ಬಿಟ್ರೆ?
No, I'll inform.
Court will be ready to do that.
I'll inform.
Yes. Day after tomorrow, fresh matters list. ಇದು cover ಹಂಗೆ ಇಟ್ಟಿದ್ದೀನಿ.
Also appear for the petitioner, my lords. That's on the last occasion, my lord, your lordship had directed to secure investigation reports, my lords. That's based on voluntary statement
So
of accused
investigation
number.
is pending. Charge sheet has not been filed. Investigation is still pending. Crime is registered, my lord. Is on.
The contention is, it is only based upon the voluntary statement of other accused. He is drawn into the web of proceedings.
ಅಲ್ಲ,
ಅದ್ರ ಮೇಲೆ he wants to rest his case.
it is the FIR is registered on 12/2/2026.
Investigation ಮಾಡಿ.
Correct.
Investigation ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗೋದಲ್ಲ whether you have any corroborative evidence or not, or only the voluntary statements.
My lords, there are no corroborative evidence, my lords.
ಅದು who knows? Investigation ಮುಂಚೆನೆ how did you say?
Investigation,
How
there
can
is
you
no
say that?
corroborative evidence, my lords.
Sir, it's a case of NDPS.
Small quantity, my lords, 100 grams of ganja, hydro ganja, my lords. The allegation is that, my lords, that
The hydro ganja ಅಂದ್ರೆ ಏನು?
My lords, that the hybrid version of ganja, my lords.
What is hybrid version?
Hybrid, my lords, it is, my lords, I'm exactly not sure, my lords.
No problem. Off ಮಾಡಿ.
ಇಲ್ಲ, ಅದು ganja, my lords. It's ganja. My lords, the allegation is that, my lords, accused number 3 and 4, my lords, placed order to purchase 100 grams of hydro ganja from accused number 2, my lords.
Let the investigation papers come. I'll take it on bail ತಗೊಂಡಿಲ್ವಾ?
ಆಗಿದೆ.
ಸರಿ ಮತ್ತೆ. List the matter on 9th April. The investigation papers, the papers of investigation conducted against the petitioners even shall be placed before the court on the next date. Avattu place everything.
Fresh matter.
Corroboration in fresh matters, yes. Corroboration ಇಲ್ಲ ಅಂತಂದ್ರೆ we'll take it that it is on voluntary statement and close it.
Please.
Stay in ಬೇಡ, ಕ್ವಾಶನ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. Yes.
Application filed for recalling the PW 1 and 2. Application filed for recalling the PW 1 and 2, my lord. PW 1 is the victim, PW 2 is the mother.
Victim, I will not permit. ಎಷ್ಟನೇ ಸರ್ತಿ ಇದು?
First time.
Under 18. She's still under 18.
Victim, I will not permit at all.
It's the first time application.
Only the mother. ಒಂದ್ಸರಿ ಆಗಿದೆ ತಾನೆ?
ಒಂದ್ಸರಿ ಆಗಿದೆ.
the petitioner is before the court, calling in question an order of the concerned court which rejects the application of the petitioner filed under section 311 of the CRPC seeking recall of PW 1 and 2, the victim and the mother, for further cross-examination. Heard so and so. The petitioner gets embroiled in a crime for offences punishable, gets embroiled in a crime in crime number, another special case is there, gets embroiled in a crime for offences punishable under so and so. Paragraph 7 alide. The issue in the list is not with regard to the merit of the matter. A PW1, the victim and the mother were cross-examined at an earlier point in time. The petitioner then files an application under section 311 seeking recall of PW1 and 2, the victim and the mother, for further cross-examination through an application under section 311 of the CRPC. The said application comes to be rejected, therefore the petitioner is before the court. The accused is before the court. The learned additional SPP would submit that the victim who was once cross-examined is still under the age of 18, and therefore the further cross-examination of the victim should not be permitted. Insofar as the mother is concerned, the learned counsel would, learned additional SPP would leave the decision to the hands of the court. I have given my anxious consideration so and so. Section 33(5) of 33(5) of the POCSO Act reads as follows. Section 33(5) mandates that the victim should not be repeatedly called for cross-examination in a proceeding under POCSO. The only exception through the judicial interpretation made to this provision is that if the victim, when an application is filed under section 311, has crossed the age of 18 years, in a given case, a victim can be summoned for further cross-examination. In the case at hand, the victim is still under the age of 18. Therefore, there is no question of allowing the application insofar as the victim is concerned for further cross-examination. Insofar as the mother of the victim is concerned, the application, the purport of section 311 is towards the discovery of truth. If the elicitation of evidence from the hands of the PW2 could drive to the innocence of the accused, such application should be permitted. In that light, the application so filed by the petitioner is allowed in part. The victim shall not be permitted to be further cross-examined, while the mother, PW2, must be permitted to be further cross-examined. The application filed by the petitioner also is allowed in part. The concerned court shall regulate its procedure by fixing a date for such cross-examination of the mother, PW2, na?
Yes, ma'am.
Mother, PW2, and oversee that the permitting of the examination of PW2 would not become a ruse, RUSC, ruse to drag the proceedings. Ordered accordingly. Next.
19.
Going for the petitioner minutes. Now, this is a case wherein the police have subjected the petitioner without arresting her to a blood test. The NDPS raid.
This is the case. We have called the doctor from Devanelli. The accused was taken to custody, arrested. Warrant statement has been recorded. Notice was served under section 52. Thereafter, medical examination was done.
Amel murder.
Plus, only there's arrest torsake. There's not a single document.
We'll see.
Rounds of arrest has not been given. Arrest.
So they were released after because the consumption they were released. They were not taken to.
Section 51 clearly reads medical examination can be conducted only on a person who is arrested. It screams.
We'll answer this, Kudi. Yes.
In fact, notices were also served on them. After serving the notice, they were subjected to medical examination.
Body search during the raid, yes, my lords, they can. NDPS allows it. My lord, section 51, when a person is arrested on a charge, it says arrested. Without
NDPS. Which provision?
My lord, section 51 says procedure of
CRPC will apply.
CRPC. Now, my lord, CRPC, now in BNSS, my lord, 51 it comes, my lord. Examination of accused by medical practitioner, request of police officer.
Adal 51, na?
51 of BNS, my lords.
BNSS.
BNSS, apologies.
Ah.
My lords, the first line, when a person is arrested on a charge of committing an offense of such a nature and alleged to have been committed under such circumstances, that there are reasonable grounds of believing that an examination of his person will afford evidence as to the commission of an offense, it shall be lawful for a registered medical practitioner acting at the request of any police officer and for any person.
Were these people arrested?
They were taken to custody, my lord. Their statement was
How
recorded
did you take them into custody?
because we, upon receiving information, there are more than 30 plus people who are present.
So how did you take them into custody without drawing up an FIR?
No, FIR was drawn.
And without arresting, when did you release them? Did they secure bail?
After
Oh, my
medical
lord, what they
examination, they
say,
were released.
page number 60, they say 25/5/25, I was arrested, I was released. But to show arrest,
Where? Arrested where?
ಅದೇನು ಹೇಳಲ್ಲ.
They were taken to police station.
Ah.
They were subjected to medical examination.
No, that's all right. Without arresting, how did you take them? How did you conduct medical examination?
I'll place that arrest details.
If you have arrested them, where is the grounds of arrest, reasons of arrest? And if you have not arrested, how do you take blood samples of
No,
theirs?
are grounds of arrest, my lord, if we arrest and then producing before magistrate. We are not, we did
Andre,
not,
without grounds of arrest, you can keep anybody in custody and
no, we have not kept it. We have released them.
immediately.
Immediately.
Where is the arrest memo?
I'll place those.
At least an arrest memo should be there.
No, the
Accused
notice
number
is
1,
issued.
2, 3, arrest
all this-
ಮಾಡಿದ್ರೆ all documents are there. Arrest memo, grounds of ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದಾರೆ. Same day, in the same rate.
And they were taken to custody.
Our
That's all right.
Accused number 4 in the, nothing, no document to show.
How
their
many
arrest.
people were involved here?
35 odd people were there, my
What
lords.
is party, is it?
It was a party, my friend's birthday party in a farmhouse.
ಯಾವ್ದು ಹಳೇದು?
ಇಲ್ಲ
ಇಲ್ಲ
ಮೊನ್ನೆ
Sunny,
ಮತ್ತು
2025 December.
Ah.
Sorry, April.
What was the drugs found?
My lords,
Everything.
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 cocaine, small quantity 0.9 grams, which was not recovered from the petitioner. My lords, accused number 1, 2, 3 in the recover ಆಗಿದೆ. Who was hosting the birthday party. ಅವರಿಂದ recover ಆಗಿದೆ. From the petitioner, they subjected to body search, nothing was recovered. Subsequently, they say that she was arrested, but not a single document is given. They subject her to blood test and urine test. Lords, without arrest, anything.
No, that's all right. That
Yes.
will answer.
Yes, please.
Only cocaine is found, is it?
ಇಲ್ಲ,
No, no.
they say
Multiple things.
Huh?
Multiple drugs. So you can see the age of these people, my lord, are all.
My lord, 60 grams of hashish, 9 grams of marijuana, 4 grams of hydroponic ganja, 0.9 grams of cocaine, and they said 12 grams of suspected narcotic substance.
The petitioner is from Mumbai. She's traveled from Mumbai to Bangalore.
For the party.
Illa Swami, she is a resident of Bangalore. Her Aadhaar card is placed on record.
Details of the accused.
Why ನೀವು ಪ್ರೊಸೀಜರ್ ಯಾಕೆ ಫಾಲೋ ಮಾಡಲ್ಲ ಅಂತ ತಾನೇ?
No, because the consumption, my lord, they are not arrested for that reason. Otherwise, my lord.
Why do you take blood samples?
No, but how do we investigate, my lord? If we,
But law requires you to arrest them.
I'll have a look at it.
ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಮೆಮೊ ಕೊಡಿ. There should be some proceeding
I'll verify.
if you have taken them into custody and released them.
I'm sure in the station PSR would have been written.
Whatever
I'll
is there,
produce.
you produce.
I'll produce it.
I'll take it on Friday.
Lord, 13th is the date in the trial court.
13th is the date in this court also. 13th, yes.
Pledge.
List the matter day after tomorrow in the fresh matters list.
20.
Matter was listed day before and Koya sir had appeared and sought for the matter to be listed on next Tuesday, my lords. It has been inadvertently listed today again.
Why is it, Tuesday I remember.
Yes, my lords. Next Tuesday it was supposed to.
No, there's a mistake. Tuesday hakit. We'll post it on 17th.
Yes, my lords.
The matter was in fact adjourned to 17th to enable the state to file its statement of objections. There is an inadvertent error of a direction to release the matter today being printed on the order sheet. In that light, list the matter on 17th in the same stage. Objections, if any, by the state by then.
Interim protection.
Interim protection granted on, interim protection subsisting shall continue to the next date. Objection ಆಗ್ತಿರಲ್ಲ.
Active, but our notice ಕೊಟ್ಟ ಏನು ಬಂದಿಲ್ಲ.
ನಾವು ಕಳ್ಸಿದೀವಿ my lords. It has reached the police on 7th, I believe, my lords.
ಏನ್ ನೋಟಿಸ್ ನೀವು ಹೋಗಿಲ್ವಾ?
Speed post ಒಂದು RPID ಮೂಲಕ
Where are you?
I'm in Mumbai, my lords.
Sir, yes.
21.
7A. ಇದರಲ್ಲಂತೂ ನೀವು ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೋಬೇಕು. All found.
Demand ಇಲ್ಲ.
Huh?
There is no demand from me.
Accept ಯಾಕೆ?
Acceptance.
ಮತ್ತೆ ಡಿಮಾಂಡ್ ಇಲ್ಲದೆ acceptance ಯಾಕೆ ಮಾಡ್ಕೊಂಡ್ರಿ? I have seen the papers. No chance. ಇದರಲ್ಲಂತ I can write. No, ಮೊನ್ನೆ ತಾನೇ ಬರ್ದಿದ್ದೀನಿ.
ಪ್ರಭು ಗೌಡ.
Once sir you are caught red-handed with currency, presumption under section 20 kicks in. That's a matter of trial. If demand illa, acceptance illa, yaar third party accept ಮಾಡ್ಕೊಂಡ್ರೆ there is some flaw there. That we will answer. Department inquiry ದು ಬರ್ದಿದ್ದೀನಿ ಮೊನ್ನೆ.
ಹೌದು. Latest.
ಕೈಗೆ recovery from the pocket or hands of the delinquent of the accused. Any amount of department proceeding exoneration will not come in the way. That is, ಇದರಲ್ಲಿ clear acceptance.
Acceptance of course.
ಮತ್ತೆ
Seen from the muzzle.
Trap muzzle clear ಆಗಿದೆ.
Trap muzzle clear.
It is recovered from you. Discharge ಹಾಕೊಳ್ಳಿ. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ. ಒಂದು heard the learned counsel appearing to, the petitioner is before this court seeking the following prayer. Heard the learned counsel appearing for the petitioner P. Prasanna Kumar. The learned counsel though vehemently contends that there is no demand, but acceptance is found, it would not be enough in law to continue the prosecution against the petitioner. Would later submit that he would avail the remedy of filing a discharge, and in the event the concerned court would not discharge the petitioner on the said ground, would approach this court again. Reserving such liberty, the petition stands disposed.
22.
My lords, I appear for the petitioners, my lords.
447. Possession livre idare.
Two civil courts,
ಆಯ್ತು, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಂತಲ್ಲ.
I'll challenge charge sheet.
Immediately challenge ಮಾಡಿ. This has to be stayed till the disposal.
Two courts, my lord, position. Grateful.
Correct, sir. You do it immediately, I'll grant an order.
Grateful.
On the learned additional SPP submits pursuant to the investigation, charge sheet has already been filed. The learned counsel of the petitioner seeks leave of this court to withdraw the petition and file and raise a challenge to the charge sheet. Reserving such liberty, petition stands disposed.
Grateful.
ಅದು ಮೆನ್ಷನ್ ಮಾಡಿ 230ಗೆ. I had withdrawn for the purpose of charge sheet.
Grateful.
Yes.
Petitioners in the matter. Crime came to be filed under provision 318(2) of PNS and Atrocities.
You should be a little louder.
But petitioners are the banking employees. The crime act came to be registered under provisions of section 318(2) of BNS and section 3. 1Q31 and 32 VA, my lord, of Atrocities Act. The respondent, my lord, too, is the borrower in the financial bank, my lord. After they have initiated the surprise proceedings, he had caused a complaint and filed.
Whom have you sold, sir?
We have not sold.
You have sold the property during the substance of the mortgage.
No, my lord. I am the banker, my lord. I am the bank employees. Bank employees. After 3 months of I have vacated the premises, I have taken possession. He has come on before and filed a petition.
The land, though it was sold to somebody else, was sold to the complainant, and the bank advanced the loan.
ಅದೇ fraud played by the borrower.
Borrower as vendor or his.
ಅಲ್ಲ ನೀವು ನೋಡಿಲ್ವಾ?
As per the documents.
Due diligence ಮಾಡ್ಲಿಲ್ವಾ?
Due diligence is correct in this one. I have produced the documents before the court.
So that is where the complainant also saying, my lord,
after 3 months of he has been taken possession, they has gone before the police and filed this.
Anyway, let them not, will let the Atrocities Act antu barala. One R&S ಅಲ್ಲ ಇದು.
ಅಲ್ಲ dispossession ಬರುತ್ತೆ.
Dispossession ಬರುತ್ತೆ because you dispossess them.
Dispossessed 3 months ago, even before the complaint filed, my lord. It is NPA in the 3/10/2024 the NPA, my lord. Magistrate order was taken.
ಲೋನ್ ತಗೊಂಡಿದ್ದೆ ಯಾವಾಗ?
2023.
NPA ಆಗಿದ್ದೆ ಯಾವಾಗ?
3/10/2024. Loan was sanctioned on Lord 11th May 23.
3 months NPA ಒಂದ್ಸರಿ ಆಗಿದೆ ಅಷ್ಟೇನಾ?
NPA 3/10/2024.
ಆಮೇಲೆ ಏನು ಕಟ್ಟಲಿಲ್ಲ?
ಇಲ್ಲ ಸ್ವಾಮಿ. He has never paid a fine.
FSC proceeding initiate ಮಾಡಿದ್ರಾ?
Initiate ಆಗಿ ಸೇಮಿಸ್ ಆರ್ಡರ್ ಆಗಿ ಅದಾದ್ಮೇಲೆ
ಏನು ಆರ್ಡರ್ ಆಯ್ತು? ಆರ್ಡರ್ ಏನಾಗಿದೆ?
ಪೊಸಿಷನ್ ತಗೊಂಡು ಆರ್ಡರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. ಅದು ಸೆಕ್ಷನ್
ಪೊಸಿಷನ್ ತಗೊಳ್ಳಕ್ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಪೊಸಿಷನ್ ತಗೊಂಡ್ರಾ?
ಹೌದು.
ಅದಕ್ಕೆ ಮುಂಚೆನೆ ತಗೊಂಡ್ರಾ?
No, I have served notice on him at page, my lord.
No, he's
page 115 is the notice to vacate.
Contention, my lord. The property which was the owner, the person who sold the property, he was not the owner because he's already sold the property to somebody else. And that, because that's the reason he did not
ಯಾರು?
take.
The person who had borrowed.
The person who sold the money, property to the borrower, sold it without having title.
That is between them. How are they involved? Sir?
Therefore, he was dispossessed and he did not pay the EMI to the bank.
We will see. Not these officials who they are armed with a possession order from the concerned court.
I have served notice on him for vacating the premises.
One additional SPP, 2 emergent notice returnable by 10th April. List the matter on 10th April. Further investigation query these petitioners shall remain state till the next date.
Clarify, my lord, with respect, other investigation can
If any other accused are, if there are any other accused in the subject crime, i.e. crime number 6 of 2026, against them, the investigation shall continue. It is stayed only against these petitioners.
24.
Housing loan.
Yes, your lordship.
In the meantime,
38 matter
petitioner
was-
to serve on the counsel who represents the respondent in the trial proceedings. There shall be an interim order of stay of further proceedings before the concerned court till the next date. List on
Your lordship.
6th April.
Your lordship, I have a submission in the trial court. It is posted on 13th.
Stay ಬೇಡವಾ?
Stay back, your lordship.
ಕೊಟ್ಟಾಯ್ತಲ್ಲ?
The order may be
ಅಯ್ಯೋ ಅಷ್ಟೇ ತಾನೆ ಸರಿ.
communicated through email, your lordship.
13th ಅಲ್ವಾ?
13th of, that is two days after this. 13th
2 days, 48 hours away.
Yes.
Yes, sir. Anything else? We'll dismiss it otherwise.
No,
Yes. ನಾಳೆ ಅಪ್ಲೋಡ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
For petitioners, your lordship.
Ah.
A counter FIR has been filed by advocate who is representing the
ಚಾರ್ಜ್
husband.
ಫ್ರೇಮ್ ಆಗಿದೆಯಾ ಅದರಲ್ಲಿ?
Charge sheet has been filed.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಈಗ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಸರ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರ್ಬೇಕು. ಜಸ್ಟ್ ಚೆಕ್ಅಪ್.
Verify, my lord. I'll verify with me.
Friday.
Friday, my lord.
List the matter on Friday in the fresh matters list.
Lordship, today was the date before the trial court.
Friday is the date here. Yes.
26.
My lord, I represent the petitioner. The charge sheet has been submitted.
We are for our to.
Notice ಮಾಡಿಲ್ಲ ಇನ್ನು? Why did you come?
Filed wakalat yesterday, lordship.
Why did you file wakalat even before issuing
Not yet
notice?
Received copy, lordship.
Huh?
We have yet to receive the copy, lordship.
Then it's a matter of stay, for stay.
No, lord.
My lord,
31
charge sheet
R&S.
for offences punishable under 113.
31 R&S, sir.
My lord,
31 R&S
Please,
and
my lords, please,
assault.
my lords, the issue is this, my lords. The petitioner number 1 has borrowed money from the respondent number 2. Now there is some dispute as regards to repayment. In
Where is
fact,
the wound
money is
certificate?
repaid. My lords,
Wound certificate.
my lords, wound certificate, lordship would kindly find at page 66, my lords. Simple in nature. Page 66, my
Cardiovascular,
lords.
familiar joint. Check soft tissue.
My lords, the
File your
alleged
objections.
incident is on the date of my marriage, my lords.
Marriage.
The petitioner number 1 was getting married on 2nd of May. The respondent number 2, along with CW 1 to 4, they barged into the chowdhury. They roughed me up before my family. All that has happened is there is some
ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ರೆ ಇವ್ರ ಹತ್ರ?
ದುಡ್ಡು ಇಸ್ಕೊಂಡು ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ. Produce the account statements, marriage. The entire account
ಇಲ್ಲ
statement is
ಬೇರೆ
produced before.
ಬೇರೆ ಟೈಮಲ್ಲಿ ಹೋಗ್ಬೇಕು ತಾನೆ ಕೇಳಕ್ಕೆ. ಮದ್ವೆಗೆ ಯಾಕೆ ಹೋದ್ರಿ?
ನಾವು ಹೋಗ್ತಿದ್ದಾಗ ಅವ್ರು ಕಾಲ್ ಮಾಡಿ ನಾವು ದುಡ್ಡು
ಅಲ್ಲ,
ಕೊಟ್ಟು
ನಾನ್ ನನ್ನ ಮದ್ವೆಗೆ
ಮದ್ವೆಗೆ ಬನ್ನಿ
ಗಲಾಟೆ
ಬನ್ನಿ ಅಂತ ಹೇಳಿ
ಮ್ಯಾರೇಜಿಗೆ ಬನ್ನಿ ಅಂತ ಕರೆದ್ರ?
ಹಾ.
ಊಟ ಮಾಡ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾಗಿತ್ತು ಸುಮ್ನೆ. ಕರೆದ್ಮೇಲೆ ಅಲ್ಲ ಅಸಾಲ್ಟ್ ಮಾಡಕ್ ಯಾರು ಹೇಳಿದ್ ನಿಮ್ಗೆ? ಮದ್ವೆಲಿ ಯಾರು ಅಸಾಲ್ಟ್ ಮಾಡ್ತಾರ?
Lordship, we have not assaulted.
ಏನ್ ಮೂವಿನ
We
ಇದು?
assaulted him.
Accused number 1, Puneet has assaulted complainant lordship.
At what stench, I had
Oh,
no stench of
tali katta
imagination.
idare,
I
sir.
could have invited somebody to my
Page
wedding and
62.
roughed them up in before the guests, my lords.
Photo on.
ಯಾರಿದು ಯಾರು ಹೊಡೆದ್ರು ನಿಮ್ಗೆ? ಅವ್ರನ್ನ ಕರಿಬಿಡಿ, ನಿಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ಅಷ್ಟೇ.
A1 lordship.
ಏವನ್ ಹೊಡೆದಿರೋದ? ಮತ್ ಮದ್ವೆಗೆ ಹೋಗಿ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡ್ತಾರ ಅವ್ರು? If you go to his marriage, you should eat and come ಅಷ್ಟೇ, not beat and come. Anyway, file your objections.
Please.
Charge sheet ಹಾಕಿದಾರಲ್ಲ?
Charge sheet file ಮಾಡಿದ್ದಾರೆ.
Yes, they list the matter on learned counsel so and so undertakes to enter appearance for the second respondent complainant. List the matter on 7th April in the fresh matters list. Objections, if any, on this by the said date.
Well, it's until then, if there
Yeah, until then.
the charges might be framed.
The concerned court shall not frame charges till the next date.
I'm grateful.
Yes, next.
27.
Matter where, my lord, farmers protested for, my lord, some justice.
Justice?
Yes, my lord. Where,
Really,
my lord,
very
in
sorry,
over
my
a period of 1 year, my lord, 12 people died, my lord, because of elephant trampling.
I know,
Farmers.
I spoke to the SP, my lord. He says, my lord, that there was no intention of arresting anybody. Of course, deaths have happened, Victim family.
That's because of the elephant movement.
Elephant, that's correct, my lord. That it happened. The victim family who lost their life, they wanted to take the body and that they have been prevented by others. Of course, whatever genuine reason may be there, my lord, but there was no apprehension of arrest.
Solid.
I've sought the records, my lord. Your lordship have it
ಏನು
next.
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ. Don't take any coercive steps against
Order is
him.
there, my
There,
lord,
my lord, your lordship have it.
ಸಾಕ್ ಬಿಡಿ.
Lord,
Let him produce the,
delay, my lord, suo motu complaint registered in the late in the night.
ಆಯ್ತು, late in the night.
Yes, my lord.
ಮಾಡ್ಲಿ ಬಿಡಿ.
The protest
what?
was, my lord, till 6 o'clock. They registered FIR in the
ಜನನೆಲ್ಲ
night and
disperse ಮಾಡಿ
10:30.
ಆಮೇಲೆ ಬಂದು register
Lord, nothing
ಮಾಡಿದ್ದಾರೆ.
has happened, my lord. In unnecessarily, my lord, case has been filed
Let's see.
due to political.
The learned political. The learned additional SPP to place on record the investigation material on the next date, list on 18th fresh matters.
Interim order.
Interim order subsisting shall continue to the next date of hearing. Heard the learned senior counsel Arun Shaman Bharadwat Madi. This next.
My lord, I appear for the petitioner in this matter. My lord, I raised a plea of nullity before the execution court and sought a reference to the High Court.
What execution, madam?
My lord, there was a conviction order against the company as well as the managing director. However, my lord, there was no conviction recorded against the office bearer of the company. So the plea of nullity was raised on 2 counts, my lord. Basically on 3 counts, but specifically on
Where
one.
do I get the order of the executing court?
My lord, the executing court order is annexure 1 at page number, the operative portion. It's annexure 1 at page number 12 it begins. 11 it begins. And the operative portion is at page 17.
Oh, this is the first order itself. Yes.
Please. My lord, the plea of nullity was raised on 2 counts, my lord. That first, there is no conviction recorded against the petitioner per se, and there is only conviction of the company. And for the conviction of the company, without recording and without reversing his acquittal before the trial court, petitioner as well as the company both were acquitted. The company's acquittal was overturned, and in the appeal proceedings, only the company was convicted. And without recording any conviction against the petitioner, the 141 section was invoked under the section under the NI Act to fine and to impose entire sentence on the petitioner, and there is not even a penny of fine on the company, my lord. So the contention was, until and unless there is a specifically conviction recorded against the petitioner, he cannot be sentenced. And for the conviction of the company, since there is no sentence, so that there is a jurisdictional error of the honorable court in not sentencing the company despite its conviction and sentencing the petitioner despite there being no conviction. This was one contention. The other contention was, before imposing this entire fine on the petitioner, no hearing on the quantum of sentence was granted. And the Supreme Court in various judgment has said that if there is no hearing on the quantum of sentence, then the sentence vitiates. But what is operating against me is only the part of sentence. There is no conviction against me. So I contended before the trial court, since there is no hearing on the quantum of sentence, it vitiates.
Then how can,
Therefore,
i-
please, ma'am.
without conviction, what is being executed now?
My lord, the sentence part is being executed. Your lordship may kindly have the appellate order, which is at page
Did
number.
you not
the
challenge
operative
those
court.
orders before the appellate courts, sir?
My lord, what had happened, we challenged those orders, but unfortunately this plea of nullity was not raised before the Supreme Court. And the Supreme Court dismissed the SLP in limine without any adjudication on merits. And my lords are well aware that in coded distilleries, this has been held that the SLP dismissal in limine does not merge with the order of the High Court, nor
That
does
is-
it amounts to upholding.
That is too rudimentary, madam. It's all right.
My lord, plea of nullity can be raised at anywhere, including in the execution proceeding. This is the settled law, my lord. I raised these pleas before the execution court, and the third plea was that the convict itself, the company, remain unrepresented. My lord, in Krishna Prasad has held that the company representative has to be a choice of the company. There was no representation on behalf of the company, and I placed before the execution court the material which shows that there was no one appearing for the company, there was no wakalatnama, there was no service through the company. So even the convict, who was the convict, that also remain unrepresented. Then this order becomes an order passed in violation of principles of natural justice, again leading to a jurisdictional error.
All
And
the all the contentions were not raised before the appellate.
no, my lord, these three contentions were not raised in SLP, my lord. Unfortunately, these were not raised, my lord. Therefore, my lord, I have sought recall of the order. That recall application is pending adjudication before this court. And during the pendency of that recall, since there was a constraint on the execution court, so I requested the court to make a reference to the High Court on the question of law, whether in summons cases too, there is a mandatory requirement of hearing the accused on the question of sentence. And I cited practices from 7 different High Courts before the execution court to contend that you have to necessarily hear the accused on the question of quantum of sentence separately after the conviction is recorded. Here is a case, my lord, where there is no conviction recorded against the petitioner. My lord, may kindly have page 67, which is the appellate order which is being enforced against me. I won't take much time, my lord. The operative portion itself substantiate for the submissions, my lord. At page 67, the operative portion is there. It reads, my lord, sir,
Yes.
appeal is
No,
allowed. The judge,
you should seek recalling of this order.
my lord, I have
Or
sought.
modification of this order.
My lord, I have sought recall of the order, and that has been heard at substantial length. Now, my lord, it is adjourned for 17th March. That recall application is pending in the criminal appeal number 422 of 2015.
Because
And
everything
during
hinges,
pendency-
everything hinges upon
Very
this.
good. Certainly, ma'am, certainly. So I have sought recall, my lord. My only submission is until unless my recall is decided, let there be not any execution of the present order, my lord.
Heard the learned counsel, Miss Nisha Tiwari appearing for the petitioner. Otherwise, we will file a for clarification.
My lord,
So, the order that is now sought to be executed before the executing court is as follows. Page 70 and 71. This was tossed before the apex court. The apex court has rejected the SLP in limine. Therefore, the order of the coordinate bench in criminal appeal would not become binding on this court to consider the submissions of the learned counsel appearing for the petitioner. As observed here and above, what is sought to be executed is the order quoted. The learned counsel submits that there was an error in order, as there was no sentence indicated against the petitioner except the order of conviction. And the company was not convicted, is it?
My lord, company was
not
convicted but
represented.
was not represented.
Company was not even represented. Therefore, there was a clear flaw in law. The learned counsel would further submit that the application seeking recall of the order passed on 14th October 2022 in Criminal Appeal 422 of 2015 has been heard at length, and matter is posted on the 17th of March. 17th of March, right?
Please.
17th of March. Therefore, if the concerned court would now proceed with the execution of the order, which is sought to be recalled, and the matter being heard by the coordinate bench, it would frustrate the very proceedings. In that light, the executing court, which court is that?
22nd ACMM.
In that light, the concerned court shall not proceed further till the next date of hearing. List the matter on 26th March in fresh matters list.
Milord, may I make one small submission, Milord? The recall was heard at length, though the Honorable Judge was pleased to release the matter subsequently from the head of part head. So now that has to come before
Where is
another
it
bench.
now?
Milord, it has to be to go to the roaster judge, who probably
Then
roaster judge.
you should
Milord,
have-
can you tag
you
the
should have
matter.
told me
Your-
that.
Milord, my submission is that since the submissions will almost be similar in this matter as well as in the recall application, Lord. If your lordship can hear both the matters, because now it has been released from the head of part head, Milord.
One
If your
moment.
lordship consider.
Which is the roster bench? We don't know. Yes.
Milord,
Anyway, we'll post it on 27th. If nothing happens, we'll pass necessary orders on that day.
Division.
Hmm?
Kamal. Yes.
Kamal sir.
Milord, I was requesting for tagging of the matter. If your lordship is
Tagging on that day will do. I don't know.
very well, very
We'll-
well,
Tagging on that day will do. 27th, yes.
very well. Obliged. So great.
29.
Case of trespass against the registered owner. Case of trespass against the registered owner. Also, but ex parte injunction granted not in favor of the second respondent.
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಬರೀ
Has not
ಅಷ್ಟೇ
been
ಇಲ್ಲ,
stayed.
ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಇದ್ದಂಗೆ.
Has not been stayed, not at page 113, 111, you lordship.
ಒಬ್ರಿಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀರಾ?
Yes. 111, the ex parte injunction now not is stayed, operative portion at page 127.
Ex parte injunction was granted in favor of the complainant.
Complainant, which is now
Yes.
stayed, 111, at operative portion 127.
Hmm.
Para 2, there shall be stay of the operation and execution of the
When
judgment
did
and
this
decree.
incident happen?
This, the judgment is on 11 February 26, my lord.
When did this incident
The
happen?
incident, my lord, is alleged on 28/1/26.
When was the stay granted?
But stay was granted,
Injunction granted when?
not this much prior to, my lord, this injunction,
No, I'm asking, was it between the two dates?
16/4/25, 16/4/20.
25 itself. Then incident ಯಾವತ್ತು?
But incident according to, on 28/1/26.
Stay vacated on 11th February 26.
Please,
He was in possession.
please. Not is vacant, not premises where not I put up a shed and not my tenant is now also not made as an accused. Not the lease agreement is at page 35.
ಇದಾದ್ಮೇಲೆ ಹೋಗಿದ್ರೆ ತೊಂದರೆ ಇಲ್ಲ.
No, he is a government servant, not. he was the-
Whatever, he is
No,
armed
otherwise
with a-
not.
he is
But in
armed with an
fact-
order of injunction which was subsisting as
As
on
on
the
the
date of the
date,
incident.
may I just make one, as on the date of not this alleged incident at Hassan, he in fact not is serving in Bangalore, that's not is a plea of LIB.
Who?
The petitioner not is a government servant. The first petitioner,
What are you working as?
but he is working not in legal metrology department.
ಇದು ಬಿಕ್ಕೋರಲ್ಲ ಯಾರು?
Because I am not the co-owners, family members.
But you have trespassed into his property. That's the allegation.
That is the allegation. I could not have trespassed because I am in Bangalore, not working in Bangalore, in legal metrology department. This
ಇದು ಎಲ್ಲಿ
happens-
ಹಾಸನ್ ಲಾಗ?
Hassan ಅಂತ ಹೇಳ್ತಾರೆ.
They have trespassed to remove the board which is.
All the others are there.
All the others may not are in Hassan, 2, 3, 4 and 5.
Yes, Jagdish.
ಪ್ಲಿಯಾ ಫಲೇಬಿ ಅಂತದಲ್ಲ ಜಾಸ್ತಿ ಕೊಟ್ಟಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ಸ್. ಈ ಇನ್ಫ್ಯಾಕ್ಟ್
ನಟರಾಜು ಮತ್ತು ಅವರ ಬೆಂಬಲಿಗರು.
ಬೆಂಬಲಿಗರು.
ಹೌದು.
ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಗೆ ಫಾಲೋವರ್ಸ್ ಬೇರೆ ಇದಾರಾ?
ಫ್ಯಾಮಿಲಿ ಮೆಂಬರ್ಸ್. But partition also.
Politician ಬೆಂಬಲಿಗರು ಗೊತ್ತಿತ್ತು.
Partition did not have produced.
And he says, my lord, ನಟರಾಜು and ದುರ್ಗಾ ಪ್ರಸಾದ್ ಕಿತ್ತಾಕಿದ್ರು ಅಂತಾನೆ ಹೇಳ್ತಾರೆ.
If he secures instruction, not he will come to know.
Yes, get the papers.
Not in respect to the first petitioner.
ಫಸ್ಟ್ ಪೆಟಿಷನರ್ ಕಿತ್ತಾಕಿದ್ರು ಅಂತಿರೋದು.
ಅಲ್ಲ ಅವನು ಇಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಇದ್ದಾನೆ ಸ್ವಲ್ಪ. Hassan, he is working not in Bangalore in legal. Let him secure instruction. Since
We'll check the call records detail we disclose.
ಸಿಗುತ್ತೆ ಅದೆಲ್ಲ ಡೀಟೇಲ್.
Yes. Legal metrology. List the matter on Monday akla?
Next Monday, I'll secure the CDR also in case if.
Yes.
23.
List the matter on 23rd. in fresh matters list.
It did not precipitate.
Don't, the respondents state shall not precipitate the matter till the next. Bail ತಗೊಂಡಿಲ್ವಾ?
Trespass under ತಗೊಂಡಂಗಿಲ್ಲ.
Yes, for the next date of hearing.
Please.
30.
In the meantime. Yes. Huh? Oh, sorry, ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ. The petitioners are before this court calling in question the register, charge sheet ಆಗಿಲ್ಲಲ್ಲ, crime ಮಾತ್ರ. Registration of a crime for offences punishable and priorly, madam. Perusal at the complaint would clearly indicate that a seemingly civil dispute is dressed, DRESSED, dressed with a color of crime, and the criminal law is set into motion. In that light, there shall be an interim order of stay of further investigation by the petitioner till the next date of hearing.
One submission. Clearly, section 1 yes ಆಗಬೇಕಾದ್ರೆ W ಆಗಿದೆ correction.
ಏನು?
31 yes ಮಾಡಬೇಕಾದ್ರೆ 31 W ಅಂತ ಮಾಡಿ.
ಓ, ನೀವೇನು BNS plus ಮಾಡಿದ್ದೀರಾ ಏನು? Yes. ಅದನ್ನು change ಮಾಡಿ.
For the petitioner in this matter.
109 added atrocity ಆಮೇಲೆ.
add.
ಪರವಾಗಿಲ್ಲ. 109.
Now, my lord, what happens is 28/2/2026, an FIR in crime number 89 of 2026 comes to be registered by the Vidyaranyapura police under 109 against me. Immediately, I am arrested. I am warming the benches at the police station. Then immediately, I have been sent for medical examination and I have been remanded to judicial custody by the jurisdictional magistrate. Subsequent to that, after 6 days delay, my lord, this crime number 96 of 2026
ಮಾಡಬಾರದು, permission ತಗೊಂಡು ಮಾಡಿದಾರಲ್ಲ.
ಅಲ್ಲ, crime number 96 of 2026 come to be registered against me, stating only for these two reasons.
Second crime ಅದು.
Second crime ಇದು.
ಅಲ್ಲೇ add ಮಾಡ್ಬೋದಿತ್ತಲ್ಲ, second crime ಯಾಕೆ?
Complainant are different.
Complaints are different.
However, what happens, my lord, when the first complainant registers the crime, he belongs to the Golla community. He is the defendant number 9 in one OS number 7644 of 2025, which is filed by the accused number 3 there. So there is a civil dispute just 1 month prior to this date of incident.
No, anyway, Atrocities Act we will stay, but not this first crime ಯಾವ್ದೋ ಇದೆ ಅದು ಸ್ಟೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
ನಾನು ಅದು ಕೇಳೇ ಇಲ್ಲ. I am only come on crime number 96. That time I filed a regular bail application before the court, my lord. What they do is,
ಇದರಲ್ಲಿ what is the second crime for Atrocities Act?
the Atrocity Ordinance Act of 2014.
ಅಲ್ಲ, ನಿಮ್ಗೆ Atrocities Act ಆಗಿ ಬಹಳ ದಿನ ಆಗಿದೆ, ಇನ್ನೂ ಆರ್ಡಿನೆನ್ಸ್ ಅಲ್ಲಿ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಸಿ 31 RNS 325A ಇದು ಯಾವ್ದು Atrocities Act ಆರ್ಡಿನೆನ್ಸ್ ಅಲ್ಲ, there is already an act 10 years ago. This is the 10th file I am seeing where ordinance is mentioned.
Cut and paste.
Yes.
Page 32 ನಲ್ಲಿ he given a description, my lord, about making telephone call 112 in the earlier occasion.
Earlier occasion ಆಯ್ತು, for what?
ಅಲ್ಲ, ರಾಡಲ್ ಬಂದು ಹೊಡೆದಿದ್ರು ಅಂತಾನೆ ಹೇಳ್ತಾನಲ್ಲ.
ಅಲ್ಲ, ಹೊಡೆದಿರೋದಕ್ಕೆ ಇದು Atrocities Act ಮಾತ್ರ ಇದು.
He is not belonging to the SCST. The earlier crime, he belongs to a Golla community. It's in the FIR. What he does is, my lord, this complainant and that complainant, both are defendant number 8 and 9 in a suit which the accused number 3 has filed.
That's all right.
And both of them are having adjacent sites, wherein I claim to be the larger.
Atrocities Act I will stay.
Son, ಕೇಳಿರೋದು ಬರೀ Atrocity Act ಮಾತ್ರ. This FIR, my lord, kindly come to Annexure A for a moment.
Where is the FIR here?
Annexure A for a moment, my lord.
ಇಲ್ಲಿ 118 ಎಲ್ಲ ಇದೆ.
Running page number 26.
118 ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
ಅಲ್ಲ, 118, 352, 351, 109 ಇಲ್ಲ ನನ್ನ ಮೇಲೆ. That is in the first
crime. Illi I am not saying anything else except atrocity.
Alla, even for 118 for a moment,
that will permit investigations.
Alla, kindly
Rod in the hodidru antidre matra.
Alla, what they have done here is that, my lord, when the date of incident kindly maybe peruse, my lord, 28/2/2026 I have been arrested. After 6 days delay, they filed this FIR against me. I did not even know that this FIR is filed against me. They take a copy of this FIR, go to the criminal miscellaneous case before the sessions court.
Insofar as offense under 324 is concerned, we will look into the investigating report.
Very well,
Atrocities Act I will stay.
I bowed on one submission. What they do is, after having filed this FIR, I had filed a criminal miscellaneous for regular bail. There I get to know that to show my criminal antecedents, they post this FIR by the de facto complainant.
See, you bail tagolli adar padige. Atrocities Act I will stay.
As regards atrocity, my lord, even there is kindly come to the earlier FIR, my lord, for a
moment, whatever it is. The
Annexure C.
Others I will only grant stay after looking into the investigation papers.
Very well. ಅದು
This
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ that at the very same moment where earlier FIR is registered, my lord, I've been arrested. So there cannot be two incidents of crime, my lord, by two separate persons.
Complainant is different.
Complainant is different.
ರಾಡ್ ಇಂದ ಹೊಡೆದ್ರು ಅಂತ ಇದೆ.
ಫಸ್ಟ್ FIR ಅಲ್ಲಿ my lord ಏನಾಗುತ್ತೆ?
ರಾಡ್ ಇಂದ ಹೊಡೆದ್ರು ಅಂತ ಇರೋದು ಫಸ್ಟ್ FIR ಅಲ್ಲ?
ಹೌದು ಫಸ್ಟ್ FIR ಅದನ್ನ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
ಆಯ್ತು.
ಸೆಕೆಂಡ್ FIR ಅಲ್ಲಿ all that they say is I've roughed him up.
No, you have roughed him
And
up.
both the
roughed him
incidents.
up on 6/3/2026.
ಇಲ್ಲ, the
Sorry,
kindly see
roughed
the
him up on
complaint date,
28/2/2026.
my lord, the complaint incident both are of 28/2/2026. Kindly take annexure B page number 31 for a moment.
ಅಲ್ಲಲ್ಲ, your lordship is page 32.
ಅಲ್ಲ 31 ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ for a moment, my lord. ಕೊನೆಯಲ್ಲಿ the alleged date of incident is on 28/2/2026 ಬೆಳಿಗ್ಗೆ 9 ಗಂಟೆಗೆ.
ಈಗ
both have happened on the same date.
ಸಬ್ಜೆಕ್ಟ್ ಕ್ರೈಮ್ ಯಾವುದು?
Subject crime is crime number 96 of 2026, which is at annexure A, my lord. Running page number 26. 26 of my petition.
One moment. The FIR.
FIR.
Where is the complaint?
Complaint is at annexure B, running page number 31.
Correct. 31 is the subject crime.
Yes, kindly see the date, last third line from the bottom, my lord. ದಿನಾಂಕ 28/2/2026 ಬೆಳಿಗ್ಗೆ ಸುಮಾರು 9 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ನಾನು ಎಂದಿನಂತೆ ಕೆಲಸ ಮಾಡುತ್ತಿದ್ದಾಗ it goes on, my lord.
ಆಯ್ತು. Where is the first complaint?
First complaint is at annexure C, my lord. That is annexure D, running page number 39. The handwritten one, then I have produced the type copy.
The time ಏನು?
Morning 7:45 ಅಂತಾರೆ. 7:45, that is in the third paragraph.
Attempt to murder.
ಅದು same date. I have immediately been arrested by the same Vidyaranyapura police, my lord. Not in a different jurisdictional police station. Both of them are friends. Both of them are defendant number 8 and 9 in OS, which I have filed.
Heard the learned counsel.
Page number 32, my lord. Your lordship is page number 32.
Ah.
He's given explanation for making, he made a telephone call to 112 on the same day, 28/2. 32, my lord.
ಈ ವಿಚಾರ ನಾವುಗಳು ಕೈ
next page, my lord. He says, police control.
You produce the papers. Atrocities Act, I will stay immediately.
Now, my lord, only one submission. They're using this as a criminal antecedent for me, my lord, and they're objecting the bail application. Only for that.
They are state.
My lord, how the Swami? Only my submission is this: on 28/2/2026, for two different offences cannot happen at the same time. Clearly, it is the same date, my lord, for both the offences. 1124 ಮಾಡಿರೋದು, all that he says is that he has called the control room. That's all.
He says that he was arrested immediately. Your lordship, if you page 44, my lord, he was arrested 7 PM on 28/2.
Formal arrest procedure, my lord.
Arrest is at 7 PM only. No, you produce.
My lord,
The learned additional SPP to secure the investigation papers in the subject crime number 96 of 2026 and place it before the court on the next date. Insofar as the offence under the Atrocities Act, the investigation the Atrocities Act shall remain stayed. They list the matter on 27th, Friday. Yes.
Very well, my lord. 48 ಅಲ್ಲಿ both of the defendants 8 and 9, they're friends, my lord.
We will answer that. We'll see.
Great.
Let the papers come. Next.
32.
RP is filed,
RP
my
ಯಾಕೆ?
lord. Annexure A was passed by my lords, my lord. Thereafter, my lord, my lords had passed an order directing the BWSSB to issue a notice and then pass any orders, my lord.
Right.
Accordingly, notice was issued. After the issuance of notice, my lord, they again file a writ petitions. They say that it is covered by my lord's order.
Covered alla idu.
Covered alla.
Notice
is issued. I have also attached the notice on annexure B.
Illappa, ivrige serve ಮಾಡಿ petitioner yaru?
Yes, my lord.
Petitioner to serve on the counsel who represented the respondent in the original proceedings.
Much.
And list the matter 27th.
Much.
33.
My lords, for petitioners, my lords. Petitioners are the complainant and de facto complainant, my lords. My lords, I'm seeking here the CBI investigation, my lords.
CBI?
Yes.
Why, sir?
My lords, let me explain, my lords.
FBI badwa?
My lords, on 9/11/2023, the petitioner number 2, he was taken from his house, my lords, to East Point Medical College, where he was working as an accountant. And in meanwhile, what has happened, their parents were called into the college, they were threatened with life, and a property was transferred to the accused called as Pramod Gowda, who is the CEO of the East Point Medical College. GPA was transferred to them.
Why CBI?
My lords, I'll just explain, my lords.
The offense is 323, 343, 348.
My lords, let me explain. Then subsequently on 12th November, when the FIR, when the complainants visited the police station, Avlali police station to register the FIR, they visited in the morning. From morning till evening, they are requesting the police to act swiftly, conduct any rescue operation so that he may be secured from the custody of the accused persons. Instead of doing that, the police are directly calling the institution and asking them to hand over the accused. At night, 8 p.m., accused comes along with a person called Anthony, who is also a staff of East Point Medical College, directly to the police station, and FIR gets lodged at night 10:30, my lords, after 2 hours of that incident.
Who are you?
My lords, I am the complainant and de facto complainant. I am the victim and de facto complainant, my lords. And my lord, subsequently, very next day, the investigation gets transferred to the Dodbellapur police station, which is about 70 kilometers far away, my lords, by a superintendent of police without giving any reasons, my lords.
The reasons are that you are making allegation against a local inspector, therefore it was handed over to different police.
My lords, there is no such reasoning mentioned, my lords. It's at page number 42, my lords. The order of the SP.
According to you, what has happened?
My lords, according to me, they kidnapped us and the GPA was transferred forcibly, my lords. The property was transferred and they had assaulted us and all these incident happened, my lords. And then subsequently, when they had to act swiftly, they go to the East Point Medical College to seize the CCTV footages after about 20-25 days. And over there, they find a technical lag. They say that there is a 5 minutes delay in the CCTV footage, and which is a technical glitch, and hence they leave it at that stage. They do not seize the DVR to rule out any tampering or any.
The allegation is forcibly transfer of property.
Forcibly transfer of property, and the person was kept under the custody of the accused persons for 3 days, my lords.
So CBI?
My lords, they are highly influential persons, my lords. They have completely biased the investigation.
Life or limb is lost and condemned. Property transfer.
Actually, his grievance is that abduction and wrongful confinement
Oh.
was missed out in the charge sheet. That is his grievance.
That's not the
So,
grievance,
but
my
on
lord.
the
The
line,
major
investigation-
evidences are ruled out, my lord. The
Proper
CCTV
investigation.
footage, which was supposed
To
to be,
seek further investigation before the court.
my lords, the accused also have been dropped out, my lord. The main accused.
Who has been dropped out, sir?
My lords, the Rajiv Gowda, Pramod Gowda, the specifically one called Pramod Gowda, in whose name the GPA was transferred, he is not made accused.
You are
Instead,
the
he is
owner of the
made
property?
Yes,
Are you the owner of the
yes,
property?
my lords. And he is made witness.
Hebrew 27, 29 years. What property is that?
My lords, it's a land, my lords.
How many acres? And where? Because you are 27 years, what land are you holding? Your petition must not become counterproductive.
Yes, my
ಯೋಚ್ನೆ
lords,
ಮಾಡಿ ಹೇಳಿ.
it must not become.
Anyways, Jagdish sir, look into it.
If-
There is no warrant. CBI never.
Well, at least an
he can file
independent
a protest
investigation may
petition
be
even-
carried
He
out.
can file a protest petition before trial court if some of the accused have been dropped.
My lords,
Let them
an independent
file a-
investigation will be carried out, my lords.
319 always option is available for you to bring back those accused.
My lords, the important evidences are not collected, my lords.
That will
The
see,
CCTV
seek further investigation. You concentrate on further investigation. CBI ಕಳಿಸಿದ್ರೆ
My
ಏನಾಗಲ್ಲ.
lords, pendency of this petition, charge has been framed, my lords.
You can't help, sir. We'll see.
My lord, charge was framed in the January of this year, my
The
lords.
hand
I
of
filed this petition
hand
in
of
the
this
May.
court will not be tied for further investigation at any stage. We'll see. Yes, list the matter on Tuesday, Wednesday, fresh matters list. Wednesday ಆಗ್ಬೋದಲ್ಲ? Yes, next.
34.
Dispute between two neighbors in an apartment. Allegation.
Dog.
ಇಲ್ಲ. ರಾಜ್ಯೋತ್ಸವದಲ್ಲಿ ಬಂದು ಡ್ಯಾನ್ಸ್ ಮಾಡಿ ಅಂತ ನಾನು ಹೇಳಿದೆ ಅಂತ. My wife, she has substantiated that dancing together in a society is always, it is part of high society living. Now, FIR is registered against me and my.
HCGP 2, additional SPP 2 emergent notice in the meantime. Yes, next.
35.
I pay for the petition. The last occasion, your lordship directed the government advocate.
Last occasion.
Just 2
And
days
3. Investigation papers.
I think 9/3 your lordship has directed me. Friday I'll get it.
List on day after tomorrow, fresh matters list.
Submission. In this case, Sessions Court has issued the notice to the accused persons to appear. It is at that stage.
Let it be, yes. Friday, fresh matters, day after tomorrow.
36.
And for the accused, my lords,
Hmm.
the petition is filed challenging the notice issued by CCV, my lords.
Notice by?
CCV,
Why?
Central Crime Branch. My lords, the FIR came to be registered on 3/6/2024, my lords. On 30/10/2024, I was arrested and I was released in February 2025.
That's all right. That's not the subject matter here.
Yes, my lord. I'll come to that. My lords, charge sheet came to be filed by Halsurgate Police Station on December 2024, my lords. After 1 year of gap, on 10/11/2025, CCB files a requisition before the trial court for transfer of the case from Halsurgate Police Station to themselves, my lords. On that, before the trial court passes any order, they issue a notice to me, my lords, to appear before them on December.
Which examination is this?
Yes, my lords.
Which examination?
Not a case of examination, my lords.
Come to page 55.
Fake marks cards are being produced. That
Fake
is-
marks cards,
yes,
sorry.
10th marks cards and second year marks.
Anything else?
That's all.
That's all. Dismissed.
No, my lords.
Then?
My contention is that before the trial court passes any orders, they have issued a notice to me. And
Oh, procedure.
yes, ma'am.
175(3). Yeah.
Not just that, my lord. CCV files a requisition seeking transfer
Of what?
of the investigation from Halsurgate police stations to themselves.
You are the accused.
Yes, ma'am.
Which law says you should be heard at that stage?
It's not that my case that I have not been heard.
Then?
Before the trial court has passed any orders, it's posted for orders on 18th of March, my lords.
You are the accused, sir.
Yes, ma'am.
You don't worry about all that.
And my lord,
Investigation stage ಅಲ್ಲಿ who filed? Who is the
No, the case has been transferred to CCB.
CCB transfer ಮಾಡ್ಬೇಕಾದ್ರೆ ನಿಮ್ದೇನು hear ಮಾಡ್ಬೇಕಾಗಿಲ್ಲ.
they themselves have filed an application. before the
No
trial,
problem.
and it's posted for orders. Yes.
No problem.
And one more ground is that
Accused need not be heard at all at these stages.
yes, one more ground. Another ground of mine is that, my lords, the initial charge sheet was filed by Halsurgate police station, my lords. My contention is that further investigation must be done and further charge sheet must be done by the same.
Now, who has done further investigation?
Further investigation, they are seeking by CCB, my lords. The
CCB can do it. It's a specialized agency.
earlier investigation was done by this.
Further
Halsurgate
investigation direct ಮಾಡೋದು.
Further investigation done by them.
The fake marks cards case.
And my lords, the scope of further investigation is also laid down in the charge sheet, my lords. Column number 17 of charge sheet, and there is nothing pending against me, accused number 1, my lords. My statements have
You
been
are
already
accused number 1.
Yes.
Yes, sir. There is everything against you.
Scope has been laid down in column number 17 of
No
charge sheet.
problems. All that is a matter of trial.
Let the trial happen, my lords. I'm just saying that it must be done by Halsurgate police station.
No,
further
sir,
investigation.
nothing.
Or even if further investigation is being done by CCB, I am not required for presence.
No, nothing. You are mixing up the issues. Yes,
You can't say.
there is nothing.
My lords, 2 days time may be given. I need to file some citations, my lords.
On this also. Further investigation by the same agency that I am aware, my judgments are there. It's not that. Now, where further investigation, ಯಾರು ಮಾಡಿದ್ರು, ಯಾವಾಗ ಮಾಡಿದ್ರು, all that you should argue or place record.
2 days time may be.
Friday, fresh matters. Yes.
My lords, Monday or Tuesday.
ಆಯ್ತು, Monday. Yes.
37.
138 proceeding, my lord. 138 proceeding, accused have filed application under section 91 of CRPC.
ಏನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಕ್ಕೆ ಸರ್?
Lord, regarding the, it is my case that I was, as on the date of issuance of the check, I was not in the city, Davangere, my lord. I was in Bangalore, my lord. So to show that I was in Bangalore, my lord, I.
PDR ಬೇಕಾ?
So,
All record details.
tower location.
ಚೆಕ್ ಸೈನ್ ನಿಮ್ದೆ ತಾನೆ?
That is my case that it was given to some other person, that is a witness, my lord.
All that ಅಲ್ಲಿ CDR ಎಲ್ಲ ಇಲ್ಲ.
My lord, other witnesses are also, but the court has taken only one witness out of the other witnesses, my lord.
The petitioner to serve on the counsel who represents the respondent in the trial proceedings. Yes.
My lord, it is posted.
No, stay. Yes. ಅಲ್ಲೇ ಕೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಬೇಕು. Next.
38.
Jagdish sir.
Approval under section 17.
Any objections?
Filed it, my lord.
Not filed.
The filed, my lord.
ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರಾ ಕೊಟ್ಟಿದ್ದಾರಾ then we'll pass orders ಅಷ್ಟೇ order reserved yes ಲೋಕಾಯುಕ್ತ ಏನು ಹೇಳ್ಬೇಕಾಗಿಲ್ಲ ತಾನೆ next
39. My lords, I appear for the petitioner in this matter, my lords. I may be permitted to withdraw the petition, my lords.
thank you just slow ಆಗಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಮೇಡಮ್ yes
My lords, I may be permitted to
disposed as
withdraw.
withdrawn
Yes, my lords, please.
yes
Oblige, my lord.
40.
I'm for the petitioner in this case, my lords. Lords, in the last state of hearing, this honorable court directed me to produce a notification of Bank of Baroda, my lords. I filed it along with a memo, my lords, yesterday.
My lords, I appear for the respondent in this case. You come on record yesterday, my lords.
My lords, page number 3 may be looked into, my lords, of my memo.
ಆಯ್ತು let
Please note that, my lords, I may read, my lords. Please note that checkbook bearing old so-and-so quotes of Vijaya Bank.
CTS check is the wait. List the matter on Monday in the fresh matters list. Look into that RBI circular and come, madam.
Yes.
Please, madam, please, please, my lords.
Grateful.
ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದಾರಾ
My colleague's name is shown, my lords. Santosh.
yes
Grateful.
41.
In this matter, in respect of respondent number 2 minutes, notice is awaited. It's meanwhile minutes,
notice awaited stay ಕೊಟ್ಟಿಲ್ಲಲ್ಲ
put it in.
ಕೊಟ್ಟಿದ್ದೀನಾ?
On 9, please, on 9/2/2026.
Post immediately after service of notice upon the respondent, interim order subsisting would continue till the next date of hearing.
Minutes, I have one more submission. This petition is minutes insofar as minutes accused number 2 and 3. Accused number 5 has also minutes filed one more petition seeking for quashing.
Number ಕೊಡಿ
Number ಕೊಡಿ.
tag the petition along with FR ಇರಬಾರ್ದು
ಇಲ್ಲ, it's compliance. Oblige.
42.
13(1)B ಏನ್ ತಪ್ಪಿದೆ
24 years of check period. Not page 21 from 2003 onwards. 22.
ಏನ್ ಚೆಕ್ ಪೀರಿಯಡ್ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ
2003, not till date. It will come up to 24 years. And all the properties are subject to income tax as well as APR. My wife was a public servant. She has retired.
in the Reddy
Similar
judgment.
to not judgment.
charge sheet ಆಗಿಲ್ಲ ಇನ್ನು
ಇಲ್ಲ.
let them not file
Please.
learned counsel BB Patil is directed to accept notice for the respondent. The respondent shall not file the charge sheet without the leave of the court. Yes. Next. You copy petitioner to serve set of papers upon the aforesaid counsel.
Can I request for a similar order not as in the
ಯಾವ್ದ್ರಲ್ಲಿ
your lordship's order?
service conditions
Not service condition. Not on the same grounds, not of 24 years check period. And when all the properties being subjected to. And statement A is 0.
ನೋಡೋಣ ಬಂದ್ಬಿಡ್ಲಿ ಅವ್ರು ಯಾವಾಗಿಂದ ಇದು
No, this was on last week.
ನೀವೇ ಪೇರ್ ಆಗಿದ್ದ
Please, 3rd February. Otherwise, not all any other service issues will be withheld.
learned counsel of the petitioner submits that but ಒಂದ್ಸರಿ ಅದು ಕೇಳ್ಬಿಟ್ಟು ಮಾಡ್ಲಿಲ್ವಾ ಇದರಲ್ಲಿ
ಇಲ್ಲ ಅದರಲ್ಲೂ that was also not an
ಇದು ನೆನಪಿದೆ
ex parte order, not exactly on the same facts. Because in this case,
ನೀವು ಅಪೇರ್ ಆಗಿದ್ದ
I had only not appeared. That was called.
serve on Friday fresh matters.
Please.
Serve on BB Patil 2 dates.
Please.
ಏನು ಆರ್ಡರ್ ಮಾಡಬೇಡಿ learned counsel with the petitioner to serve on counsel BB Patil forthwith list the matter day after tomorrow in fresh matters.
Friday ಇಲ್ಲ can I request tomorrow?
tomorrow ಆಗ್ಬೋದು
Please. Please.
ಇವತ್ತು ಸರ್ವ್ ಮಾಡಿ ಕರ್ಕೊಂಡು
43.
in the meantime
44.
504 506
dispensation IA may be allowed.
heinous offences will not state. Yes. In the meantime. ನಿಮ್ದಲ್ಲ ಸರ್ ನಿಮ್ದೇನು 183
44.
statement recorded without the mother.
Without the mother, my lord, yes.
Yes. See, we'll take it at 2:30. Yes. ಇಲ್ಲ ಮುಗಿಸ್ಕೊಂಡು. I want to pass an order ಅದಕ್ಕೆ 230.
45.
Please, my lords, I appear for the petitioner, my lords. I may be permitted to appear virtually, my lords.
Yes, sir. What is the problem?
My lords, we have challenged the 35(3) issued to us. The FIR was registered on the complaint of a commercial tax officer working in South Zone, Koramangalam. This complaint agitates before the registration of the FIR is nothing but delegation of powers by the commercial tax officer to the police officers. Now, the registration of the FIR is predicated on the complaint, which agitates that a particular firm by the name Sushil Enterprises obtained a GST registration fraudulently on the basis of forged documents. And after obtainment of that GST registration, they carried out certain transactions.
One moment. This Jagdish, idರಲ್ಲಿ take notice and secure instructions. I will take it on Friday. Learned additional SPP is directed to accept notice for the respondent to secure instructions and papers of investigation and place it before the court. List the matter on Friday. Fresh matter.
In the interim, they may be directed to.
Day after tomorrow, sir. Yes.
Please, my lords. My lords, serial number 47 is also covering the same subject matter.
Yes, 47 also, 45 and 47 same.
So grateful, my lords.
Yes.
For the petitions, my lords, the complaint was lodged only after the petitioners detected vehement discrepancies of 38 lakhs. To escape the liability, my lords, this person who is a scrap dealer files a complaint against me that I have to give him 36 lakhs. Petitioners, this is all the incident happened in Andhra Pradesh, my lords. Nothing to do here.
1 HCGP, 2 emergent notice,
And kindly come to
returnable
page
by 9th. There shall be an interim order of stay of further investigation in 304 of 2025 till then. ಬೇಡವಾ?
Great.
ಮತ್ತೇನೋ ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
57 ಅಲ್ಲಿ only because of the magistrate feeling the FIR got registered.
Correct. ಮೆಸೇಜ್ ಹೋಗ್ಬೇಕು ಅಂತ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ಅಷ್ಟೇ.
Great.
48.
What are the civil suits pending, sir?
I have given minutes.
Kudi.
Plaint has been produced. Blood. Out of 19 vendors, Malada, for 5 people, I am the GPA holder.
Heard the learned senior counsel V. Lakshminarayan appearing for the petitioner. The parties to the list are before the civil court in OS 498 of 2024, and the same relief is sought before the concerned court. This is a civil suit which is an offshoot of earlier civil suits pending between the parties. The petitioner is a GPA holder of the successful of the party who is successful in OS 779 of 2008, which ends in a final decree proceeding. The crime is registered in a petition which is in a proceeding which is seemingly civil in nature in crime number 182 of 2025. In that light, there shall be so and so. Next states 1 HCGP 2 emergent notice.
49.
Jagdish sir, ಇದಕ್ಕೆ ನೀವು ಬನ್ನಿ.
Now your lordship can quash this FIR, my lord, because subsequently since your lordship has earlier FIR has been
ಇದು quash ಮಾಡ್ಬೋದಾ?
We have registered subsequent
ಇದೇ
FIR.
ಸಬ್ಸಿಕ್ವೆಂಟ್ FIR ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ಹೌದು. ಸಬ್ಸಿಕ್ವೆಂಟ್ FIR ಚಾಲೆಂಜ್ ಮಾಡಿರೋದು.
ಅದು quash ಮಾಡಾಯ್ತು.
ಇದು ಸಬ್ಸಿಕ್ವೆಂಟ್
Internally
FIR.
we have obtained a permission.
Permission ತಗೊಂಡಿದ್ದಾರೆ my lords. But the allegation is this, that we have permitted them to consume liquor.
No, Sharat.
No, my lords.
ಒಂದೇ ಒಂದು.
Please.
The boy is 15 years old.
ಹೌದು, ಹೌದು.
You have permitted him to consume alcohol without limit.
My lords.
Now the boy goes out and dies.
My lords, ಇದು
Postmortem report says that he is dead because of consumption of excessive alcohol. ಅದೇ ಹೇಳಿದ್ದವರು.
ಇಲ್ಲ ಹಂಗೆಲ್ಲ ಇಲ್ಲ.
So it is consumption of alcohol.
Consumption of
Postmortem
excessive
report-
alcohol.
postmortem
A
report
life
says-
is lost.
My lords.
How did you permit a 15-year-old boy to enter the restaurant and consume alcohol? How did you serve alcohol?
My answer is this. We have not.
Unless these are strictly implemented,
I completely
none
board
of
on
the
my lords.
places in Bangalore are doing this.
That's I completely.
All
board
of you be ready for prosecution.
on- I completely board on my lords, but that is not the case.
ಸುಮ್ನೆ ಬೋರ್ಡ್ ಅಷ್ಟೇ. Below 18 not allowed. ಒಳಗೋದ್ರೆ above 18 ಯಾರು ಇಲ್ವೇ ಇಲ್ಲ.
That is not the case here, my lords.
ಏನ್
Here-
not the
no,
case here?
Because, my lords,
Hmm.
I don't think my learned SPP will dispute this, my lords. What they have
ಏನು
done is-
ಯಾವ್ದು ಪಬ್ ಇದು?
Lords, Legacy Brewery Company ಅಂತ ಹೇಳಿ.
ನಡೆಸ್ತಾ ಇರೋದು ಯಾವ್ದು ಸರ್? Brewery company,
ಲಿಗೆಸಿ ಬ್ರಿವರಿ
legacy pub.
ಪಬ್ ಅಲ್ಲ ಬ್ರಿವರಿ.
Oh, ಪರವಾಗಿಲ್ಲ, ಎಲ್ಲ ಒಂದೇ.
What has happened is, I have watched personally the entire CCTV footage.
ಏನ್ನ?
CCTV footage,
CCTV.
ಅಷ್ಟು hours ಏನಿದೆ ಅದು. My learned SPP may not dispute this also. We have not served them liquor, my lords. What has happened is, it appears they have brought this from outside and they are
Outside liquor not allowed inside.
correct.
ಆ ಬೋರ್ಡ್ ಮಾತ್ರ ಇದೆ.
My lords, they have
ಎಲ್ಲಾ
not,
ಕಡೆ ಆ ಬೋರ್ಡ್
my lords, each time, my lords, if they had consumed it openly, my lords, we would have taken action. What they have done is,
ಮತ್ತೆ ಬಿಸ್ಲರಿ ಬಾಟಲ್ ಹಾಕೊಂಡು ಕುಡಿದ್ರ?
ಬ್ಯಾಗ್ ತಗೊಂಡ್ ಬಂದಿದ್ದಾರೆ, ವಾಟರ್ ಬಾಟ್ಲು ತಗೊಂಡಿದ್ದಾರೆ, ಬ್ಯಾಗ್ ಕೆಳಗಡೆ ಔಸ್ಕೊಂಡು, ಟೇಬಲ್ ಕೆಳಗಡೆ ಏನೋ ಮಾಡ್ಕೊಂಡು, ಫುಟೇಜ್ ಅಲ್ಲಿ ಇದೆ. I don't think my learned SPP will dispute this.
No.
We have not, my lords, invoice.
I will dispute it.
We have
I will
not,
permit investigation.
we have not, my lords, we have not served liquor, my lords. Your lordship will kindly see.
ಕದ್ದು ಮುಚ್ಚಿ liquor
That is not
ಕುಡಿದಿದೆ.
there in the FIR also. That is not, my lords, in the FIR also, it is not their case that we have served them liquor. That is their
That's a
own.
matter of investigation.
My lords, your lordship will kindly appreciate this. Under section 77 of the.
Where is the
juvenile-
postmortem report? ಕೊಡಿ.
I'll place it.
Postmortem report
Clarification,
only
I placed
says,
it.
my lords, postmortem ಅಲ್ಲಿ liquor consumption excessive ಆಗಿದ್ರಿಂದ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ. ಅವ್ರದ್ದು ಸ್ಟಮಕ್ ನಲ್ಲಿ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ಏನಿದೆ ಅಂತಂದ್ರೆ
Stomach ingredients.
ಅದು postmortem report ಅಲ್ಲಿ ಬಂದಿರೋದು. Rice in the stomach, undigested rice and smell of alcohol. This is what is there.
ಅದು ರೈಸು ಸರಿ ಇಲ್ವಾ ನಿಮ್ಮಲ್ಲಿ?
Actually ಇಲ್ಲಿ ಆನಿಯನ್ ರಿಂಗ್ಸ್ ಅದು ಇದು ತಗೊಂಡಿರೋದು, ರೈಸ್ ಐಟಮ್ ತಗೊಂಡೇ ಇಲ್ಲ ನಮ್ಮ ಬ್ರಿವರಿನಲ್ಲಿ. I don't know where he has gone out and where he has consumed, but in our brewery, we have not served the liquor and we are strictly following the rules. We have put up the board.
The board 18 not allowed ಅಷ್ಟೇ board.
The lordship may kindly see this. My lord, children are there with the family.
ಅದನ್ನೇ ಕೇಳಿದ್ದು 18 not allowed ಅಂತ children ಎಲ್ಲಿ ಬಂದ್ರು?
ಅಲ್ಲ my lords, it's family restaurant ಇದು. ಬೇರೆಯವರೆಲ್ಲ ಇದ್ದಾರೆ. If you may pass on this, my lords, I have annexed this also as a photographs. If your lordship kindly take the photographs, my lords.
No, I don't think so.
ಯಾವ್ದೋ ಬೇರೆ ರೆಸ್ಟೋರೆಂಟ್ ಇದ್ದಂಗಿದೆ ಇದು.
ಇಲ್ಲ my lords.
ಬ್ರಿವರಿ ಲಕ್ಷಣನೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಇದೇ ರೆಸ್ಟೋರೆಂಟ್.
ಬ್ರಿವರಿ ಲಕ್ಷಣ ತಕ್ಷಣ ಗೊತ್ತಾಗುತ್ತೆ.
ಅಲ್ಲಿ ಕೂತಿದಾರಲ್ಲ ಇವರೇ ಹುಡುಗರುಗಳು.
I don't think so. My
These are the
can
students.
take a defense saying that I didn't serve it. When the outside materials are not allowed inside. It
No,
is their responsibility.
outside alcohol not allowed inside.
But this is my lords, they have
Only children below 18
the
allowed
lordship may
inside.
kindly see section 77 of the
Yes, sir.
Act which they have, you know. May request my lords to see
ಕೊಡಿ madam.
77 of the Juvenile Justice Act.
ಇದೆಯಾ? ಕೊಡ್ತಾ ಇರ್ತಾರೆ. ನೀವು ಸರ್ವ್ ಮಾಡಿದಷ್ಟು ಜಲ್ದಿ ಆಗಲ್ಲ.
Serve ಮಾಡಿಲ್ಲ my lords.
ಹೇಳಿ.
Not because I have seen this CCTV.
You have seen serving?
No, CCTV footage personally, my lords. Your lordship may, pen drive is also there. I can pass on the pen drive, my lords.
Pen drive ಬೇಡ sir.
77, my lords. This is the provision which they have invoked. Penalty for giving intoxicating liquor or narcotic drug or psychotropic substance to a child. Whoever gives or causes to be given to any child.
Causes to be given. ಅಂದ್ರೆ ಅವ್ರು ತಗೊಂಡ್ಬಂದು ಬಿಟ್ಟಿದ್ರೆ ಅದು causes to be given.
ಇದು my lords, if ಅದು knowingly we have allowed, my lords.
ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿಲ್ವಾ?
Lords, knowingly if we have allowed, my lords, certainly there is an offense, my lords. I understand. But this has happened, my lords, if your lordship will kindly appreciate this, my lords. You certainly, my lords, we have not served them liquor. That is not the case in the FIR as well as in the complaint. And your lordship, my lords, quashed the FIR on the first instance.
On permission not being
yes,
taken.
certainly, my lords. On that order of your lordship is 5/2/2026. After 1 month, when another matter came up, that was of the staff, my lords. Then they realized that they will have to take permission and invoke this. This they do on 5/3/2026. In a hasty manner, my lords. The magistrate.
What hasty manner? ನಿಮ್ಮಲ್ಲಿ ಕುಡಿದ್ಬಿಟ್ಟು ಒಂದು ಲೈಫ್ ಇಸ್ ಲಾಸ್ಟ್.
My lords,
15 ವರ್ಷದ ಹುಡುಗ he has lost his life.
Lords, he has not drunk here. He has not drunk. We have not served the liquor. He has not drunk here. My lords, they must establish that had the culpa.
ಅದಕ್ಕೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
My lords, your lordship may kindly see, my lords. 77 ಗೆ ಅದು ನಾನ್ ಕಾಗ್ನೈಸಬಲ್ ಅಫೆನ್ಸ್ and 86 ನಲ್ಲಿ ಕ್ಲಾಸಿಫೈ ಮಾಡ್ತಾರೆ. So 77 I am able to establish, my lords, only it is
305 ಹಾಕಕ್ಕೆ ಹೇಳ್ಬಿಡ್ತೀನಿ.
No, we will investigate. We will invoke.
My lords,
We don't know.
that's a different, my lords. If this was the reason for
If you say non cognizable ಇದೆಲ್ಲ ಅಂತ 305. Abetment to suicide.
My lords, Your lordship is well aware, my lords. Abet, my lords, I can only say at this moment, my lords, we have not served him liquor. We
Suicide
have not-
ilwala, abatement, 304.
Lords, we have not knowingly permitted him to consume liquor also. These students, my lords, I can.
Knowingly permitted.
Knowing, we have not.
JJ Act does not say knowingly permits.
Lords, your lordship may kindly take Karnataka Excise Act.
Last time I quashed it on a technical ground.
And, my lords, your
ಬೇಕಂತ ಇವ್ರು ಮಾಡ್ತಾರೆ ಅದನ್ನ.
lords, our post-mortem report ನಲ್ಲಿ, my lords, it is not there.
ಆಲ್ಕೋಹಾಲ್ ಇದೆ ಅಂತಿದ್ಯಾ?
Alcohol.
ಅಲ್ಲಿ ಆಲ್ಕೋಹಾಲ್ ಎಷ್ಟು ಕಂಟೆಂಟ್ ಎಷ್ಟು ಪರ್ಸೆಂಟೇಜ್ ಅಂತ ಪೋಸ್ಟ್ ಮಾರ್ಟಮ್ ಅಲ್ಲಿ ಬರಲ್ಲ.
ಅವ್ರು ಹೇಳೋ ಪ್ರಕಾರ ಇವ್ರು ಆಲ್ಕೋಹಾಲ್ ಕುಡ್ದೆ ಆತ ಸೂಸೈಡ್ ಹಿಡ್ಕೊಂಡ ಅಂತ ಏನೂ ಇಲ್ಲ.
ಅದೇನ್ ರೈಸ್ ಜೊತೆ ಇದೆ ಅಂತ ರೈಸ್ ತಿಂದಾಗಿದೆ ಅಂತನಾ? ಮತ್ತೆ
my lords, your lordship may kindly see, my lords. My lords, if this, my lords, if, my lords, ನಾವಂತೂ ಆಲ್ಕೋಹಾಲ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ. ನಮ್ ಪ್ರಿಮೈಸಸ್ ನಲ್ಲೂ ನಾವು ಅವರಿಗೆ
ಈಗಲೇ ಕದ್ದು ಮುಚ್ಚಿ ಕುಡಿದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ
ನಾವು ಸರ್ವ್ ಮಾಡಿಲ್ಲ my lords. ಅವ್ರು ಎಲ್ಲೋ ಹೊರಗಡೆ ಇಟ್ ಈಸ್ ದೇರ್ lords, ಅವ್ರು ಎಲ್ಲೋ ಹೊರಗಿಂದ ತಂದು ಬ್ಯಾಗ್ ನಲ್ಲಿ ಬಚ್ಚಿಟ್ಕೊಂಡು ವಿತೌಟ್ ನಾಲೆಡ್ಜ್ ಆಫ್ ದಿ ಸ್ಟಾಫ್ ಆಲ್ಸೋ ದೇ ಆರ್ ಡೂಯಿಂಗ್ ಸಮಥಿಂಗ್. ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಪರ್ಚೇಸ್ಡ್, ವಾಟ್ ದೇ have
ಅದು ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ?
lords, what they have purchased is onion rings, onion rings, water bottle, 2 non-veg items, ಒಂದು ಮೋಜಿಟಾ ತರೋದೇನೋ ತಗೊಂಡಿದ್ದಾರೆ, some brewery mocktail. These are the items they have purchased. ಇವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ my lord, some bag, but because I have personally seen that CCTV
ಮತ್ತೆ ಪರ್ಸನಲಿ ಹೇಳಿ,
because I am saying this, my lord, ಇವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ, ಒಬ್ಬ ಹುಡುಗ ಬ್ಯಾಗ್ ತರ್ತಾನೆ, ಸ್ಕೂಲ್ ಬ್ಯಾಗ್. ಆ ಬ್ಯಾಗ್ ಒಳಗಡೆ ಅವ್ರೇನೋ ತಗೊಂತಾರೆ. Then they go behind this table, below the table. Table ಹೋಗ್ತಾರೆ, water ತಗೊಂತಾರೆ ಲೋಟದಲ್ಲಿ, ಏನೋ ಮಾಡ್ತಾರೆ. Something that nature they have done. No, unknowingly to these hotel staff members. ನಮಗೆ ಗೊತ್ತಿದ್ದು ಮಾಡಿರೋದು family restaurant. That is the reason I pointed out, produced the photos also. ಬೇರೆಯವರೆಲ್ಲ ಇದ್ದಾರೆ.
Legacy Brewery family restaurant.
It is a family restaurant, my lords. All family restaurants.
So ಹಾಗಾದ್ರೆ children are allowed.
Children are allowed. It's not.
ಸಾಕ್ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. Children are allowed.
Children are allowed.
ಇಲ್ಲಿವರೆಗೂ ಬಿಡಲ್ಲ ಅಂದ್ರೆ 18 ಒಳಗೆ.
Lords, will not serve liquor to the children. But under the supervision of the adults, children will come to this kind of restaurants. It's a brewery as it is there across the city of Bangalore. May your lordship may kindly see this photograph. ಎರಡನೇ ಟೇಬಲ್ ಅಲ್ಲಿ ಕೂತಿರೋದೇ ಆ ಹುಡುಗರುಗಳು. We don't even know which boy actually. Madam,
they can't take a shelter that they brought it from outside,
because
because they themselves put a board saying that
77 of the Juvenile Justice Act does not get attracted. 36(1)(g) also, the maximum offence is fine. And it also says, my lords, your lordship, the petitioner who is before my lords is the owner of the
province invoke ಮಾಡಲ್ಲ.
ಅಲ್ಲ, but the issue, my lord, now as of today we only know that a child was allowed and alcohol was consumed. Thereafter he died. So we will invoke after investigation we invoke whatever section
148. I'll come back and here. ಅಷ್ಟರಲ್ಲಿ ಏನಾರ ಒಂದು ಸೊಲ್ಯೂಷನ್ ನೋಡಿರಿ.
My lords, we have not served them liquor, my lords. It is not their case also, we have not served them liquor.
Submission.
Invoice all ಇದೆ. We have not, it is not their case, my lords. By this time the investigation, by at registering FIR, my lords, all this happened because of this, my lords. ಏನಾಯ್ತು my lords, actually this boy committed.
2:30 ಇರಿ ಸರ್.
One submission for settlement on Friday, your lordship. Like a POCSO matter.
POCSO matter.
ಹೌದು ಸ್ವಾಮಿ. He 17 years 9 months.
ಅದಕ್ಕೆ
ಅಲ್ಲ ಆಲ್ರೆಡಿ ಮದುವೆ ಆಗಿದೆ.
ಯಾರಿಗೆ?
She is married, victim is married, the complainant.
The
accused living together on Friday, your lordship. Friday 3. Much
Humble submission, my lord.
Your matter is not there.
Date is not being given, my lord. That is in one I am only speedy disposal and another
Friday?
interim order. Friday. Okay, oblige sir.
Trial court fixed date on Friday.
Alcohol.
Trial court fixed date on Friday.
Trial court. Madam, your case or all courts case? Yeah, another one, 5. Yes.
No, trial court fixed date on Friday, not.
For what, sir?
For appearance.
Oh, appear ಆಗಿ. Police station ಅದು.
Civil suit pending ಇದೆ.
No, ಪರವಾಗಿಲ್ಲ.
Lordship yesterday moved
comply.
in
Which one? Why tomorrow? ಎಲ್ಲಿದೆ? ಕೋಲಾರಲ್ಲ? ಓ, ಹಾಗಾದ್ರೆ ಒಂದು 2 weeks ಬಿಟ್ಟು ತಗೊಳ್ಳೋಣ ಬಿಡಿ.
Lordship yesterday moved in
ಸಿಲ್ವರ್. ಇವರು ಸಿಲ್ವರ್ ಬಂದಿಲ್ವಾ ಮೇಡಮ್?
not listed.
ನಾಳೆ ಹಾಕ್ಸೋಣ.
Sir, Lordship I am
ಇವತ್ತು ಕೊಡಕ್ಕಾಗಲ್ಲ ಸಿಲ್ವರ್, ನಾಳೆನೆ.
End of the list, Lordship, please.
Friday ಮೇಲೆ silver.
Friday.
Lordship, please, end of list.
End of the list pending matter, no? Yes. ಏನು ನಿಮ್ದಲ್ಲ ತಾಳಿ ಪಕ್ಕ
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್.
ಯಾವ್ದು ನೀವು ಪೆಟಿಷನರ?
ಇಲ್ಲ ಸರ್.
ಹ?
PCR ಸರ್.
ಅಡ್ವೊಕೇಟ್ ಇಲ್ವಾ ನಿಮ್ಮ ಅಡ್ವೊಕೇಟು?
ಬಂದಿದ್ರು ಸರ್, ಅವರು ಸಿವಿಲ್ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬಿಟ್ರು ಸರ್.
ಅವ್ರು ಬರಕ್ ಹೇಳಿ ಮಧ್ಯಾಹ್ನ
ಮಧ್ಯಾಹ್ನ
ಬರಕ್ ಹೇಳಿ.
My lord, serial number.
ನೋ ಮಂಡೇ.
My lord, serial number 83, my lord. It's for compromise.
ಇಟ್ಸ್ ಫಾರ್
83, first list.
ಸೆಟಲ್ಮೆಂಟ್
Settlement.
4
Monday.
4 PM.
My lord, may I request on
ಯಾವತ್ ಮಂಡೇ ಬೇಕಾ? ಮಂಡೇ 4 PM.
Grateful.
ಅಯ್ಯೋ ಊಟ ಮಾಡಕ್ ಬಿಡಿ ಸರ್.
Sir, boss.
ಮುಂದಿನ ನಿಲ್ದಾಣ ಅಯ್ಯಪ್ಪನಹಳ್ಳಿ. Next station is ಅಯ್ಯಪ್ಪನಹಳ್ಳಿ. ಈಗ ಅಯ್ಯಪ್ಪನಹಳ್ಳಿಗೆ ತಲುಪಲು ವಾಹನಗಳು ಎಡದ ಬಗ್ಗೆ ಗಮನ ಇಡಿ. ರೈಲು ಈಗ ಬೆಳ್ಳಿಗಾನಹಳ್ಳಿಗೆ ತಲುಪಲಿದೆ. ಎಡಕ್ಕೆ ತೆರೆಯಿರಿ. ರೈಲು ಇಳಿಯುವ ಮುನ್ನ ಅಂತರದ ಬಗ್ಗೆ ಗಮನವಿದೆ.
सर क्या कोलार को रूट
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವ ವರ್ಷದ್ದು? ಬಿಡಿ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದೆ. ಏನು ಒಫೆನ್ಸ್ ಏನು? ಒಫೆನ್ಸ್ ಅಷ್ಟಕ್ಕೆ ಸ್ಟೇ ಆಗಿದೆಯಾ? ಅಷ್ಟಕ್ಕೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಬೇಕಾ? ಆಯ್ತು ಸರ್, ಫೈನ್. ಆಯ್ತು, ಎಸ್. ಹಾಂ, ಕೊಡಿ, ಇಸ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. ಅದು 200 ಮ್ಯಾಟರ್ಸ್ ಬ್ಯಾಚ್ ಇದೆ, ಅದಕ್ಕೆ ಜೊತೆಗೆ. ಹಾಂ ಹಾಂ, ನಾನು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದು. ಆಯ್ತು, ಕರೀತು ತಾಳಿ ಕೊಡ್ತೀನಿ, ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಯಾವುದು ಪಾಲಿಸಿ ಮಾಡ್ತೀನಿ, ಕರ್ಕೊಡಿ. ರೆಡಿ ಇದ್ದಾರಾ? ಇನ್ನೊಂದು ದಿನ ಆಗುತ್ತಾ? ಒಂದು ನಿಮಿಷ. ವೈಶ್ ಶಾಂತಿ ಭೂಷಣ್ ಮೀಟಿಂಗ್. ಹಾಂ ಹಾಂ, ಐ ಟೇಕ್ ಇಟ್. 2:30 ಅಂತಿಲ್ಲಲ್ಲ, ಐ ಟೇಕ್ ಇಟ್. ವೇಟ್ ಪ್ಲೀಸ್, ನೀವು ಕೆಲಸ ಮಾಡಿ, 3:30 ಬನ್ನಿ. ಐ ಟೇಕ್ ಇಟ್ ಡೆಫಿನೆಟ್ಲಿ. ಅದರಲ್ಲಿ ಬ್ಯಾಂಕ್ಸ್ ಆಲ್ಸೋ ಐ ವಾಂಟ್. ಬರಲಿ, ನೀವು ಬನ್ನಿ. ಹಾಂ, ಫ್ರಾನ್ಸಿಸ್ ಹಿಯರ್. ಫ್ರಾನ್ಸಿಸ್, ಕಮ್ ಅಟ್ 3:30. ಹಾಂ ಹಾಂ, ಆಯ್ತು. ಅಲ್ಲಿ ಪಾಸ್ ಸಮ್ ಆರ್ಡರ್. ವೆಯ್ಟ್, ಈಗಲೇ ಏನು ಬೇಡ. ಹಾಂ, ವೆಯ್ಟ್. ಹೌದು, ಅದು ಏನಾರು ಹಾಕ್ಕೊಳ್ಳಿ, ಆರ್ಡರ್ ಅಂತೂ ಮಾಡೋಣ. CBI ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿದ್ವಿ.
ಇಲ್ಲ, ಅದನ್ನು objection ಆಗ್ಬೇಕು. We have collected all the documents in this matter. My lord, IVR.
No, bank will be helping to cleanse the system. Don't.
Absolutely no, my lord. I am permitted to file objection.
I am not stopping you from filing objections at all. This digital arrest case cannot. This anyway. 3:30 month. But come at 3:30. ಎಷ್ಟಿದೆ? ಹಾಂ, ಏನದು? ಅಯ್ಯೋ ಮೇಡಮ್, ಹಾಂ.
Lordships asked all of us to complete, but Mr. Vikram Hulgod is held up in the election.
That is why today election not possible. 17th will take it, Tuesday. ಎಲ್ಲರಿಗೂ ಹೇಳಿಬಿಡಿ, ರೂಬೇನ್ಗೆ ಹೇಳಿ.
Please,
Madam, ASG.
he appears for me also, I'll inform.
Huh?
He appears for me also, I'll inform.
Yaru?
Cradle, Ruben, sir.
Rubens.
I'll
ASG inform ಮಾಡಿ 17th will take it at the same time at 2:30. So it gets over. ಇವತ್ತು election ಇದೆ ಬೇಡ.
No, Mr. Ruilgold is overseeing, my lord.
That is why.
Tell your lordship upfront before.
That's why, yes. Tuesday.
Great.
Possible change ಇದ್ರೆ ಹೇಳಿ ನನಗೆ.
Anyway, we'll complete on that day, my lord. Your lordships.
I'll keep him informed.
ನಿಮ್ಗೇನು ತೊಂದರೆ ಇಲ್ಲ.
ಅವತ್ತಿನ ದಿನ mostly
last
they may not wind up on that day, minutes. They may probably take.
It may not wind up on that.
We
You
may
wind up
complete,
you
we
wind
filed
up
our
your
submissions
side.
also, my lord. The notes that your lordships had asked us tendered, that's been tendered.
ಅವ್ರು wind up ಮಾಡ್ತಾರೆ.
If we don't, we will be wound up. Otherwise, we have to complete.
Tuesday 2:30 only.
2:30.
Interim order.
Interim orders ಏನಿದೆ ಕಂಟಿನ್ಯೂ ಆಗಲಿ ಮೇಡಮ್. ಸೇಮ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ 17th at 2:30 PM. Because the elections today. ಎಲ್ಲಿ ಅವರು ಆಲ್ ಕಾಲ್ ಬನ್ನಿ. Yes, Jagdish sir.
Your lordship may kindly take page 55.
Postmortem report.
ಕೊಡಿ ಕೊಡಿ.
Smell of alcohol found. Your lordship,
There,
next.
wound position, conditions, subject. Where do I get that?
Next page, my lord, the last column, my lord. Stomach contents.
Oh, contains smell of alcohol present.
Now, this has been been sent for further examination, FSL examination. That will determine the.
But ಇದು contrary to law ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ ಅದು.
No, there's no contrary to law, my lord.
That's all I'll point out. Your lordship may kindly take page 50.
Now you leave this, come on merits.
Yes, minutes, on merits. Your lordship may kindly take page 55 minutes.
Page
55. Annexure L. What's the, your lordship got?
55.
These are the items which were served to the
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬನ್ನಿ ಅಂದ್ರೆ ಗೀ ರೋಸ್ಟ್ ಚಿಕನ್ ಕೊಟ್ಟಿದೀವಿ ಅಂತ ತೋರ್ಸ್ತಾನೆ.
ಅಲ್ಲಿ ಬರೋದಕ್ಕಿಂತ ಮುಂಚೆ because no, my lord, your lordship.
ನಾನು ಏನೋ ಲೀಗಲ್ ಪಾಯಿಂಟ್ ಹೇಳ್ತೀರಾ ಅಂದ್ರೆ ಗೀ ರೋಸ್ಟ್ ಚಿಕನ್ ಆನಿಯನ್ ರಿಂಗ್
ಹೇಳಿ
ಕೊಟ್ಟಿದ್ದೀವಿ.
ಲೀಗಲ್ ಪಾಯಿಂಟ್ ಗೆ ಬರ್ತೀನಿ. Then your lordship may kindly take page 53.
ಬೆಳಗ್ಗೆ ಬರೀ ಆನಿಯನ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಈಗ ಬರೀ ಚಿಕನ್ ಗೀ ರೋಸ್ಟ್ ಕೊಟ್ಟಿದ್ದೀವಿ.
ಅದನ್ನು ಹೇಳ್ದೆ. Your lordship may kindly take page 53. This is a newly established family restaurant. One ತಿಂಗಳು
newly established family restaurant.
Family restaurant. So, and if your lordship.
Brewery ಅಂದ್ರೆ
brewery, family restaurant.
brewery, all right.
If your lordship takes 1 minute.
ಬೇಡ ಬೇಡ.
Now
your
photo
ಸಾಕು.
This is what has happened. Your lordship may now take the FIR minutes. Page 17. Relevant paragraph, page 19, relevant portion. Third paragraph from top, unnumbered third paragraph. ಸದರಿ ಹುಡುಗರು ಅಪ್ರಾಪ್ತ ಬಾಲಕರಾಗಿದ್ದು ಅವರುಗಳ ವಯಸ್ಸಿನ ಬಗ್ಗೆ ಖಚಿತಪಡಿಸಿಕೊಳ್ಳದೆ ಅವರಿಗೆ ಮದ್ಯಪಾನ ಧೂಮಪಾನ ಮಾಡಲು ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟು. So their case is that we have enabled them.
That's what I told you.
Enabled them. It's not that we have served the liquor or sold the liquor or given the liquor, even according to them. And that corresponds with the photographs as well as the invoice which I produced. Now your lordship may kindly take the order passed by the learned magistrate, granting permission. Page 24 minutes. The first portion of the order is about the liberty which was granted by this honorable court.
Correct.
Therefore, they have come before. The second portion, the averments of the first information statement prima facie constitute the necessary ingredients under section 36(1) of Karnataka Excise Act and 77 of the JJ Act. 36(1) ಅಲ್ಲಿ ಯಾವುದು 36(1)G actually ಅದು ಕೂಡ ಅವರು ಅಬ್ಸರ್ವ್ ಮಾಡಿಲ್ಲ. Then your lordship will kindly see.
Non-application of mind.
Your lordship will kindly see. According to the first information statement, the accused persons being license holder against the conditions of the license sells liquors to a child who is under 18 years of age. Yar case adu, sells liquor. Nobody's case.
Magistrate's case.
Therefore, my lord, there is complete non-application of your lordship in plethora of judgments as laid down that there must be judicious application of mind. The liberty being granted by this honorable court itself is not a application of mind by the magistrate.
My order.
ಅಲ್ಲ, ತಾವು ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದ್ದಲ್ಲ ಅದೊಂದೇ ಅಪ್ಲಿಕೇಶನ್ ಆಫ್ ಮೈಂಡ್ ಅವ್ರ ಪ್ರಕಾರವಾಗಿ. ಇಂಡಿಪೆಂಡೆಂಟ್ ಆಫ್ ದಟ್ there must be some judicial application of mind. There is absolutely no judicious application of mind. Then your lordship may kindly see the complaint which is annexure B. Look, this incident has happened on 31/1/2026.
ಹೌದು.
Photographs ಅಲ್ಲಿ
31/1/2026.
31/1/2026. Photographs ಅಲ್ಲಿ ಇರೋ ಡೇಟು ಫಸ್ಟ್ FIR
ಅಲ್ಲ, ಇದು ಪೇರೆಂಟ್ಸ್ ಏನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ.
Parents of the deceased boy
Parents have left Bangalore.
left Bangalore and left behind legacy.
My lords, annexure B. This complaint, earlier complaint nalli one FIR agittu which your lordship quashed. If at all they had to take permission, it was based on the old complaint. They had to register NCR, then send the informant to the magistrate. They cannot create a fresh complaint. Annexure B, they have created one more complaint. 4/3/2026.
No, it is only Nivedane.
But this is the complaint.
Nivedane to the court.
Not to the court. Nivedana to the court is something else. I have to point out. Nivedana to the court is at annexure J. This is the Nivedana to court, which is at page 59. This is the Nivedana to court. This annexure B, they have created a fresh complaint, and your lordship will see in the FIR. On the basis of this fresh complaint, Thaneyalli Vartamana ಸ್ವೀಕರಿಸಿದ ದಿನಾಂಕ 5/3/2026, because after the magistrate grants permission. And this is the complaint which was sent along with this requisition. They cannot create a fresh complaint. Earlier there is a complaint. FIR is there. Your lordship quashed that. What they have to do on the old complaint, because your lordship held that there is non-compliance of the procedure under 155(2), which corresponds to 174(2) of the BNSS Act. What they have to do on the old complaint, quote your lordship order that quashed the FIR, registered NCR, send the informant to the judicial magistrate. And judicial magistrate, my lords, thereafter he will have to make an endorsement on the requisition, whether he received this information personally or through post. Post athwa muddam. That is what this honorable, the coordinate bench of this honorable court, in the case of Vageppa Gurulingappa, your lordship has also followed this judgment while on a different parameter, my lords. Lords, criminal rules of practice is quoted, and it says that on receipt of this requisition, the learned magistrate will have to make an endorsement on the requisition, whether he received it personally or through muddam. Muddam or through post. There is no such endorsement here.
ನಿಮ್ಮ ಇದರಲ್ಲಿ ಬೋರ್ಡ್ ಇದೆಯಾ? ಲಿಕ್ಕರ್ ವಿಲ್ ನಾಟ್ ಬಿ ಸರ್ವ್ಡ್. ಎಲ್ಲಿದೆ?
Liquor will not be served on the board.
ಯಾರಿಗೂ ಅಲ್ಲ.
ಅಲ್ಲ, 20 under for the students below the age of 21.
ಸ್ಟೂಡೆಂಟ್ಸ್ ಮಾತ್ರನಾ?
For the those who are aged less than 20 years. Lords, ಅದು
ಇನ್ಸಿಡೆಂಟ್ ಆದ್ಮೇಲೆ ಹಾಕಿದ್ರ?
ಇಲ್ಲ ಇಲ್ಲ, ಮುಂಚೆಯಿಂದಾನೆ. If your lordship see this video for a moment, my lord, ಅಲ್ಲಿ ಮಕ್ಕಳು ಬೇರೆಯವರೆಲ್ಲ ಬರ್ತ್ಡೇ ಕೇಕ್ ಕಟ್ ಮಾಡ್ಕೊಂತಿದ್ದಾರೆ. Your lordship will kindly see. It's not, we have not, and now also it's not my case of the learned friend that we have served. We have sold this liquor. It's a bad incident which has transpired, my lords. Unfortunately, it's a newly established restaurant. And my lords, there must be some culpa. They must show negligent. They were well aware that the students are consuming. In spite of it, they have allowed them. That is not their case, my lords. And now the judicial magistrate goes beyond that and says, we have served the liquor.
ಮತ್ತೆ ಅವ್ರೇನ್ ಬಿಸ್ಲರಿ ಬಾಟಲ್ ಕುಡಿತಾ ಇದ್ರ?
ಎರಡೇ ನಿಮಿಷ ನೋಡಿದ್ರೆ
ನೀವ್ ಹೇಳದ್ ನೋಡಿದ್ರೆ ಬಿಸ್ಲರಿ ವಾಟರ್ ವಿತ್ ಆಡೆಡ್ ಮಿನರಲ್ಸ್.
ಅಲ್ಲ, ಇದಾದ್ಮೇಲೆ your lordship kindly appreciate this also. If the students are able to, are competent of doing this, ಅವ್ರು ಹೊರಗೆ ಹೋಗಿ ಮತ್ತೆಲ್ಲಿ ತಗೊಂಡು ಇನ್ನೆಲ್ಲಿ ಕುಡಿದಿರೋ ಅದೆಲ್ಲ ಏನು ಗೊತ್ತಾಗಲ್ಲ. ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು ಆಫ್ಟರ್ 3 hours.
ನಿಮ್ಮಲ್ಲಿ ಕುಡಿದು ಮನೆಗೆ ಹೋಗಿದಾರಲ್ಲ, ಅದು ಪುಣ್ಯ. ಹೊರಗೋಗಿ ಇನ್ನೊಂದು ಕುಡಿಯೋ ಕಡೆ ಏನ್ ಪ್ರಮೇಯನೇ ಇರ್ಲಿಲ್ಲ.
ಇಲ್ಲಂತೂ ನಾವು ಸರ್ವ್ ಮಾಡಿಲ್ಲ. And your lordship will kindly see the petitioner, my lords, is the partner of the brewery.
Company is not made a party na?
Not that grown.
ಆಮೇಲೆ
saying 36(1) ನಲ್ಲಿ, if at all they have to do on the staff members who are present at the premises.
ಅಯ್ಯೋ, ಸ್ಟಾಫ್ ನ ಬಿಟ್ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ ನೀವು, ಹಿಂಗಾದ್ರೆ ಹೆಂಗೆ? ಅವ್ರು ಯಾರು
Lords,
ಸ್ಟಾಫ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
the lordship sees this for a moment, my lords.
Why are you insisting on video watching? Yes.
This will show that we have not served them the liquor, my lords.
Sir, one life is lost.
Lords.
ಯಾವ್ದು 15 ವರ್ಷದ ಹುಡುಗನಿಗೆ ಸಿಕ್ಕಾಬಿಟ್ಟು
Lords,
ಕುಡಿಯಕ್
that is-
ಬಿಟ್ಬಿಟ್ಟು.
Lords, we have not served them the liquor. Your lordship will kindly see.
No, not only you, Jagdish sir, not only you. I think the commissioner should issue a strict direction
Lords,
to all the breweries or pubs in Bangalore. If they leave anybody without checking the Aadhaar card below 18 years, license will be cancelled. I'm going to write in this order. Anyway, if I may allow you, I may allow the petition, but this direction will be there.
Please, my lords. Yeah, I'm.
I may and ಹೇಳಿದ್ದು.
I bow down with your lordship because that's why your election is required. Apart from this case, my lords.
No, those
I also
directions,
feel
those
that there
directions
must
are
be
already.
some, because students, my lords, our brewery owners have won some responsibility, as your lordship is saying. Strict guidelines ಬೇಕು. ಇದೆ ಅದನ್ನ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡೋದಕ್ಕೆ ಈ ಕೋರ್ಟ್ ಇಂದ ಡೈರೆಕ್ಷನ್ಸ್ ಬೇಕು.
No, and
But in this case, my lords, your lordship may kindly consider. There is complete non-application of mine by the judicial magistrate.
And this case, my lord, they cannot say, we just put a board, we will not serve, and allow people to consume whatever they want to consume inside.
ಅದಕ್ಕೆ ಹೇಳಿದ್ದು ಬೋರ್ಡ್ ಅಲ್ಲಿ below 18 not allowed. ಒಳಗಡೆ only 18.
Only 18
Only below 18 allowed. Above 18 ಇಲ್ವೇ ಇಲ್ಲ ಯಾರು.
Correct. And second, my lord, my learned friends
ನಿಮ್ದು
argument,
ಬಿಡಿ. ಇವ್ರು ಕೇಳಿದ್ರೆ ಪೆನ್ ಡ್ರೈವ್ ನೋಡಿ ಅಂತಾರೆ.
my learned friends argument that magistrate is not applied and he has not made an endorsement. Your lordship may see annexure J, page 59. Magistrate says received on 5/3/2026 at 12 PM. And thereafter in the order sheet also, magistrate say RR Nagar police submitted a requisition, received requisition along with acknowledgement of NC 79 of 2016 and first information report through WPC so and so. At so and so open code. SH RR Nagar has referred the first information, it is request to first information has been made so and so. I have gone through the content of the requisition, acknowledgement, NC number so and first information statement. Along with the said document, first information, produce a copy of the order of the Honorable High Court. So all these things is referred. It's not that he mechanically passed it.
No, pass ಮಾಡಿರೋದು. His argument is there could not have been another complaint when only the permission granted was quashed.
That's fair, my lord. Your lordship is the NC 79 of 2016.
NC ಮಾಡಿದ್ದೀರಾ?
ಹೌದು. All these things are there. All these things were produced.
Anyway, let me see whether it's application of mind or otherwise. But that direction should be there.
It should be. And
Is
the
that
directions, my lord,
tomorrow?
not only that they put a board, they should make sure that the children do not consume. It is their responsibility. They can't wash away their hand.
So far as the direction is concerned, my lords.
No, that you can't come in the way.
No, I'm saying.
It's for your good as well. Yes. Reserved.
Lords,
The petition response, there shall be an interim order of stay of all further investigation qua the petitioner till the next date.
Just 2 days.
Reserve ಮಾಡಿ. Till the next date of hearing. ಇಲ್ಲ ಲೈಸೆನ್ಸ್ ಕ್ಯಾನ್ಸಲ್ ಮಾಡ್ಬಿಡ್ತೀರಾ? ಮತ್ತೆ ಅವ್ರು ಯಾರು ಕುಡಿಯಕ್ಕೆ ಕೊಡ್ತಾರೆ?
ಹುಡುಗರು ಕೊಡದೇ ಇದ್ರೆ ಸಾಕು.
ಆ?
ಚಿಕ್ಕ ಮಕ್ಕಳು ಕೊಡದೇ ಇದ್ರೆ.
Yes, opened this after obtaining huge loans.
Huge loans.
Loan ಮಾಡಿ
ಮಕ್ಕಳು ಕೊಡಬಾರ್ದಾಗಿತ್ತು ಸರ್.
Yes, no. Yes. Lords, if for the benefit of your lordship, you may pass
ಏನು?
a pen drive.
ಬೇಡ. You don't worry about court's benefit. We'll pass orders. Yes.
I appear for the petitioner in this case, my lord. Petitioner is a fintech company.
One moment, Pramod sir.
My lord, the complainant, second respondent, my lord, invests in an app of an entity called Proceedings. My lord, who I don't have an account with, I have not had any transaction with. And my lord, she files a complaint that she invested around 1.5 crore rupees through this app. And my lord, that money was then transferred to accounts of Bank of Baroda, Yes Bank, another cooperative bank in Maharashtra, etc. Again, my lords, Axis Bank is not mentioned. I am not mentioned in the complaint. The police.
Who are you?
My lords, I am a fintech company, my lords.
Viona.
Yes, my lords, like your lordship, my lords, same Razor Pay, Phone Pay, my lords, I am in exactly the same position. A notice is issued to me by the police. In fact, issued to my bank, my lords, with whom I maintain a current account, saying that my account should be frozen. And my lords, that there should be a lien marked on account. But my lords,
freeze ಮಾಡಿದಾರಾ?
My lords, they have been pushing to freeze it, my lords. The lien has been marked.
All right. Lien has been marked of what amount?
Yes, my lords, it has been marked.
1.5 crores.
No, my lords, 2 transactions, my lords, because in the notice.
What is the amount?
It is, my lords, around
6,37,274.
ಎಷ್ಟು 1?
1 CR
CR ಅಂದ್ರೆ?
No, no, no. It
1
is
crore
crore.
lakhs 37,274 rupees.
1 crore 37 lakhs?
no, Manoj.
36
If I may
lakhs
just explain,
37.
Manoj, the notice is at page 32.
Page?
32, my lord. Bank account, my lords, of mine, because this notice is a generic notice, not only relating to my bank account, but probably, my lords, bank accounts of others also. My account, my lord,
ನಿಮ್ದು ಯಾವುದು? ವಿಯಾನೋ ಅಕೌಂಟ್
item number
ಎಲ್ಲಿದೆ?
3 and 6. Item number 3 and 6 is 2.86 lakhs and 6.36 lakhs.
ಅಷ್ಟೇನಾ?
And why, my lords, my name is mentioned? What is my nexus to this, my lords? And I'm not even mentioned in the complaint. If the court could kindly see, my lords, annexure F is the FIR, and the complaint is extracted at page 49. My lords, I'm not even accused. The complaint, my lord, which is extracted at page 50, does not even have any mention of my name. The notice also to the bank does not explain what my role is. In fact, my lords, this prox trend through which, my lords, this complainant had invested, my lords, does not even hold an account with me. In fact,
No,
page 50.
if you're somebody like Razorpay, nobody need to hold an account. You're a payment intermediary
And therefore, my lords, in
or
the
a payment
notice,
gateway, whatever it is.
even in the notice, my lords, they don't indicate that I have processed any transactions or any money has come into my account because of the transactions that were processed. My lords, the notice is as bald as it could be. Kindly see, my lords, with reference to the above, page 32, my lords, the case has been registered in Cybercrime Police Station. In this regard, you are hereby directed to furnish the following so and so. And my lords, the subject is to provide the customer details, debit freeze the account. And
You have the records?
Please.
ಕೊಡಿ.
In this lordship, your ಮೇಲೆ 16 cases NCR bail
ಆಯ್ತು, ಕೊಡಿ.
register ಆಗಿದೆ.
We'll take it tomorrow. They don't freeze the account till then. List the matter tomorrow. ಆಗುತ್ತಲ್ಲ ಮೇಡಮ್ ನಾಳೆ? In the fresh matters list. The account of the petitioner shall not be debit frozen until the next date. Heard the learned senior counsel Pramod Nair appearing for the petitioner. ಆಮೇಲೆ learned records ಕೊಟ್ರಾ?
ಕೊಟ್ಟಿದ್ದೀನಿ.
Yes. ಕೊಡಿ. ಇದಕ್ಕೆ ಹಾಕ್ಬಿಟ್ಟು ಕೊಡಿ. Tomorrow we'll take it, sir.
My lord, I need the pardon, my lord. I am appearing through.
Where are you?
Kolar, my lord.
ಇದು ಸೈಬರ್.
This by virtue of my house, by virtue of annexure FE, my lords, at page number 50, upon my complaint. Upon my complaint, my lord, the acknowledgement, my lord, regarding some unknown person hacked complainant's S-Bank account number, so and so, made fraudulent transaction by using that account without complainant knowledge. Since then, account stands non-operative, my lords. After that, my lords, this complaint comes to be registered on dated 27/5/2024. However, my lords, the kingpin, my lords, who has hacked my account has been already arrested, my lords, and obtained a bail.
Yes, you take notice. The learned additional SPP is directed to accept notice, secure instructions, and make submissions on the strength of the records that are found. Records would mean the papers of investigation. No coercive steps or precipitative action shall be taken against the petitioner till the next day.
Meanwhile, my lord, my lords, meanwhile, I have served the notice, my lords, which is at annexure B, my lords, to come and appear, my lords. After me, my lords, obtaining bail.
ಈಗ ಹೇಳಿದ್ನಲ್ಲ, not to precipitate or take coercive. Yes, next.
Annexure B ಮಾತ್ರ till next date stay ಮಾಡಿದ್ರೆ
ಪರವಾಗಿಲ್ಲ, next date. Yes, next.
Grateful, my lords.
They'll not take any action. Yes.
Grateful, man. Grateful.
Where is the respondent?
In court 4.
Huh?
Court 4.
Court 4.
She's in court 4. It's busy with the case.
Sorry?
Respondent advocate busy in court 4.
Oh, you went there and came.
She messaged me.
All right, pass over.
53. Petitioner in this case.
There is a civil suit pending between the parties, my lord, same parties. And one of the, my lords, accused, my lords, have filed a suit for a declaration, my lords, in the year 2019, my lords. Sorry, 2022, my lords. To overcome the same, my lords, the complainant, my lords, has lodged the complaint, my lords. There is a transaction between the complainant and accused, my lords. With regard to the same, my lords,
Why you have not argued for all these days before the other courts?
No, my lords, not.
Yeah, no. Order sheet is bigger than the petition. What civil suit?
Lord, civil suit.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ.
ಯಾಕೆ ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, ಫಸ್ಟ್ ಅದು ನಂಗೆ ಕಾಪಿ ಸಿಕ್ಕಿದ್ದಿಲ್ಲ ಸರ್. There is also an interim order, my lords, by the
Interim order? Trial court.
Please, my lords, in the civil suit. Notice has been issued by this honorable court, my lords, to the complainant, and he is now in unrepresented.
Notice ಆಗೇ ಇಲ್ಲ.
ಇಲ್ಲ, ಆಗಿದೆ ಸ್ವಾಮಿ, unrepresented, ಸರ್ವ್ಡ್.
ಇದೆ notice ಆಗಿರೋದು. That's what I'm searching.
Oh, my lords.
You 2024 ಲಿ my order.
Please, my lords.
Secure investigation charge sheet ಆಗಿಲ್ವಾ ಇನ್ನು?
ಆಗಿಲ್ಲ.
ಎಲ್ಲಿ papers?
Take the instruction. Charge sheet ಇನ್ನು.
Because, my lords, there is a direction from this honorable court, my lords, do not file the charge sheet without leave of the court.
Get the papers of investigation. Yes, the learned HCGP to secure the papers of investigation and place it before the court on the next date, same next Wednesday.
Right.
Same stage, yes.
I appear in this case, my lord.
Lords, in this case, I am for the respondent number 3, my lords. I'm the husband of the deceased in this matter. Okay?
306, huh?
Registered.
My lords, I press for
There is the zipline
file objections and press.
activity which was conducted not by the general trails thing, where the zipline snatched and the victim.
Oh, the zipline, ನಾನು ಅಷ್ಟೇ ಕೊಟ್ಟಿರ್ಬೇಕು.
ನೀವೇ ಕೊಟ್ಟಿದ್ರು.
Zipline
File an objection.
in that resort.
Resort.
Yes, yes.
2024 da? Yes.
Yes, bro.
File our objections, my lords.
ಇನ್ನೂ ಹಾಕಿಲ್ವಾ?
My lords, last time ನಾವು impleading application allow ಆಗಿದ್ದೆ last year.
ಓ ಯಾಕೆ ಇದು ಪಾರ್ಟಿ ಮಾಡಿರಲಿಲ್ಲ ಇವ್ರನ್ನ?
ಪಾರ್ಟಿ ಮಾಡಿದ್ವಿ.
ಮಾಡಿರ್ಲಿಲ್ಲ.
ವೆಕೇಶನ್
ಮಾಡಿದ್ವಿ ಮತ್ತೆ ಆಮೇಲೆ
ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ನೀವೇ ಹಾಕಿರೋದಾ? ಸ್ಟೇಟ್ ಹಾಕಿರೋದಾ?
State ಹಾಕಿರೋದು.
State.
ಆಯ್ತು, ಒಂದು ಡೇಟ್ ಕೊಡ್ತೀನಿ, ಅವತ್ತು ಮುಗಿಸಿ.
Please, my lords.
17, 24 ಅಲ್ಲ, 18th.
Grateful.
Same stage. Objections if any by then.
Interim order maybe.
Interim order. Yes, interim order continues. Next.
Yes. Grateful.
55.
Appearing for the petitioners, my lords. Lords, seeking for speedy disposal.
Speedy disposal.
Yes.
No, no, no.
What's the, ಯಾವ ವರ್ಷದ್ದು madam?
That's the.
16.
Yes, my lords.
The petitioner is before this court seeking the following prayer. Heard, so and so. A private complaint comes to be registered in PCR 480 of 2016 and the matter is referred for investigation, which becomes a crime in crime number 110 of 2016 before the second respondent police. The police, after investigation, file a charge sheet on 25/5/2021 for offences punishable under section 406, 420, 465, 468, 471 and 506 of the IPC. The concerned court takes cognizance of the offence and the matter is pending before the concerned court as CC 1994 of 2024. In the light of the, you are the complainant, Allah?
Yes, my lords.
In the
8
light of
years.
the prayer being innocuous and the matter of the year 2016, I deem it appropriate to direct the concerned court to dispose the subject CC with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
Grateful, my lords. Yes.
Offense,
56.
406, 465, 420.
Appear for petition. The offense section 419, 500.
Huh?
This petition arrived in accused number 1.
Mm.
There is no any single, the individual overtax against this petitioner.
On the last date,
Even the complaint government also.
I was directed to produce the documents which are produced along with the private complaint.
Ill hakilva?
I will file it.
Kodi.
Lord, there is one snack, my lord. My lord's judgment only covered by my lord's judgment.
Yavudakke?
Have to be remanded. Offense of defamation.
Hmm.
Complaint of defamation, my lord. My lord's order in
ಏನೇನ್ ತಗೊಂಡೆ?
petition 7806 of
ಇಲ್ಲ.
2025.
They have referred it
cognizance-
for investigation.
No, my lord, the cognizance is taken before hearing the accused. My lords have passed a direction that
ಇದು
under
25, 24 ಇದು.
24, 204 procedurally, my lord may kindly look into that memo,
ಯಾವ
My
ಜಡ್ಮೆಂಟ್ ಕೊಡಿ?
please.
This is pre BNSS ಅಲ್ವಾ?
Pre-BNSS, my lord,
ಹಾ.
204 also,
204 ಅಲ್ಲಿ ಬೇಕು. I have passed an order, is it?
para 10, my lord. Just bringing to my lords, my lord, if it has to be heard on merits, I'm
We'll see. Yes.
pre-BNSS.
ಮೊನ್ನೆ ಮಾಡಿರೋದು ಇದು. No, this is, madam, referring for investigation.
That 2 points were referred to.
Hmm.
One
Second,
is crime
second legal
pre-regist-
snag.
Second legal snag. If my lords, the order sheet in the present case, my lord, cognizance is taken and thereafter summons is issued to the accused. My lords want me to.
No, no, when, this was a proceeding of 2024. No, that is post BNSS idu.
Please,
Not on 204, post BNSS. 223 ಅಲ್ಲಿ ಪ್ರೊಸೀಜರ್ ಫಾಲೋ ಮಾಡಿಲ್ಲ
Yes,
ಅಂತ.
my lord. The page number 139 of my memo, which I have now
But this
produced.
is 2022 complaint, madam.
Yes, my lord,
Ah,
I
ground
let him,
la-
I'll argue on the merits.
That's all. This is not applicable at all. Yes, sir.
Yes, sir. This petition arrived in accused number 1.
Hmm.
Now throughout the complaint, there is no single or individual overtax against this petitioner.
Overtact, defamation. ಅಲ್ಲಿ.
Overtax.
Ah.
Now, second thing is that even though the throughout complaint only allegation against accused number 3, accused number 5 and accused number 3.
Ah.
They only protest because he has taken the amount by giving the false information to the government. They protest. Even the accused is not participated in the protest also.
You are the sole accused, huh?
Accused number 1, narrated as
Accused number 1.
Yes, ma'am. Total 12.
You participate ಮಾಡಿದಿರೋ ಇಲ್ವೋ ಅಂತ it's a matter of trial.
Exhibit C1 to C20 to the 25, they have produced the document.
What are, you are a government servant?
ಈಗ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಇರ್ತಾರೆ.
ಈಗ? ಅವಾಗ?
ಹಾಗೆಲ್ಲ ಇದು ಆಫ್ಟರ್ PCR ಆದ್ಮೇಲೆ ನಮ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ ಆಗುತ್ತೆ.
ಓ, ಏನು ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
He is appointed in
The
the fire department.
fire station.
Fire station.
Even
yes.
after registering the case, the complaint made given the representation to the department. Even the
Defamation is a private act,
Yes.
not against the.
even there is no allegation throughout complaint and sworn statement and the document produced by the complaint, there is no single
Yes,
allegation.
Samita,
against
My lord, page number 47 of my memo, my lord.
Hmm.
Lord, these, all the accused, my lord, they formed a Sangha by name Dalita Vakkuta.
Hmm.
He is also a member of that Dalita Vakkuta Sangha.
Hmm.
He, his brother and others, my lord.
Hmm.
My lord, they give a false complaint to the deputy commissioner and the tahsildar in the year 2022.
Hmm.
They also give press statements
Hmm.
alleging corruption as against the respondent and his wife. Respondent's wife was at one point of time, at that point of time, she was working as a Gram Panchayat member, my lord,
Hmm.
and allegations were made.
Hmm.
My lord, page number 47, my lord.
What became of the allegations?
My lord, allegations, corruptions allegation was not proved, my lord. In 2021, his house was damage due to rains, and they had sought for compensation from the government. That also the report had come as there is no false submissions or reports given to the government, and that it was a lawful claim which they had made. They had also made allegations of corruption. Complaints were given to the Lokayukta. That was also dropped, my lord. Complaints were given. After inquiry, they were dropped. They take out slogans in the,
Where do I get that?
my lord, they have given press statements. My lord, first as page number 47, my lord. This is the page number 47 of the memo which I have produced, my lord.
ಅದೇ ಇವತ್ತು
Yes,
ಕೊಟ್ಟಿದ್ದು.
my lord.
47 is Himbaraha.
Himbaraha. The petitioner's name is there. He first tries to obtain all the documents under the RTI Act. He says that he has not at all participated in any act of defamation as against the respondent and his wife. The petitioner at that point of time obtained documents under the RTI Act. This is one document.
Collect the document from RTI. I'm not used.
My lord, page number
ಟ್ರಯಲ್
7.
ಆಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ RTI ನಲ್ಲಿ document collect
499 500 ಟ್ರಯಲ್
I
ಆಗ್ಲಿ.
am filed the application and RTI. They have obtained the copy ಅಷ್ಟೇ. Whether the granted amount in ಅಲ್ಲಿ
The matter of evidence whether you participated or not.
Even ಈ ಡಾಕ್ಯುಮೆಂಟ್ ನಾನು ಸರ್ಕ್ಯುಲೇಟ್ ಮಾಡಿದ್ದೀನಿ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಎಲ್ಲೂ ಇಲ್ಲ, ಅಲಿಗೇಷನ್ಸ್ ಇಲ್ಲ. ಡಾಕ್ಯುಮೆಂಟ್ ಸರ್ಕ್ಯುಲೇಷನ್ ಮಾಡಿದ್ದೇನೆ. Mere obtain the document through RTI is not amount to different.
ಇವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ ಅಂತ ಹೆಂಗು?
My lord, they have taken out a dharna in Azad Park, my lord, page number 71. There are certain photographs, exhibit C2 anta mark agide. By memo, page number 71, my lord. He is a part of that Sangha. He was a part of that Sangha till he got appointed in the government job. As a part of that Sangha, they take out protests. Then there are newspaper clippings at page number 72 onwards, my lord. One more last document, page number 76, there is a pamphlet.
Alleging corruption against you.
Please, ma'am. All those allegations have been proved to be false. My lord, page number 76 is a
ಆಯ್ತು,
pamphlet.
ಇದೇನು what is this 74? ಅವರೆಲ್ಲ ಅಕ್ಯೂಸ್ ಇದ್ದಾರೆ, ಇವ್ರು ಮಾತ್ರನಾ?
Your security ಕೇಳಿದ್ದಾರೆ. The respondent's wife, Srimati Lalita, has sought for security.
ಅಲ್ಲ ಪೇಜ್ 74.
74, my lord.
ಏನು ಸಮ್ ಹ್ಯಾಂಡ್ ಬಿಲ್ ಇದೆ ಇದು?
Exhibit C6, my lord.
ಅಲ್ಲ ಅಲ್ಲ, this one ಇದು
ಪರ್ಮಿಷನ್ ಕೇಳಿರ್ತಕ್ಕಂಥದ್ದು.
ಏನ್ permission?
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಇವ್ರು ಇಲ್ಲಿಗಲ್ ಆಗಿ ಎಲ್ಲ ಇದು ಸರ್ಕಾರದಿಂದ ತಪ್ಪು ಮಾಹಿತಿ ತಗೊಂಡು ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ, ಅದ್ರ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಿ ಅಂತ ಹೇಳಿ
ಸೊ
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಕ್ಕೆ.
ಇದೆಲ್ಲ ಸುಳ್ಳು ಅಂತ ಆಯ್ತಾ?
ಅಲ್ಲ, ಇನ್ನು ಇದು ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿರ್ತಕ್ಕಂಥ ಈವನ್ ಐ ಆಮ್ ನಾಟ್
ಆಯ್ತು, ಇದೆಲ್ಲ
ಐ ಆಮ್ ನಾಟ್ ಪಾರ್ಟಿಸಿಪೇಟೆಡ್ ಇನ್ ದಿ.
that's all right. All the allegations are false.
Even that allegation not.
ಅಲ್ಲ, enquiry is conducted, all allegations are false.
No document has been placed
So
by
all
the.
those documents which are produced in the, as exhibit C1, the photographs of the house
ಅಲ್ಲ,
having been damaged by
ನಿಮ್ಗೆ
rain.
ಕ್ಲೋಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಎಲ್ಲಿದೆ ಅಲ್ಲ? ಲೋಕಾಯುಕ್ತ ಎನ್ಕ್ವೈರಿ ಕ್ಲೋಸ್ ಆಗಿರೋದು, ಬೇರೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿರೋದು.
No document has been.
ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ ಇವತ್ತು?
Exhibit C1 to C24 ಅಲ್ಲಿ ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿ?
Get those documents,
Yes,
madam.
ma'am.
26th, 25th. Yes,
Interim matter.
that will continue. Yes, next.
Obliged. 57.
Huh.
Please, my lord. Of filing my statement of objections. And
ಈಗ
this
ಆಗ್ತಾ
was-
ಇದ್ದೀರಾ? ಕಾಪಿ ಕೊಟ್ರಾ?
I'll copy code.
File in the registry.
Yes.
Learned counsel B Ramesh seeks to file Swarupanand ilva ಈಗ?
Yes.
Registry to delete the name of R Swarupanand as appearing for the second respondent. Counsel B Ramesh appearing for the second respondent seeks to file statement of objections. The same be filed in the registry. 25th. Yes.
Much obliged.
Next.
Interim matter may kindly be.
That ಕೇಳಲೇ ಬಿಡಿ.
Filing memo for withdrawal, my lords.
Thank you, sir.
Seeking liberty to file fresh notice.
Any objection?
No, my lord.
Yes, next.
My lord.
Wait.
59.
Lord, in this case, my lord, I have Kokala for my lord, petitioner, my lord, since my lord
ಯಾರಿಗೆ?
he is filed, petitioner ಗೆ, since he has filed a memo for retirement, your lordship, it is.
Memo for withdrawal ಅಂತಿದೆ?
ಅಲ್ಲ, retirement. Withdrawal of the amount filed by the respondent.
Application, one withdrawal of the amount and one more application.
What amount is deposited?
Lord, it is my lord, maintenance amount, my lord, which was maintenance amount, your lordship.
You are the husband?
Please, your lordship.
ಎಷ್ಟಿದೆ?
ನಾನು ಈಗ ಒಕ್ಕಲತ್ ಹಾಕಿದ್ದೇನೆ ನೋಡಿ.
ಎಷ್ಟಿದೆ?
19,000 something.
ಅದು ವಿಡ್ರಾ ಮಾಡ್ಲಿ.
ಅದ್ರಲ್ಲಿ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಹೇಳ್ಬಿಟ್ಟು.
ಅದ್ರೇನ್ ತಗೊಂಡು ಮಾಡ್ತೀರಾ ಈಗ?
FIR ಆಗಿದೆ ಅವ್ರ ಮೇಲೆ, ವೈಫ್ ಮೇಲೆ.
25th as a last chance.
ಅಲ್ಲ ಅದು ನನ್ನ.
Registry to delete the name of Karthik Venkatesh and print the name of H.S. Shankar
Please,
as appearing for the petitioner.
please, your lordship.
Memo of retirement filed by Karthik V stands accepted.
Please, your lordship. Oblige.
25th, yes.
Lord, a complaint has been filed after 2 months. Respondent is party in person, my lord.
ಎಲ್ಲಿ?
On last date, your lordships were not sitting, therefore, my lord might be.
Oh, they'll be watching. Vacating stay ಅದೇನೋ ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದು ಇನ್ನೊಂದು vacating stay
ಇಲ್ಲ
ಹಾಕಿದ್ದಾರೆ.
ಇಲ್ಲ, vacating stay ಮೇಲೆ order ಆಗೋಗಿದೆ. Lordship on the
Heard
last
the
occasion-
learned counsel Vipin Hegde appearing for the petitioner, awaiting the appearance of the respondent in person. List the matter on Tuesday 17th in the same stage.
Interim order is to be executed.
Interim order will continue to the next day.
61.
I pay for responding number 2 to 5 minutes.
306 and 34 of IPC.
6 ನೀವು ಯಾರು?
Lords, the mother of the Milord, deceased Milord. She is a 9th standard Milord student. She was studying in Milord, respond number 3 college. Respond number 2 to 5 Milords. The accused persons Milord.
represent the
There is a
management.
death note also Milord. Initially Milord, the after reference under 156(3) for investigation Milord. The police have filed B report Milord.
ಓ ಇದೆ.
Oh, yes.
This railway police, lords.
ರೈಲ್ವೆ ಪೊಲೀಸ್.
Railway get the.
Body was found on the
Body
railway
was found on.
Found in the railway.
Or investigation is not by you, is it?
No, it is by Azul.
First-
By Azul.
But so the date of incident was, my lords, on 17/2/2022. By then UDR was registered. Then, my lords, they file a complaint on after 1 year, my lords, 10 days. 27/2/2023.
What did you do for 1 year, sir?
On the date of the incident, my lord, a complaint came to be filed.
That
the
is UDR.
Missing complaint, UDR ಆಗಿತ್ತು. Thereafter, my lord, I have several occasions, my lord, I have visited the, my lord, the police, they have not registered. Thereafter, before the, my lord, Human Rights Commission, my lord, I have filed a complaint that has been referred, and my lord, thereafter.
Page.
Please.
Human rights complaint
The
was
order
on
itself, my lord, the
2/3/2023. Human rights complaint was on 2/3/2023.
Page number 24. Page number 24 of the order itself, my lord, trial court has, my lord, recorded. Para number 12.
Page 24.
Also, para number 12 ಅಲ್ಲಿ the trial court has, my lord, rejected the, my lord, the B report and to file fresh final report. At that time, my lord, it was recorded, my lord.
ಆಮೇಲೆ ಏನಾಗಿದೆ?
Railway police station ಅವರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್
ಅಲ್ಲ,
ಮಾಡಬೇಕು
ಮತ್ತೆ B report ಹಾಕಿದ್ದಾರೆ.
B report has been filed. The very same B report has been, my lord, refiled, my lord. ಒಂದು ಫಸ್ಟ್ ಫೇಸಿಂಗ್ ಶೀಟ್ ಒಂದು ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ. Entire, my lord, record and, my lord, statements have been reproduced, my lord, which are produced earlier before the very same court, my lord. The very same court has rejected the B report and directed the other officials to, my lord, file final report after conducting inquiry.
ಈಗ ಅದಾದ್ಮೇಲೆ B report ಮತ್ತೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರಾ?
B report ಅನ್ನು accept ಮಾಡಿಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್
ಕ್ಲೋಸ್
ಮಾಡಿದ್ರು.
ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ.
Death note also, my lord. By mentioning all the
306 cannot
names
be
of, my
closed.
lord.
Delay, my lords. First contention is, my lords, delay. Second thing, even according to them, my lords, human rights complaint was lodged on 2/3/2023.
ಅದು ಎಲ್ಲಿದೆ ಕಂಪ್ಲೇಂಟ್?
Copy, my lords. Page number.
Will send it to some other investigating officer.
CID.
CID ಗೆ ಮಾಡಿ. Yes.
47, my lords.
The complaint to the police inspector after 1 year.
47.
ನೀವು ಪ್ರಿನ್ಸಿಪಾಲ್?
ನಾನು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಮತ್ತೆ ಪ್ರಿನ್ಸಿಪಾಲ್ ಸ್ಟಾಫ್ 2 to 5.
2 staffs.
2 to 5.
ಸೌಂದರ್ಯ ಸ್ಕೂಲ್ ಯಾವ್ದಿದು?
ಸೌಂದರ್ಯ.
ಸೌಂದರ್ಯ ಕಾಲೇಜ್, ಲಾ ಕಾಲೇಜ್.
ಲಾ ಕಾಲೇಜ್ ಇದು?
ಲಾ ಕಾಲೇಜು is there.
She is the 9th standard student, my lords.
306 ಬೇರೆ 305 ತಾನೇ ಬರ್ಬೇಕು.
ಇಲ್ಲ, ಅದು ಅವ್ರು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಅವರು. ಫಸ್ಟ್ ಗೆ UDR ಆಗಿರೋದು 305 ಗೆ.
305 ಗೆ. Let the investigation.
Unnecessarily management, my lords. Kindly see one
Necessarily management. What
one observation of the trial court, my lords, at page 34. Page 34, one observation. Para 11, my lords. I'll not read it, my lords. Para 11.
37.
34, my lords.
Second order.
Para 11, page 34.
ಏನು?
ಅಲ್ಲ,
ಏನು
ನಮ್ಮ ಮೇಲೆ ಏನಿಲ್ಲ ಅಂತ.
ಅವರ ಹೆಸರು
ಪ್ರಿನ್ಸಿಪಲ್
ನಮ್ಮ ಮೇಲೆ ಏನು ಇಲ್ಲ ಅಂತ.
ಪ್ರಿನ್ಸಿಪಲ್ ಅಲ್ವಾ ನೀವು?
ನಾನು ಪ್ರಿನ್ಸಿಪಲ್ ಹೌದು.
ಅವೇ ಮತ್ತೆ ಹೇಳಿರೋದಲ್ಲಿ.
ಇಲ್ಲ, ಅಲ್ಲೇ ಅಷ್ಟೇ ಹೇಳಿರೋದು. Year school marks is not everything. So and so, thank you very much. Thank you for everything.
ಅದಕ್ಕೆ ಮುಂಚೆ 8 you all.
80 all ಅಂತ ಹೇಳಿ ಸ್ಕ್ರಾಚ್ ಮಾಡಿದ್ದಾರೆ.
ಚೈಲ್ಡ್ಸ್ ಮೈಂಡ್ ಸರ್, 15 years ಅಲ್ಲಿ ಡೆತ್ ನೋಟ್ ಕರೆಕ್ಟ್ ಆಗಿ.
ಇಲ್ಲ, I am not on that point.
And in the FSL report also, my lord, handwriting is
A
tagged.
girl child of 15 years dies on account of harassment of other students and the principal and students always criticizing marks, fees.
She could not, my lords, reach up to the, lords, that is what is recorded in
to the what?
Para 11, my lords.
Up to the what, sir?
Her own expectations. That is what is recorded, my lords.
I think the para 13 of trial.
Para 13 of the trial judgment
may not be necessary for that observation. Not clear on what basis this observation is made.
If we read the death note,
not experts.
Your expert opinion, magistrate.
And the next line in that page 35.
The deceased was psychologically not adjusted. In English. To new syllabus. ಯಾರು ಹೇಳಿದ್ರಂತ ಇದನ್ನ ಇವ್ರಿಗೆ?
ಅಲ್ಲ, ಅವರ ಸ್ಟೇಟ್ ಇದು
ಯಾವುದೋ ಒಂದು
generally teachers expect good marks from all students. Otherwise allegation ಏನು?
ಅಲಿಗೇಷನ್ ಇರುವಂತದ್ದು ಬೇರೆ ಮಕ್ಕಳು ಎಲ್ಲ ಇವರ ಮೇಲೆ ಕಮೆಂಟ್ ಮಾಡಿದಾಗ ಟೀಚರ್ಸ್ have not taken any action ಅಂತ. That is the complaint.
No, that's not the only thing.
Yes, ma'am.
Investigation ಆಗ್ಬೇಕಿದೆ.
Detailed complaint, my lord.
We report ಅಂತೂ ಸಾಧ್ಯವೇ ಇಲ್ಲ. You seek quashment, you do anything. In a 306 case, in a 305 case, when the child is dead,
yes,
there is no question of B report being filed there. ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ B report?
Management, my lords. I can understand if principal and my lords.
Management will not. Principal, yes.
Principal.
Management ಯಾರಿದ್ರಲ್ಲಿ?
Responding number 2.
President.
Yes.
President, he will not, ಅವ್ರನ್ನ ಬಿಡಲ್ಲ. Not the principal.
Principal.
Not the teachers.
Yes.
Who have time and again insulted the student that you are not up to the mark, you are useless. If you are willing to study, you can.
Is made after 1
you
year.
Don't seem like, you don't look like someone who can study.
That statement is made after 1 year, 1 year, 10 days from the date of.
Death note ಅಲ್ಲಿ? Death note ಅಲ್ಲಿ?
I think that's the death note. That's all she.
ಏನ್ ನೋಡಿ B report ಹಾಕಿದ್ರಿ?
ಇವ್ರದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲರದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ನಿಮ್ದೆಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ obviously.
ಅವ್ರದೇ ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿ.
ಇಲ್ಲ ಇಲ್ಲ.
Whose name has been mentioned, my lord. These very same teachers have been.
Why will the teacher say yes, I did?
ಇಲ್ಲ ಇಲ್ಲ, ಅವ್ರು ಮಾತ್ರ ಅಲ್ಲ, ಬೇರೆ ಇವ್ರದ್ದು ಮಾಡಿದ್ದಾರೆ. ಮೃತಾಳ ಚಿಕ್ಕಪ್ಪನ ಹೇಳಿಕೆಯನ್ನು ತಗೊಂಡಿದ್ದಾರೆ.
ಚಿಕ್ಕಪ್ಪ?
ಹೌದು.
ಯಾರು ಚಿಕ್ಕಪ್ಪ?
ಸ್ಟೂಡೆಂಟಿನ ಚಿಕ್ಕಪ್ಪ ಅಂತ. And relatives statements are also taken.
No,
neighbor ಇದ್ದು ತಗೊಂಡಿದ್ದಾರೆ.
Page number 1.
ನಾಳೆ ಇದನ್ನ ಬಿಟ್ರೆ 302 B report ಹಾಕ್ತಾರೆ.
Statement of all the relatives ತಗೊಂಡಿದ್ದಾರೆ. Even marks ಇದ್ದು.
You may get acquitted, but not B report. I am the first time seeing 306 ಅಲ್ಲಿ B report ಹಾಕಿರೋದು.
Page number 130, my lords.
130?
130, my lord.
I will pass orders tomorrow.
Please.
ನಾಳೆ ಮಧ್ಯಾಹ್ನ ಮೇಲೆ ಏನಿಲ್ಲ ಅಲ್ಲ ಮೇಡಮ್ 4:30 ಹಾಕಿ ನಾಳೆ ಬಿಲ್ಡಿಂಗ್ ಡೇಟ್.
Great. For the petitioner, your lordship, it's a case of 138 enact. It's a case of 138 enact, your lordship. The petitioner had filed an application before the first appellate court for extension of the time to comply with the
148.
148, yes, your lordship.
Yes, sir.
However, that has been rejected.
2 months time is given earlier.
ಒಂದು ತಿಂಗಳು ಕೊಡೋಣ. ಎಷ್ಟು ದಿನ ಬೇಕೀಗ?
2 weeks, your
They have
lordship. Already.
2 weeks.
They
Already we
already
have,
produced the DD.
We have the DD.
Shows the 15/12. ಅದೇ DD ನ ಇನ್ನು ವ್ಯಾಲಿಡಿಟಿ ಇದೆ.
In a 2-3 days.
Page number.
ಇನ್ನು 2 weeks ಟೈಮ್ ಕೊಡ್ತೀನಿ. ಅಷ್ಟ್ರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡದೆ ಹೋದ್ರೆ ಆರ್ಡರ್ ಸೆಂಟೆನ್ಸಿಂಗ್ suspension will go.
Great.
The petitioner is before this court calling in question an order of the concerned court dated 4th April 2025, which rejects the
16/12.
4th April ಅಂತ ಏನೋ ಇದೆ ಅಲ್ಲಿ? 16th April. 16/12/2025, by which the concerned court rejects the application filed by the petitioner seeking extension of time to make a deposit before the concerned court as obtaining under section 148 of the Negotiable Instruments Act. The learned counsel for the petitioner submits that if 2 weeks time is granted, the demand draft which is already taken would be deposited before the concerned court. In the light of the said submission as also perusal of the demand draft, I deem it appropriate to grant the petitioner 2 weeks time from today to make the deposit of 20%, of 20% amount. Subject to the said condition, the order of suspension of sentence shall stand revived. In the event the petitioner would not deposit in the next 2 weeks as directed, the order of suspension of sentence would get automatically vacated. With the aforesaid observation, disposed.
And for the petitioner, in 63.1, in 63, my lord, this is a POCSO case
In WP
where this court has
1918.
directed
Hey,
registration,
ಯಾಕೆ ಅರ್ಜೆಂಟ್?
court has directed registration of
ಎಲ್ಲಿ
FIR.
ಓಡ್ಬೇಕಾಗಿದೆ? ಇರಿ ಸ್ವಲ್ಪ. ಹ್ಮ್.
My lord, there are 2 cases, please.
ಹಾ.
The first one, WP 1918/2026, please, my lord.
ಈಗ FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
Charge sheet is
Investigation.
filed against- Charge sheet is filed against.
ಹಾ, ಸರಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ವಾ?
No, I'll challenge the charge sheet.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿರದ? ನಿಮ್ದೇನು? ಸ್ಟೇ ಆಗಿದೆ.
Stay ಆಗಿದೆ.
ಅದನ್ನ investigation permit ಮಾಡಿ.
Stay is,
ಪರ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
investigation is permitted.
My lordships have told on February 4th, my lordships to place the materials before this court. It's already been 40 days, my lord, since the
ಇಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕೊಡಿ.
No, your lordship is directed to continue the investigation.
ಕಂಟಿನ್ಯೂ ಬಟ್ ಪ್ಲೇಸ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮೆಟೀರಿಯಲ್.
Yes, and also order to not take any coercive steps in this case, my lords.
You want coercive steps to be
No, my
taken?
lords, your lordship has already granted,
Correct.
ordered.
Yes, Jagdish sir. I'll take it on 27th. Produce the investigation material.
I make submission, my lords, investigation officer, despite of an interim order from this court, my lords, when my lordships are specifically told not to precipitate the matter, she has issued a notice. She was present before the court on that day. Knowing fully, she issues a notice calling me for investigation, police station ಬನ್ನಿ ಅಂತ. She was
ಅದು ಕೋಆಪರೇಟ್ ಮಾಡಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ.
ಅಲ್ಲ,
ಅಲ್ಲಿ ನಿಮ್ ಮನೆಗ್ ಬಂದು ತಗೋಬೇಕಾ ಸ್ಟೇಟ್ಮೆಂಟ್?
ಇದ್ದಾಗ ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಟಿಸ್.
ಅದನ್ನ ನೋಡೋಣ.
I went the next day itself. My lordships have permitted.
Now I have permitted investigation. You cooperate with the investigation, with the investigation.
I already
Produce
went,
the,
my lordships have produced all the materials.
all right,
There is an
yes.
endorsement also.
No problem. Produce list on 27th. The
Their petition
Leonard additional SPP to
in both the cases, please, my lord.
ನಿಮ್ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ ಅಂತ.
ಅಲ್ಲ, ಅದರಲ್ಲಿ I have to point out one particular aspect.
ಆಮೇಲೆ
as
ಪಾಯಿಂಟ್
to-
ಔಟ್ ಮಾಡಿ. ಇದು ಕಂಪೈಲ್ ಪೆಟಿಷನ್.
Otherwise, I will have to come again, please, my lord, because in both the cases.
Come again.
Like insofar as the challenging of charge sheet concerned, my lord. No, my only humble submission to this.
ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಲ್ವ ಚಾರ್ಜ್ ಶೀಟ್ ಇಲ್ಲಿ?
ಅಲ್ಲ, FIR was challenged. In the meantime, there was no interim order, please, my lord. But the investigation was concluded and the charge sheet has been filed. But pursuant to my request, this honorable court was, pleased to direct the investigating officer
to collect the CCTV footage furnished by the petitioner, please. my lord. It was collected. Pursuant to that also, please, my lord, the investigating officer collected the CCTV footage from the adjacent buildings, and wherein the footage which I gave was matched, and that has been sent to the forensic laboratory, please, my lord. So my submission is that as on the date of the offense, the victim was very well in the premises of the school. That is being vindicated, please, my lord.
Let them challenge the
My lord,
charge
in
sheet
both the
that your
cases.
lordship.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಲ್ವಾ?
Martin, certainly I'm going to.
ಮಾಡಿ ಮತ್ತೆ.
Yes, please, my lord.
Challenge the charge
Liberty
sheet.
may kindly be granted to me.
Liberty granted.
Yes, please, my
This
lord.
court has directed registration of FIR against him, my lords. There is sufficient material.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡೋದ್ ಬೇಡವಾ ಅವರು?
There is sufficient material.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡೋದ್ ಬೇಡವಾ? How can you come in his way?
Okay, I am
ನಿಮ್ದ್ರಲ್ಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಕ್ ಹೇಳ್ತೀನಿ
the
ಈಗ.
complainant in this case.
So,
No, this is a case, my
ಅಲ್ಲ,
lord.
so he should not challenge the charge sheet, is it?
This petition 63 may be disposed and liberty may be given.
63 ಯಾರ್ದು?
ಇವ್ರದೇ.
ಅದಾಯ್ತಲ್ಲ, ಅದೇ ನೀವ್ ಹೇಳೋದು ಅದನ್ನ.
ಡಿಸ್ಪೋಸ್ ಆಗಿ ಅವ್ರು ಲಿಬರ್ಟಿ ಕೊಟ್ಟು ಬೇರೆ ಪೆಟಿಷನ್ ಹಾಕೊಂಡ್ ಬರ್ತಾರೆ. ಇದು
ಹಾಕೊಂಬರ್ಲಿ, ನಿಮ್ಗೇನ್ ಪ್ರಾಬ್ಲಮ್?
ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳ್ತಿದ್ದಾರೆ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದರಿಂದ
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ, ಈಗ ಪೆಂಡಿಂಗ್ ಇರಲ್ವಲ್ಲ?
63 there are two petitions.
I understand, sir. Challenge the charge sheet, yes.
Published.
63 disposed, reserving liberty to challenge the charge sheet.
63.1 interim order may be.
63.1 interim order stands extended subject to the condition that the petitioner shall cooperate with the investigation. Any non-cooperation with the investigation being projected by the learned additional SPP, the interim protection granted would automatically vanish.
My lordships kindly permit me for a moment. ನಾನು next day ನೇ ಹೋಗಿದ್ದೀನಿ, endorsement ಕೊಟ್ಟಿದ್ದಾರೆ ಪೊಲೀಸರು. In fact, my lordships, I have produced the exculpation.
The learned additional SPP to secure and place on record the entire investigation papers on the next date.
Please. ಅಲ್ಲ ಮತ್ ಅಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಬರ್ತಿಲ್ಲ ಅಂತ ಇದ್ ಮಾಡ್ತಾರೆ. ಆಲ್ರೆಡಿ ಹೋಗಿದ್ದು, ನಾನು ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
Records ಬರ್ಲಿ.
In the garb of investigation, they will immediately, my lordships, arrest him.
ಅದು ಬೇಡ, ಅದ್ಯಾರು ಕೋರ್ಸ್ ಸ್ಟೆಪ್ಸ್ ಅಂತ ಹೇಳಿಲ್ವಾ?
ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇದ್ದಾಗ್ಲೇನೆ ಅವರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ತೀನಿ ಅಂತ
ಬರಲ್ಲ ನೋಡ್. Yes,
ಇಂಟ್ರಿ ಮಾಡ್ರಿ is extended.
that is extended. 27.
64.
Petitioner in this case, my lord.
Statutory bail. Jagdish sir.
376, 314.
FSL ಇಲ್ಲ, ಏನು ಇಲ್ಲ.
No, the ground.
ಆಮೇಲೆ ಇನ್ನು ಏನೇನೋ ಇಲ್ಲ.
So that ground they will, the default charge sheet, they cannot, the defect in charge sheet will not lead to default bail.
ಆಮೇಲೆ ಇನ್ನೇನಿದೆ ನಿಮ್ ಗ್ರೌಂಡ್?
The investigation officer filed a requisition on 19/1/2026 is admitted that ನಾನು retrieval ಕಳಿಸಿಲ್ಲ ಅಂತ. Investigation ಆಗಿಲ್ಲ ಅಂತ mobile phones which was seized at the time of my arrest, my lords.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಲ್ಲ,
ಅದ್ರ ಜೊತೆ ಇಲ್ವೇ ಇಲ್ಲ ಅದು.
ಅದು ಬರುತ್ತೆ ಬಿಡಿ.
ಆಮೇಲೆ ರಿಟ್ರೀವ್ ಮಾಡಿ after lapse of 90 days they filed a requisition, my lords.
ಏನು ಮೊಬೈಲ್ ಫೋನ್?
Mobile phone retrieve.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ಏನ್ ಪೋಕ್ಸೋ ತಾನೇ ಇದು?
Please, my lords.
3, 4, 5.
Please, my lords.
Yes sir, you are accused number 1.
Sole accused, my lords.
Sole accused.
Please, my lords.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಬರ್ಲಿ ಬಿಡಿ. ಆಮೇಲೆ
completely mistaken identity, my lords.
No sir.
On merit, my lords, kindly see that their complaint and charge sheet statement, my lords.
ಹಾಕ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ, ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ MS ರಾಮಯ್ಯ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ದವರು ಅಂತ ಹೇಳ್ತಾರೆ. ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ನನ್ನ ಜೊತೆ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದ ಗೋವಿಂದ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆಯ್ತು.
But my lords, the charge sheet shall be filed within 60 days, my lords.
ಅಲ್ಲ, ಅದೊಂದು
No,
ಪ್ರಾವಿಷನ್.
the issue, my lord, because BNSS mandates the charge sheet has to be filed. So we have filed it. And
60
non-completing.
days ಒಳಗೆ ಹಾಕಿದ್ದಾರೆ. ಆಮೇಲೆ ಇನ್ನೇನೋ 30 days ಒಳಗೆ ಏನೋ ಮಾಡ್ಬೇಕು.
30 days ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್. On 84th day charge sheet was filed.
ಯಾವತ್ತು ಹಾಕಿದ್ದು? 84th day.
84th day.
What is the punishment?
Yes, this you have to answer.
ಅಲ್ಲ 3, 4 are there. Punishment beyond 10 years.
ಅಲ್ಲ, punishment beyond 10 years.
So punishment beyond 10 years.
What is the offense?
3,
POCSO
4, 5.
3, 4, 5 ಅಲ್ವಾ?
Yes.
ಏನ್ ಚಾರ್ಜ್ ಶೀಟ್ ಯಾವತ್ತು ಹಾಕಿದ್ರೆ?
ಅಲ್ಲ ಸ್ವಾಮಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕೋದಕ್ಕೆ
60 days ಅಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂತ ಎಲ್ಲಿದೆ?
that one section 193 subsection 2, my lords.
193(2) ಅಲ್ಲ, 187 ನಲ್ಲಿ.
They will have to
See, 187 goes with regard to the offense. ಈ 193 ಅಲ್ಲಿ there is some problem. Last time I told you.
Correct.
Now 197 ಅಲ್ಲ ಅದು?
Within 2 months, 193.
193 subsection 2 minutes.
193.
193.
The report of the police officer on completion of investigation for offences under so and so and POCSO
Yes, my lord.
shall be completed within 2 months from the date on which the information was recorded by so and so.
No, but that's correct, no, but is he entitled for default
Now
bail?
he is saying this has to be imported to default bail and contending that 60 days al hakbekagittu 84th day hakidare anta. Default bail will be, in this case, is an offense beyond 10 years.
Yes.
So you have 90 days period to file the charge sheet. So these two are incongruous.
No, but the,
How do you reconcile this?
no, this doesn't say failure to file charge sheet.
Allah, there is no consequential action, true?
Justice Srishananda observed that, my lord.
Yaru?
Justice Srishananda Saibro.
Ah.
ಅದರಲ್ಲಿ conjoint reading of section 187 and section 193 subsection 2, the filing of the charge sheet mandatory within 60 days.
Default bail ಹೋಗ್ಬಿಡುತ್ತೆ ಅದು. Then 183, what is that? 187 will have no meaning at all. This is an offense which is punishable for life or 20 years or whatever it is, if convict, all right. So it is 90 days without doubt. 90 days al charge sheet ಹಾಕ್ಬೋದು. But this 193 is creating a problem. 193 B CRPC li ಯಾವ್ದಿತ್ತು?
172.
171A, my lord, that was inserted for the purpose of now the POCSO Act. Trial has to be completed within.
Trial has to be complete. Trial ಅಲ್ಲ, investigation complete ಮಾಡಬೇಕು ಅಂತಿರೋದು.
Even trial has to be completed. Therefore,
Then this statutory bail will be an inevitable consequence.
no, that is not the purpose. The purpose
But
is,
there is a coordinate bench judgment also.
look at it, my lord.
ಇಲ್ಲಿದೆ, ಇಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ತಗೊಳ್ಳಿ. ಯಾವುದು ಸೂರತ್ ಸಾಹೇಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಇದು ಯಾವುದು?
Correct. ಇದರಲ್ಲಿ FSL report shall be filed within 1 month from the date of collection of samples.
ಅದಾಯ್ತು. Yes, that will see. Judgment memo of citations ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್. ಸ್ಟೇಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದಾರೆ.
This requires an answer because Justice Srishananda ಅವರು ಹೇಳ್ತಾರೆ ಎರಡನ್ನು ಒಟ್ಟಿಗೆ ಕೇಳಬೇಕು. You should harmonize the two and leave.
No, harmonize the two, but
No.
I understand.
See, it is their argument that once investigation officer filed within a period of 60 days, right to seek extinguishes. Therefore, it should be filed. But what happens to the offense for life? Statute, you have investigation, you can continue investigation up to 89th day file ಮಾಡಬಹುದು. ಇದನ್ನ ತಗೊಂಡ್ಬಿಟ್ರೆ 60th day ಫೈಲ್ ಮಾಡಬೇಕಾಗುತ್ತೆ, even in POCSO cases.
ಇವರು ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ದಾರೆ.
Dismiss
It is
ಮಾಡಿರೋದಲ್ಲ,
filed,
observation.
within 60 days. In that case, my lord, charge sheet was filed within 60 days.
Within 60 days it was filed.
Let me have it.
So this is a far reaching consequence. ನೀವು ಒಳಗಿದ್ದೀರಲ್ಲ
Please, ma'am.
ಅಲ್ಲೇ ಇರಿ.
It's my fundamental rights, my lords.
Fundamental right. ಯಾವ್ದು 4, 5, 6 POCSO?
Allah, it's completely mistaken identity, my lords. My kindly allow me, my lords, I will play the investigation video statement, my lords.
ಯಾವ್ದ್ರ ವಿಡಿಯೋ?
ಐವನೇ ಹೇಳ್ಕೊಡ್ತಾರೆ ಯಾರು ಇದ್ರನ್ನ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ. The statement of the victim mother, my lords, stated ನನ್ಗೆ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. But then completely on the same
ನಿಮಗೂ
time, my lords,
ವಿಕ್ಟಿಮ್ಗೂ ಏನ್ ಸಂಬಂಧ?
victim mother, she was working with me as a house constructor works, my lords. And in the complaint, my lords, kindly peruse at the where someone who is working at the MS Ramaya hospital is the culprit. And again in the charge sheet, she stated that, my lords, who was working with me.
What is the animosity between you and her mother?
Because, my lords, when she was deceased, my lords, she was 7 months pregnant. I feel, my lords.
The child has died, is it?
Please, my lords.
302 ಬೇರೆ ಇದೆಯಾ?
109. Commitment to suicide.
109. 108. Suicide. Oh, the
There is no death
child
case.
commits suicide.
Please, my lords.
She was
After
7 months pregnant at that time.
Please, my lords.
The facts are horrible. How to reconcile this 193 and this coordinate bench?
What the state has taken up this issue. Supreme Court.
ಯಾವುದು?
This judgment, If you challenge this judgment also, let me have a look at it.
ಅಲ್ಲ ಅದ್ ನೋಡಿ, ಬಟ್ ಜಡ್ಮೆಂಟ್ ಇಸ್ ಸ್ಟೇರಿಂಗ್ ಎಟ್ ಅಸ್ ನಾವು.
That's correct.
ನಾವು ಪೋಕ್ಸೋ ಇಲ್ಲಿ 60 ದಿನದಲ್ಲಿ ಹಾಕ್ಬೇಕು ಅಂದ್ರೆ ಸ್ಟ್ಯಾಚ್ಯೂಟರಿ ಬೇಲ್ 60 ದಿನಕ್ಕೆ ಕೊಡ್ಲೇಬೇಕಾಗತ್ತೆ ಆಮೇಲೆ.
No, in
And
fact,
look at
my
the
lord,
offense.
No, in fact, the series of judgment where.
How old was the child?
17 plus years.
No, series of judgment where said, since investigation has to be completed within 1 year, trial has to be completed within 1 year. Court started granting bail after 1 year. So that matter was taken up to Supreme Court. Supreme Court said that I'll place this. Supreme Court said his purpose beneficial legislation to victim, not to the accused.
We'll
Probably
see.
we'll have to look into
Friday.
that. That's Monday.
ಆಯ್ತು, ಮಂಡೇ.
Please manage.
ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆಯಾ?
Please manage.
ಮಂಡೇ.
Because it is filed on the second month, 17th.
So what, sir? Yes. ಫ್ರೀಡಮ್ ಫೈಟರ್ ತರ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
So, because my fundamental right violated on the hands of the statute, state missionary.
We'll see if there is no substance, we will stay it also, don't worry. Yes. Madam? ಅಲ್ಲ ಇದು ಮುಗಿಸ್ಕೊಳ್ಳೋಣ ಅಪ್ ಟು ಆರ್ಡರ್ಸ್.
Preliminary hearing 65.
ಇವ್ರು ಬಂದ್ರ?
Appear for petitioners.
Appearing for respondent number 2, my lord.
There is a matter where, my lord, SC/ST atrocity case has been registered against a public servant. His mother was, my lord, the license to.
ಇದನ್ನ ತುಂಬಾ ಕೇಳಿದೀನಿ, ಮತ್ತೆ ಅಡ್ಜರ್ನ್ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
And when your lordship granted interim order, they register one more case. Second case.
Tag ಆಗಿರೋದು
It
ಅದೇ.
is also tagged. We have also produced the.
ಇದು 2024 ಇಂದ ನೆನಪಿದೆ. ಅದೇ ಇದು ಕ್ವಾರಿಂಗ್ ಪಕ್ಕ. ಎಸ್.
Public servant has been tracked.
ಇವತ್ತು ಎಲೆಕ್ಷನ್ ಇದೆ, ನಾಳೆ ತಗೊಂತೀನಿ. ಟುಮಾರೋ. ಇವತ್ತು ಡ್ಯಾಮೇಜ್ ಏನಿಲ್ಲ. List tomorrow, ನಾಳೆ ಇಲ್ಲ. Heard the learned senior counsel appearing for the petitioner, Arun Sham appearing for the petitioner. As a last chance to the respondent complainant to make submissions. ಇಲ್ಲೇ ಇದ್ರಲ್ಲ ಇವರು.
ಇಲ್ಲೇ ಇದ್ರು.
ಕ್ಲಿಫ್ಟ್ ಅಂತ.
ಕ್ಲಿಫ್ಟನ್ ಅವರೇ ಇಲ್ಲೇ ಒಂದೇ ರೇಟ್.
ಆಯ್ತು, ಲಿಸ್ಟ್ ಟುಮಾರೋ, ನಾಳೆ ತಗೊಂಡ್ಬಿಡ್ತೀನಿ. ಲಿಸ್ಟ್ ಟುಮಾರೋ ಇನ್ ದಿ ಸೇಮ್ ಸ್ಟೇಜ್.
Interim order.
Exactly continues.
66.
ಎರಡರಲ್ಲೂ ಕ್ಲಿಫ್ಟನ್ನೇ ಅಲ್ವಾ? ಆಯ್ತು.
66.
My lords, appearing for the petitioner in this matter, my lord, we have been informed by the petitioners that complaint was lodged on the same set of facts, the same allegations before the registrar of societies, my lords. So we're waiting on a copy of the judgment. If short accommodation of
That is not the issue. In fact, what had happened was the society, it had become defunct. Subsequently, they predated earlier resolutions and meetings and submitted before the registrar of societies, including presence of some people who were deceased 2 years ago.
My lords,
They are not even alive on that particular day, including my signature was forged and my signature they did not put.
lords, the submission of petitioners to this extent, learned senior Jowli engaged in the matter, he has informed us that if a person is exonerated.
Today's problem ಅಷ್ಟೇ. List day on Wednesday.
I'm not opposing for that purpose. What he says is
List
factually
on
not
list on Wednesday in the same stage. As a last chance, it is made clear no further adjournment on whatsoever ground will be granted.
Great.
Yes, next.
67.
Petition seeking relaxation of condition to sell the vehicle.
Which vehicle, sir?
This is a Range Rover Sport 3.0 vehicle.
You want to sell it?
I filed an application to sell the vehicle. The interface between the accused number 1 and the de facto complainant, they compounded the said offense.
First time ಬರ್ತಾ ಇರೋದಾ? First time is it?
No, second time. What has happened is on the last
ಅಲ್ಲ,
day.
last time notice ಏನಾಗಿಲ್ಲ ಅಲ್ವಾ?
Swami, I am filing a memo to dispense the notice. There are certain facts.
The state should be heard.
Yes. Complainant has compounded the said offense with the.
You are the accused.
No, I am actually, Malaj, I am not arrayed as accused here. Malaj, what has happened is.
No. Jagdish sir, take the notice in this.
Malaj, I just file a memo. 67.
ಒಂದು ನಿಮಿಷ ಅದು ಮಾಡೋಣ. Fresh matter ಹಾಕ್ತೀನಿ Friday. Just see. Yes, he wants release of the vehicle. He is an applicant but not an accused nor the complainant. Court has rejected it.
No, it has allowed the application, but onerous financial conditions have been.
ಹೌದಾ, ಏನು ಎಷ್ಟು?
Well, it's one condition is if at all the vehicle is found to be purchased out of the proceeds of the sale, then the condition states third in case of the court comes into conclusion that if the vehicle is purchased out of the proceeds of the crime in the latest state, petitioner is liable to pay loss to the de facto complainant. De facto complainant has already compounded the said offense with the accused.
Let's see. ಅದು Friday ತಗೊಂತೀನಿ. Friday ಬೆಳಗ್ಗೆ. Friday fresh matters. Yes.
How does Karnataka?
Order 68.
Non-compliance of office objection, CH moved. Finally, a week's time is. Ida. Oh, adena.
Recall ge 2,500 rupees with caste mele idu agindi. Offense 498 306 man.
The recall non madakagala. It has to go there, but we'll permit him to comply with a week's time is granted to comply with the office objections. In the event they stand complied, list the matter. Even one side no bandilla. List the matter on the 16th, 23rd in the fresh matters list. This next.
69.
Anil Kumar, ಏನಿದೆ?
ಇದು offenses under section 471, 465, 468.
Respondent ಯಾರು?
State. They have filed vacating stay application, my lord. This is relating to production of, they are alleging that we have produced fake documents at the time of initial appointment. Appointments took place in the year 1994. FIR is filed in the year 2022. Thereafter, my lord, charge sheet has been filed. That is under challenge.
I will see. Interim order ಇದೆಯಲ್ಲ?
Interim order.
List the matter on 25th in admission along with the application, 24th in admission along with the application seeking vacation of the interim order. Interim order subsisting will continue till the next date. Next.
70.
That's on 17/2, my lords were pleased to grant me an interim order. Adnadi enagittu because of our mistake only, my lords, it's JMFC court Devnadi, my lords, it's got recorded as Bangalore. To that effect, my lords, I may be even permitted to file an amendment, my lords.
Nimde problem.
Yes, that's why it's our mistake only, my lords.
Counsel for the petitioner files
I for amendment.
an application seeking amendment of the prayer insofar as the description of the court is concerned. For the reasons indicated, so and so application is allowed. The petitioner to amend the prayer with regard to the description of the court. The same has crept into the order as well, dated 17/2/2026. Therefore, the order shall now read as pending before JMFC court, Devanahalli, na?
Devnadi, yes.
Devanahalli in place of Bangalore.
That's I even filed my amended petition.
The learned counsel files an amended petition with regard with the corrected prayer. The same is taken on record.
Grateful.
71.
Lordship, since
Furnishing PF ಎಲ್ಲ ಕಟ್ಟಿಲ್ಲ ನಿಮ್ದೆ ಮಹೇಶ್?
we paid, my lords, it has to go.
The learned counsel submits needful has been done, office to verify. Yes, next.
71.
Lordship, she has granted bail since from 5 months she is unable to furnish surety. This page number 23 is the bail order.
Bail ಕೊಟ್ಟಿದಾರಾ?
Yes, my lord. 2 sureties, my lord.
Where is she from?
She is from Nigeria, my lord. Foreigner.
Nigeria?
Yes.
ಏನು NDPS ಎಲ್ಲಿ withdraw ಮಾಡಿ ಕಳಿಸಿ.
Yes.
If she is staying illegally here, withdraw the prosecution,
Yes,
take
ma'am.
steps to deport.
Yes.
ವಾಪಸ್ ಹೋಗಿ ಸಾಕು ನೀವು.
ಆಗ್ಬೋದು.
8C consumption ಗೆ.
Below 10 years, below commercial quantity.
ಹಾ.
Yes, my lord.
ಇದಕ್ಕೆ ಓವರ್ ಸ್ಟೇ ಆಗಿ ಆರಾಮಾಗಿರ್ತಾರೆ ಇಲ್ಲಿ.
No, my lord, will deport.
Withdraw prosecution and take steps under the SOP.
Please.
ವ್ಯಾಲಿಡ್ ವೀಸಾ ಅಂತೂ ಇರೋದೇ ಇಲ್ಲ. ವೀಸಾ ಎಷ್ಟು ದಿನ ಆಗಿದೆ ಎಕ್ಸ್ಪೈರ್ ಆಗಿ?
2-3 years.
ಏನ್ ಇದು ಹಿಂಗಾದ್ರೆ ಇದು ಯಾವ್ದೋ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಲಾಂಚ್ ಮಾಡ್ಬಿಟ್ಟು 3 ವರ್ಷದಿಂದ ವಿತೌಟ್ ವೀಸಾ ನೈಜೀರಿಯನ್ ಇಸ್ ಸ್ಟೇಯಿಂಗ್. ಅದು ಏನು ಇದು ಕನ್ಸಂಪ್ಷನ್ಗೆ. Is it not giving a hand to them to overstay in this country without valid visa? ಬೇರೆ ಎಲ್ಲಾದ್ರೂ ಆಗುತ್ತಾ ಇದು? Get ready to go. Yes. ಈ ನೀವಲ್ಲ ಏನ್ ಫೈಲ್ ಕಟ್ತಾ ಇದ್ದೀರಾ ಆಗ್ಲೇ? ಪೆಟಿಷನರ್ ಏನ್ ಫೈಲ್ ಕ್ಲೋಸ್ ಮಾಡಿ ಹೋಗ್ತಾ ಇದ್ದೀರಾ? ಎಸ್. Take steps in this immediately.
Please, immediately.
8C ಗೆ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಇಟ್ಕೊಂಡು ಓವರ್ ಸ್ಟೇ ಮಾಡಕ್ ಬಿಟ್ಟಿದ್ದೀರಲ್ಲ. This is why SOP is important.
Please.
The petitioner is before the court on the score that though bail has been.
Your Lordship have it next week. We will discuss with the prosecution department based on this SOP. We will withdraw it and will place it before Your Lordship, Lord, then.
Madi.
But what I have been told is, my lord, Your Lordship's order, Lord, they are constituting a committee on that, my lord.
Oh, I have directed constitution of a committee.
They're into that, my lord. Your Lordship may have this, my lord, next week.
ಅಲ್ಲ ಒಳಗಡೆ because of surety she has not been able to come out. If you take that surety ಕೊಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ I have to release her immediately.
No, Your
And
Lordship,
she is overstaying without permit, without visa.
the entire petition can be closed, my Lord. Your Lordship will have it next week. By that we will discuss with the consent.
ಇಲ್ಲ
Monday, my lord.
we'll send you out, don't worry. ನಾವು ಆಚೆ ಬಂದು ಏನು ಮಾಡ್ಬೇಡಿ ಅಲ್ಲ ಇರಿ ಆರಾಮಾಗಿ.
Wanted to go to my country, my lord.
You want to go to your country, we'll send to your country.
Others, my lord, Your Lordship, wash it, my lord. We let her get a ticket, my lord. We'll send her.
That's what I'm saying.
Instead of that, SOP.
We'll quash it in terms of the SOP you send. Take steps to. Yes.
Send to detention center.
Quash ಮಾಡೋಣ.
Yes, please.
Let him amend the.
Let FRR detention center ಕರ್ಕೊಳ್ಳಿ.
Center.
Detention center ಕರ್ಕೊಂಡ್ಬಿಟ್ಟು ಡಿಪೋರ್ಟ್.
Lord, Your Lordship may direct them to implead us, my lord, so that.
ನೀವು ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
No, my lord.
ಇಲ್ಲ.
ಅವ್ರನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡ್ಬೋಣ. ಮಾಡ್ಬಿಟ್ಟು ನಾಳೆ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
ಸರಿ.
Yes, the learned
Also amend the prayer.
FRRO.
Prayer for quashing.
ನೀವು ಒಂದು ಕೆಲಸ ಮಾಡಿ ಇದು ಕ್ವಾಶಿಂಗ್ ಕೇಳಿ.
ಸರಿ.
ಬರೀ ಮಾಡಿಫಿಕೇಶನ್ ಕೇಳಿದ್ರೆ ಕ್ವಾಶಿಂಗ್ ಕೇಳಿ ನಾಡಿದ್ದು ತಗೊಂತೀನಿ. Implead FRRO as a party. Shanti Bhushan is directed to accept notice for the respondent. 8C is for consumption. 3 ವರ್ಷದಿಂದ ನೀವು ಇಟ್ಕೊಂಡು ಕೂತಿದ್ರೆ ಇಲ್ಲಿ. And she wants to go back. Yes.
Great.
ಈಗಲೇ ಅಮೆಂಡ್ ಮಾಡಿ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಶಾಂತಿ ಭೂಷಣ್ ಸರ್.
Friday.
Huh?
Friday.
Yes.
72.
It has become infectious in view of the fact that alternatively the petitioner had filed a criminal revision petition of 82 of 2025 before the district court, my lords, for recalling the order for cross-examination of PW1. That has been allowed.
ಇದು ಇಲ್ಲೂ ಅದೇ ಕೇಳಿರೋದಾ?
ಇದು ಅದೇ ಕೇಳಿರೋದು.
The learned counsel B. Ramesh appearing for the respondent.
Obtained an order, downloaded the order, my lords. Now it has been allowed.
The entire proceedings question ಕೇಳಿದಾರೆ ಇಲ್ಲಿ.
Allah, my lords, kindly refer to the order dated 27/25. They have restricted their prayer, my lords.
ಹೌದಾ?
ಹೌದು. While passing an interim order.
The coordinate bench of the petitioner is before this court seeking the following prayer. The coordinate bench of this court on 27/2/2025 had passed the following order. The prayer of the petitioner was restricted only to permitting further cross-examination of PW1. The learned counsel B. Ramesh, representing the respondent, would submit that the same prayer was sought before the Court of Session in Criminal Revision Petition 82 of 2025, and the court has passed the following order. In the light of the relief being granted to the petitioner by the revisional court, nothing further would survive for consideration in the hands of this court. The petition is disposed as having become unnecessary. Yes.
Much of.
Next.
73.
Memo for withdrawal.
74.
ನೀವು withdrawal ಬಂದಿದ್ದೀರಾ?
No, my lord, 70.
74.
74. Aging, my lord.
ಯಾರಿಗೆ? ಫೆಬ್ರವರಿ ಆಯ್ತು ಅಂದ ತಕ್ಷಣ ಏಜ್ ಬಂದ್ಬಿಡ್ತಾ ವಾಪಸ್. ಎಸ್.
my lord, the ECIR is predicated, my lord, on two cases. Both of them have been stayed by this honorable court. And my lord, something more is that both the cases have been filed by banks and both the banks have been settled. My lord, your lordships, my lord, I recall in one of the cases, my lords expressed that this tendency of banks, my lord, filing criminal cases for cross-roaded recovery, my lord, it should be stopped.
No, that, what are you here for now?
Well, I am, my lord, the petitioner. I have been, my lord, arraigned as, my lord, an accused in the ECIR. Because, my lord, I am the accused, my lord, in the predicate
One
cases.
moment. I remember having passed some order in
Yes,
this.
my lord, your lordships have, my lord, stayed both the cases.
Where is that?
My
No,
lordship
no,
kindly, your lordships would
orders
kindly
kodi nandu.
page, my lord, 50.
Rahul, where is Rahul Reddy? CBI.
First order, my lord, is on page number 27. And my lord's order is, your lordships would kindly have page number 27, my lord, the first order, where your lordships, my lord, state.
I have posted it on what date?
15/4, my lord.
15/4. Astral ಏನ್ urgency ನಿಮ್ಗೆ?
My lords, ECIR has summon is issued, my lords.
So what, Astral, what urgency? Everything will be closed here.
My
That
lords,
is precisely why I have granted time to him.
I both on.
Then?
Only thing we have issued only summons.
Correct. Why do you want to frustrate everything when I have directed not, no, nobody should frustrate this.
And OTS done
Rahul
accepted.
Reddy had appeared in that case.
OTS done accepted. My lord, OTS done accepted. Where is the proceeds of
wait.
crime, my lord?
My lords,
In case of
Loan
OTS
amount till proceeds. Wait till 15/4 at least. What is all this?
my lords, only request is, my lords, let it be pending, my lords. We have summoned.
I am not disposing this.
My lords,
madam.
on 5th, we have asked her to come. She has appeared. After that, we have not issued any further notice to
No
her.
problem. Yes. The heard the learned senior counsel, MS Shyam Sundar, appearing for the petitioner. The subject petition challenges summons, which is an offshoot of the two proceedings pending before the court. In one proceeding, after hearing the parties, this court passed the following order, page 27. 6 weeks time is granted for the bank to accept the one-time settlement or otherwise. And if nothing would come about in those 6 weeks, the matter would be heard on its merit is what is indicated. In the interregnum, it transpires that the ECIR is registered and summons are being issued to the petitioners. Therefore, in the light of the aforequoted order, which directed that it was directed that any proceeding should not be taken that would frustrate the settlement that is pending between the bank and the petitioner, the enforcement directorate will have to hold its hands in the peculiar facts of this case. Therefore, there shall be an interim order of stay of further proceedings pursuant to the ECIR in the light of the aforequoted order till the next date of hearing. Tag this petition along with, we'll tag everything here on that day.
Let it come on that date.
That day, it will come on that day. Tag this petition at page 27, list on 15/4. Rahul, ನೀವಿಲ್ಲಲ್ಲ ಇದರಲ್ಲಿ? ಮೇನ್ ಕೇಸ್ ನಿಮ್ದೇ ಅಲ್ವಾ? ನಿಮ್ ಕೇಳಿ ಲೆಂದಿ ಆರ್ಡರ್ ಮಾಡಿದೀನಿ ನಾನು. ಬ್ಯಾಂಕ್ ಕೊಡ್ತಾ ಇದಾರೆ ದುಡ್ಡು ಅಷ್ಟರಲ್ಲಿ.
Proceeds of crime, my lord, it's being, my lord, extended.
ಈಗ ಲೋನ್ ಕ್ಲಿಯರ್ ಮಾಡಿ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆದ್ರೆ, where is the?
My lords, they have diverted this fund somewhere else. That is what we are investigating.
I will see. Wait, if nothing is happening, I will answer that on merits.
Please.
Then you can definitely.
In one of the cases, my lord, I remember, if, my lord, diversion of funds, my lord, using of the funds for non-designated purpose,
Diversion of funds, CBI has come in. Bank has complained to the CBI.
I understand that. This
we are
tendency has
settling
to go. Just because, my lord, the nationalized banks can file complaint directly with the CBI.
No, that is the RBI.
This is happening.
Our ECIR is independent of CBI's.
He's learnt everything.
I don't digest this Anuparna Bordolai, madam.
She's being with the ASG, she's learnt.
I understand that, my lord. At least, my lord, Anuparna Bordolai, madam, should not be saying this.
Why?
My lord, in fact,
has some restriction.
My lord, she's on the other side, my lord, at least in 80% of the cases.
East side?
Yes.
Now I am this side, my lord.
She is rowing our boat, my lord, many times.
All right. Yes.
Greatly obliged. And the office objection and non-filing of ECIR could kindly be dispensed.
Why?
We don't have that document. There is, my lord.
What summons matra challenge ಮಾಡಿ.
ಹೌದು ಅಲ್ಲ ECIR also, my lord, but we don't have a copy of the ECIR. They don't give it.
ಅವರೇ ಕೊಡ್ತಾರೆ.
Greatly.
ತಗೊಳ್ಳಿ. digital arrest.
List number 2.
L. Suraj. Francis is here.
He was here. But in the meanwhile, what happens is, if my lords reconnect the order on the last date, because of this case, my lord, before the small cause court, I want to travel abroad for a job. The police don't give me a clear, in the police verification report, this case pops up, because of which the passport authorities would then keep my passport in safe custody, give me a surrender certificate. Under those circumstances, my lords, on the last date on 20th February would say, learned additional SPP appearing for the respondent state submits that police clearance certificate would be issued in accordance with law, not
ಒಂದು ಲೆಟರ್ ಕೊಡಕ್ಕೂ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ?
ಅಲ್ಲ ಏನು ಕಮ್ಯುನಿಕೇಟ್ ಮಾಡಿಲ್ವಾ ನೀವು?
ಅಲ್ಲ, we have given the certified copy
of this order.
Of this order.
ನೀವು ಒಂದು ರಿಕ್ವಿಸಿಷನ್ ಕೊಡಕ್ಕೆ ಏನ್ ಜೊತೆಗೆ?
ಅದೇ we went there, my lord. They don't give us any acknowledgement.
ರಿಕ್ವಿಸಿಷನ್ ಕೊಡಿ ಸರ್, ಕೊಡ್ತಾರೆ. ಈಗ ಕೊಡಿ, ಬೆಳಗ್ಗೆ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ,
ಇವತ್ತೇ ಕೊಡ್ಲಿ, ಬೆಳಗ್ಗೆನೆ ಕೊಡಿಸ್ತೀವಿ.
ಅದೇ ಇವತ್ತು ಕೊಡಿ, ಬೆಳಗ್ಗೆ ನಿಮಗೆ ಸಿಗುತ್ತೆ PCC.
ಅಲ್ಲ, they need to give a, they have given an adverse police verification report.
They will give you what is to be given in terms of this order.
Please, my lord.
But you should give some requisition.
We did, my lords. ಅದಕ್ಕೆ acknowledgement
ದೂರನ ಇರ್ತಾರೆ, ಹೇಳ್ತಾರೆ ಅಲ್ಲಿ ರಿಕ್ವಿಸಿಷನ್ ಬರ್ಲಿ ಅಂತಾರೆ.
Acknowledgement ಇಲ್ಲ ನನಗೆ ಅಷ್ಟೇ. I have given it.
Let him give and let him send a copy and I'll get it done.
ಅಷ್ಟೇ ಆಯ್ತಲ್ಲ.
And accordingly, then the regional passport officer must return the passport with a clear PCC.
That when Shanti Bhushan says that, don't worry about it.
Because I mean, my lords, on 2nd I was supposed to report for my job. Now I missed that bus. I've managed to convince them to hold on, and
you don't worry. Tomorrow I'll take this on Friday. By then you will get your PCC. You PCC copy na you kodi.
Please
copy kodbodalla. Please copy kodi. He will take further steps.
Let him produce before the
regional passport officer kodi. He would have informed.
First I'll give the requisition to the police.
Requisition to the police. Take PCC. Go before the RPO.
They will directly send it, my lord, to the RPO.
Whatever.
They will not give it to my hand. They will directly give it.
Whatever.
Let them send it, my lord. The moment it is reached,
when he says it will be done, it will be done.
100%.
Yes.
That was my immediate grievance for which I moved this matter also, my lords.
Main matter, you're not interested.
Illa.
My lord, in this case, my lord, I am permitted to. Today, Mr. Ravishankar, senior counsellor, to appear. He is in election campaign.
ಎಂಗೇಜ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು.
ಯಾರನ್ನ?
ರವಿಶಂಕರ್.
ಅವರು ಎಲೆಕ್ಷನ್ ಇದ್ದಾರಾ?
ಎಲೆಕ್ಷನ್ ಕ್ಯಾಂಪೇನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಆಯ್ತು.
ಐ ರಿಕ್ವೆಸ್ಟೆಡ್ ಹಿಮ್, ಯು ಟೋಲ್ಡ್.
ಬೇಡ ಇವತ್ತೇನ್ ನಾವೇನ್ ತೊಂದರೆ ಕೊಡಲ್ಲ.
ಅಲ್ಲಿ ಕ್ಯಾನ್ವಾಸ್ ನಾನು ಕಲರ್ ಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ದೀನಿ ಫ್ರಾನ್ಸಿಸ್, ಯು ಪ್ಲೀಸ್.
ಇವತ್ತೇನ್ ತೊಂದರೆ ಕೊಡಲ್ಲ.
May I pass on the timeline of key events, my lord?
ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ.
My lord, in this case, my lord, we will file a detailed objection.
ಅದೇನ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದ್ರೆ ಸಾಕು. ಡೀಟೇಲ್, ನಾನ್ ಡೀಟೇಲ್ ಅವೆಲ್ಲ.
No lapses in our part in this matter. Lord, she had it, my lord,
Francis, you tell me, a person comes to your bank for housing loan, 5 lakhs, 10 lakhs, 15 lakhs. You make him roam from pillar to post for those 10 lakhs. For that document you get, this document you get. Digitally, you bank officials sit there.
we are not sitting, my lord.
Allah,
There is
whoever it
confusion in this matter.
ಯಾರ ಬ್ಯಾಂಕ್ ಇಂದ ದುಡ್ಡು ಹೋಗಿರೋದು?
My lord, in this matter, my lord.
ಯಾರ ಬ್ಯಾಂಕ್ ಇಂದ ದುಡ್ಡು ಹೋಗಿರೋದು?
My lord, these he has taken. My lord, that is the.
No. Let me complete. See, in this, he is made to sit in. He or she either. She is made to sit before the system, saying that you will get money. Anybody getting money free of anything will definitely get interested. 2 hours only. You sanction 50 lakhs. From where did that 50 lakhs come into the coffers of the petitioner?
Yes, my lord.
On paper, she doesn't get it at all.
Yes, my lord.
Those people direct to create a beneficiary.
No, we have not directed to create beneficiary, my lord. That is the confusion. My lord, here in the case, my lord, it is a pre-approved law.
I'll tell you, without the connivance of the officials of the bank, nothing of this sort can happen. This is precisely why it has become a pan-India problem, not a local problem.
Yes, my lord.
Because it has become a pan-India problem, CBI must intervene in this.
My lord, in this matter, my lord, my lord, the house system is, my lord. She is drawing a salary around 4 lakhs.
All
My lord,
right.
she is eligible for the pre-approved loan. That will be notified to her. If she is login iMobile, my lord.
Yo,
she
2
will-
hours only you give loan?
That's what, my lord. If you log in, my lord, if you log in iMobile, once again, sir.
Not even 2
Wait,
hours.
If I log in, my lord, if I log in my iMobile, there could be a notification that you are entitled for the pre-approved loan based on your financial credits. My lord, she is having the accounts nearly from 7 years, 6 years. She is an IT employee. Drawing is CCR financial credit worthiness is eligible for her to take the pre-approved loan. My lord, see, my lord.
So 50 laksha loan pre-approved, you give it to anybody?
My lord,
Looking at salary.
based on the financial credit worthiness and their salary and their income.
And how do you expect the return?
My lord, the return, my lord, the return, it is an unsecured loan, my lord.
Exactly.
Exactly, my lord.
Unsecured
My lord,
loan, public money.
Yes, my lord.
You 50 lakshas.
I will come to that point. My lord, in this case, my lord, after that, my lord, once she log in the iMobile, my lord, there is a process. Step 1, steps 2, steps 3, steps 4.
Correct.
My lord, she has to enter her OTP and whatever the requisite the data. My lord, it will take to the next step.
I thought pre-approved. The money came into your coffer, Suraj?
Yes, my lord.
Money came to you.
Yes, my lord.
It went away immediately.
Illa, allene. It has.
Lords may take the timeline, Lords. I produced all with the documents. It's not that I'm just talking there. It's with
11:15 a.m.
is when they asked me to take a screenshot of my bank balance. That's when the fraudsters get to know I have no money. I am not somebody who has money to give them the money. So what they then tell me is there is a pre-approved loan. So that, my lords,
at 12:11 p.m.
I've already got the money. By 12:11, at 11:15.
ಇಲ್ಲ ಅದನ್ನೇ ಸ್ಟೋರಿ ಅವರು ಅದಕ್ಕೆ ಮೊದಲೇ ಒಂದು ಸ್ಟೋರಿ ಇದೆ ಸ್ವಾಮಿ ಇಲ್ಲಿ
ನೋಡಿ ಮುಂದೆ ನೋಡಿ.
once again permitted to place this.
Page 6, my lords. Page 6 is the document. Congratulations, 12:11 p.m. I have produced the document also. 49 lakhs is credited to my account.
Yes.
So then, my lords, merci. If my lords comes to serial number 17, 657, I add a payee Nitin. The corresponding document.
Who is that?
That is some unknown person who the fraudsters make me add. That, my lords.
How much you transfer?
Page 12 email also I received from the bank 6:57 p.m.
That is where I'm concerned.
Yes, my lord.
Everything is from the bank.
Please the next page, my lords. Within 1 minute 20 lakhs, my lords. If I have to receive fee from a client, they say 24 hours, you have to wait 30 minutes, beneficiary. Only 1 minute till 20 lakhs is transferred to somebody. Can that be done, my lords? Any RBI guidelines itself do not allow for that.
My lord, in this case, my lord, in this what my learned friend is placing before the court is what exactly contrary to the transaction taken place. My lord, prior to disbursement of the money, my lord, several processes have to be undertaken.
Well, 1 minute till you undertake the process.
One second. My lord, the first she has to log in or the password. And my lord, there are steps, my lord.
Yeah, you're talking as though it takes days to get money. It does take days.
My lord,
if a man goes for housing loan, it takes days.
Yes, my lord, I agree, my lord. In this process, my lord,
You barter public money.
After dispersal, my lord, the money was credited to the SP account of the customer. My lord, initially she transferred 2 lakhs to her own account, HDFC bank account. When the money loan has been dispersed to her SBI, the account, she transferred 2 lakhs to her own account, HDFC bank account.
All to gain my confidence,
I will place all the documents.
Fraudsters would tell me, please transfer to your own account.
No, I am only trying to get to know the involvement of the bank, if it is there.
Yes, my lord.
If involvement of the bank is prima facie found in these cases, CBI will step in.
Yes, my lord. My lord, secondly, my lord, one more submission I permitted to me. Secondly, my lord, he tried to transfer 10 lakhs. My lord, she failed 3 attempts. My lord, she herself has called the customer care. Customer care, to added the beneficiary. Upon adding the beneficiary, she tried to send some 10 lakhs. Those attempts were failed. Then she herself has called the customer care. My lord, permitted to transfer the money. Customer care, my lord, asked her what purpose you are transferring the money. My lord, she told it is relating to property purchase and requested the customer care to add the beneficiary, permitted her to transfer the money. Then thereafter, my lord,
put it on paper.
Yes, thereafter, my lord, we permitted her to where transferred 10 lakhs. 19 lakhs, my lord, she is telling that she has been digitally arrested. 19 lakhs, 79 to 2024, the journey has started. 89 2024, my lord, 19 lakhs has been transferred from Calcutta. See, from Bangalore, my lord, she first started at Bangalore. 89, she is telling that she was at Calcutta. At least by that time, she could have intimated some nearest and dearest, stating that, my lord, they have been digitally arrested. My lord, RBI, my lord, we are also cautioning each and every notification. Even RBI, we are also getting notification, RBI notification. See, that is not our case that she has not the login or iMobile and all the credential, requisite credential in this matter.
Let's see, put it on paper.
I will put it in the paper.
Milords, in fact, in the documents that I produced today, a retired judge, Milords, over a course of 10 days would lose 1.6
Delhi High Court recently, my lord, in a similar matter, has passed an order. Delhi High
In
Court.
several instances, it has lasted a week, 10 days, etc. In this case, it is
Even
it spills over to the next day. It is 2 days.
RBI has framed a draft notification. My lord, in this draft.
Let him file his objection.
Yes, my lord.
None of this is there in their private complaint. My lords will then also see
We'll
the
see.
private complaint.
He will place all the
Let
documents.
him place whatever he wants to
Yes, my lord.
place. Yes.
My lord, the RBI's zero liability, which they are claiming, my lord, the sections of clause 7, there is a negligence on the part of the customer. I will put it.
You file your objection.
I will file my objection in this matter.
We'll take it on 27th. By then you file your
I will.
objection.
Much obliged.
It's on 27th at 4 p.m.
Much obliged.
I request that something comes in the order because again, the police shouldn't trouble me tomorrow when I
Hey,
go
who
and
is
give
troubling you now?
the police, Milords.
Why, sir?
They were.
Give a request. First of all, you don't want to give a request.
ಇದಕ್ಕೆ ಫಸ್ಟ್ ನೀವು ಇದಕ್ಕ
ಕೊಟ್ಟಿದ್ದೀವಿ.
PCC ಗ ಕೊಡಿ ಫಸ್ಟ್
At least police ಒಂದು at least
He expects prosecutor to sit in the police station and get it clear.
Not that.
ನೀವು ಫಸ್ಟ್ ಇವತ್ತು ಸಾಯಂಕಾಲ give a requisition, tomorrow you will get it.
Milords, my itinerary, I'd already filed an undertaking affidavit in terms of my lord's
You
order.
first file it, sir. When are you leaving?
Now again depends on when they give it to me.
Now you can't go anywhere.
That is my situation, Milords. I don't have my passport. I
That's
don't.
the situation everywhere. We'll take it on Friday.
But I'm supposed to go to Europe, not to anywhere near Middle East.
So you travel to the pole, not on the sea. Yes. Yes, Jagdish sir. Friday ತಗೊಳ್ಳ?
ಆಗ್ಬೋದಲ್ಲ? I will get it. But the only issue is that my learned friend should not expect me to be sitting in the police station. With police clearance. I get a call saying that are you in police station? The police are not acting. Why should I be sitting in
Oh
police
no, don't do all that. Give a requisition, he would have informed. That's all. Yes.
27th.
27th.
Much obliged.
Friday for this, Milords.
Friday for travel thing.
Travel.
Yes.
Much obliged.
ನಿಮಗೆ 27th ವರೆಗೂ ಟೈಮ್ ಲಿಸ್ಟ್ ಫ್ರೈಡೆ ಅವತ್ತು 27th ಹಾಕ್ತೀನಿ.
Much.
Intermortem may be expected.
Intermortem subsisting will continue.
Much obliged.
Next matter, seal number 1, Shri Vijay Kumar.
This case
Settlement
ಅಂದ್ರೆ ಇದು 120 189 189 class 2 191 class 2 191 3 matter is settled there is also friends due to
Friends
friends ಗಲಾಟೆ
attempt to murder friends ಬರೋಲ್ಲ.
ಆಕ್ಚುಲಿ ಅದು ಆಗಿಲ್ಲ ಬಟ್ ಸ್ವಲ್ಪ ಬುದ್ಧಿ ಕಲಿಸ್ಬೇಕಂತ ಹೇಳಿ ಈ ರೀತಿ
ಬುದ್ಧಿ ಕಲಿಸ್ಬೇಕು ಅಂತ
ಇದೆ ಅಷ್ಟೇ, ಬೇರೆ ಉದ್ದೇಶ. ದೇರ್ ವಾಸ್ ನೋ ಎನಿ ಸ್ಮಾಲ್ ಇಂಜುರಿ ಆನ್ ದಿ ಹೆಡ್.
ಸ್ಮಾಲ್ ಇಂಜುರಿ ಆನ್ ದಿ ಹೆಡ್.
ಬಂದಿದ್ದಾರೆ ಅವರು, ಆಲ್ ಆರ್ ಪ್ರೆಸೆಂಟ್ ಬಿಫೋರ್ ದಿ ಕೋರ್ಟ್. ಕಂಪ್ಲೇಂಟ್ ಅಂಡ್ ದಿ ಅಕ್ಯೂಸ್ ಆಲ್ ದೇರ್.
Jagdish sir, small injury on the head, attempt to murder. Settlement.
Headman. Injury.
ಎಲ್ಲಿದೆ wound certificate?
Wound certificate police ನಾನು.
I'll secure wound.
Secure the wound certificate. Friday 4 p.m. to report settlement. Learned additional SPP shall secure the wound certificate. Grievous wounds ಇದ್ರೆ ಇಲ್ಲ.
ಆಯ್ತು. grievous ವಕಲ.
ಫೀಲ್ ಬೇಡ, ರಿಜಿಸ್ಟ್ರಿ ಹಾಕಿ ಬರುತ್ತೆ.
Friday.
Yes, Swaroop.
Seal number 2, Swaroop S.
Seal number 2 to 16.
Allegation is that I have not paid the PF, my lords, but entire amount has been paid. I'm producing it along with a memo.
All are identical?
All are identical, my lords. Same.
What is under challenge? Proclamation?
Proclamation, my lords. Entire amount has been cleared.
To whom?
To the PF officer, my lords. PF authority. Small amounts, my lords, but I have cleared everything. There was some delay for which complaint has.
When you will appear before the court?
My lords, it may be stayed for now.
No stay, I will dispose it.
Kindly.
You appear on the next date.
Kindly. See here, I'll keep him present before this honorable.
In settlement ಇದ?
My lords, our settle ಮಾಡ್ಕೊಳ್ಳೋರು ಯಾಕಂದ್ರೆ they're government officials.
Settle ಮಾಡ್ಕೊಳಂಗಿಲ್ಲ, you can't do that.
Kindly.
Now, the matter is pending before the court.
Kindly.
Now you are here on proclamation.
Kindly.
I will set aside the proclamation, subject to the condition that you appear before the court. There I will record this also.
Kindly.
The court will pass necessary orders.
So the only the issue is that the amount has not been paid. Now it has been paid.
ಇಲ್ಲ paid ಅಂತಾನೆ ಹೇಳ್ತೀನಿ.
Kindly.
ಹೇಳಿ, the court will record that. If there is anything, you come back.
Kindly. We are avoiding an order of conviction. I mean, that
No,
is,
that's why
never.
conviction cannot happen in the light of this order.
Kindly.
The petitioner is before, in all these, the
ಇನ್ನೆರಡು ಇದೆ, ಅದು ಎರಡು ಬಂದಿಲ್ಲ ನಂಬರ್.
ಆಯ್ತು, ನಾಳೆಗೆ ಹಾಕೋಣ.
ಅನ್ನ
The petitioner is common, huh?
ಎಲ್ಲ all same petitions.
The petitioner in all these cases.
Petitioners.
ಗುಲಾಂ ಮುಸ್ತಫಾನ ಇವರು ಕೊಡಲ್ಲ ಬಿಡಿ.
ಪೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಈ ಕೇಸ್.
ಇವ್ರನ್ನ ನಾವು 2022 GM ಕೂತಾಗಿಂದಾನು ನೋಡ್ತಾ ಇದ್ದೀವಿ.
ಗೊತ್ತಾಯ್ತು. I appeared in multiple matters before. Your but they paid, my lords. I produced the receipts. In this case, there's no bother.
Gulam Mustafa will not pay.
They paid, my lords. In this case,
ಮಾಡಿದ್ದೀರಾ?
Those are the receipts which I just paid.
Anyway, the petitioners in all these cases are common. The prayer is common. As the concerned court in PCR 29, in CC 1087 of 2025 has issued proclamation against these petitioners on the score that they have not appeared before the concerned court, and the issue was with regard to payment of provident fund amounts to the employees. The enforcement officer has registered the crime, and the proceedings are set into motion thereon. The learned counsel for the petitioners places on record the payment confirmation receipt of payment of provident fund amount to all its employees. Therefore, it is for the petitioner to place this material before the concerned court in CC 1087 of 2025. It is needless to observe that the concerned court will take note of the documents and pass necessary orders thereon. The issue of next date in. The petitioner shall appear before the concerned court on the next date of listing.
6/3 to some. I'll just find out what.
And the next date of listing, subject to the said condition, proclamation of any kind hanging on the head of the petitioner shall stand obliterated. In the event the petitioner would not appear before the concerned court on the next date, the proclamation orders would stand revived.
Just avoiding the order of conviction, if any direction could be passed to close the matter based.
Close antilla. The concerned court shall, before rendering its order, the concerned court before rendering its order shall take note of the payment that is said to have been done by the petitioner to all its employees and pass orders thereon. This should protect you. Yes. I can't stay conviction kodbedi anta.
I understand.
Yes. Same order. You want separate orders?
My lords, in one petition, if everything could be
ಆಗುತ್ತೆ ಅಲ್ಲ?
disposed of, ಇನ್ನೊಂದು ಎರಡು ನಂಬರ್ ಬರ್ದು ಕೊಟ್ಟಿರ್ತೇನೆ.
ಆಯ್ತು ಕೊಡಿ, ಅಲ್ಲ ಕಾಮನ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ.
Kindly, two petitions.
ಆಯ್ತು ಸೆಪರೇಟ್. Yes.
Admission 17.
Radhika. For withdrawal.
Yes, Your Lordship.
Why, madam?
No, to challenge the charge sheet. Your
Please do. Permitted.
Much obliged.
Charge sheet format.
18. Gautam Simla. Gautam Dev Simla.
ಸೆಟ್ಲ್ ಆಯ್ತಾ? ಅಬ್ಬಾ, ಬೆಲ್ ರಿಂಗ್ ಮಾಡ್ಲಿಲ್ವಾ? ಆಮೇಲಿಂದ ಬೆಲ್ ರಿಂಗ್ ಮಾಡಿಲ್ವಾ? ಓ, ನಿಮ್ಗೆ ಗೊತ್ತಾಗಲ್ಲ ಬಿಡಿ. ಇವ್ರ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದ್ದಿದ್ದು ದಟ್ ಲೇಡಿ ಮನೆಗೆ ಹೋಗಿ ಬೆಲ್ ರಿಂಗ್ ಮಾಡ್ತಾ ಇದ್ರು ಅವಾಗ.
ಇಲ್ಲ ಅದಲ್ಲ, ಇದು ಬೇರೆ ಮ್ಯಾಟರ್.
ಅದು 18 ಅದೇನೆ.
My lord, there is some wrong tag ಆಗಿದೆ. ಕೆಲವು ಮ್ಯಾಟರ್ we have not settled. Some, my lord, we are now.
ಮೈಲಾರಪ್ಪ ಅಂತಿದೆ ಇಲ್ಲಿ.
ಇಲ್ಲ, we are concerned about 18.2.
ಸೇಮ್ ಕ್ರೈಮ್ ಇದು.
ಇಲ್ಲ, ಬೇರೆ ಕ್ರೈಮ್. There is a mistake, my lord, while tagging.
ಅದು ಟ್ಯಾಗ್ ಆಗಿರೋದು ಮಿಸ್ಟೇಕ್.
18.2, 18.3.
ಅಫೆನ್ಸ್ ಏನು?
My lord, 420.
ಇವ್ರದ್ದು 420 ಅಲ್ಲ ಬಿಡಿ,
ಅಲ್ಲ.
ಅವ್ರದ್ದು 354A
Yes, ma'am.
ರಾಂಗ್ ಆಗಿ ಟ್ಯಾಗ್ ಆಗ್ಬಿಟ್ಟಿದೆ.
Wrong tag. 8, my lord, now.
T-link 18.1, 2, 3, 4, 5 ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ?
ಅಲ್ಲ, 18.2, 18.3, 18.7, 18.8 and 18.12, my lord, have been settled. Entire crime number, my lord, 444 of
ಓ ಮೇಡಮ್, ಇದೆಲ್ಲ ಬೇರೆ ಎಲ್ಲ ಮೈಲಾರ ಪದ್ ಸೇರ್ಕೊಂಡ್ಬಿಟ್ಟಿದೆ ಇದರಲ್ಲಿ. ಅದು ಡೀಲಿಂಕ್ ಆಗ್ಬೇಕೆಲ್ಲ. ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ. ಈ ನಂಬರ್ ಬರ್ಕೊಡಿ ಯಾವ್ಯಾವ ಸೆಟ್ಲ್ ಆಗಿದೆ. 420. What is it? 420? 425. Yes.
I will give the number.
ಅವ್ರು ಇದಾರಲ್ಲ ಅಂತ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟ್ರಾ.
ಹಾ?
ಅವ್ರು ಇದಾರಲ್ಲ ಅಂತ ಸ್ವಲ್ಪ ಎಕ್ಸ್ಟ್ರಾ ಆಗಿದೆ ಅಷ್ಟೇ.
ಬಿಪಿನ್ ಅದಕ್ಕೆ ಬೆಲ್ ರಿಂಗ್ ಆಗ್ತಾ ಇದೆ. ನಾವು ಬೆಲ್ ರಿಂಗ್ ಮಾಡಿದಿಲ್ಲ. ಎಸ್.
Give the number.
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಲ್ಲಿದೆ?
My lord, we have
Parties are present?
Parties are present.
ಎಲ್ಲ ಸಿಗ್ನೇಚರ್ಸ್ ಮಾಡಿ.
My lord, accused A1 and A2 are present, my lord, others are not, but complainant is present.
Complainant and accused, yes. ಬರ್ಕೊಡ್ತಾರೆ. ಅದು ಯಾವ್ಯಾವ್ದು ಅಂತ ಬರ್ಕೊಡಿ.
I will write and give it, hand it over.
Order sheet signatures.
Yes, next.
19, Hari Prasad withdrawal memo.
Withdrawal in terms of.
20, Saravana X, B group.
Settlement 26 ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ.
One reporting settlement. 84.
Offense 354A, Lordship. Both of these, if they are close relatives, so due to some misunderstanding, the complaint was lodged between the family.
Both are present?
Both are present.
Good. Warrant counsel so and so enters appearance. ಮಿಕ್ಕಿದೆಲ್ಲ ಮಾಡ್ಕೊಂಡು ಒಂದು ಪ್ಯಾರಾ ಎಲ್ಲದರಲ್ಲೂ ಹಾಕ್ಬೇಕು. Parties are present before the court and are identified by the respective learned counsel. ಅದೆಲ್ಲದರಲ್ಲೂ ಹಾಕ್ಬಿಟ್ಟು. ಎಸ್.
ನೋಟಿಸು ಆಗಿಲ್ಲ ಮೈಲಾಡಿ.
Order sheet signatures.
ನೀವು ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
84 ದಲ್ಲಿ.
ಮಾಡ್ಕೊಳ್ಳಿ ಬಿಡಿ. ಸೆಟ್ಲ್ ಮಾಡ್ಕೋಬಾರ್ದು ಅಂತಿದೆ.
ಆಗ್ಬೋದು.
354.
ಆಗ್ಬೋದು.
ಅದು ಗವರ್ಮೆಂಟ್ ಲರ್ನೆಡ್ so and so accepts notice ಅಂತ ಮಾಡಿ registry to print the name of learned HCGP ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಕ್ಲೋಸ್ ಮಾಡಿ. Yes.
85, order sheet signatures.
Madam.
Offense.
Offense 314 and 316(5) of BNS, my lords, and
314.
314 and
What is that?
dispute between employer and employee. The principal allegation is he had sent an email from his official email ID to a competitor company, my lords. Now they have settled the matter.
314, 315 ಏನದು? Earlier
316(5) is criminal breach of trust by public servant.
ಅಷ್ಟೇನಾ? Yes.
Parties are present.
ಆಯ್ತು.
ಡೇಟಾ ಥೆಫ್ಟ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರು, ಬಟ್ ಇಟ್ಸ್ ನಾಟ್ ಡೇಟಾ ಥೆಫ್ಟ್. ಅಪ್ರಿಸಿಯೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ನ ಅವರುಂಟು.
Yes, so and so. Present, same. Yes. Next.
Order sheet signatures.
ಅಷ್ಟೇನಾ?
Just continue.
ಯಾವ್ದಿದು?
Hearing on IA 75.
ಅಲ್ಲಿ
Petitioner is not a the allegation against the petitioner is that designs were copied, my lords. Counterfeit products were created of design protected.
Offense ಏನು?
My lords, punishable under section 420, 120B and 34, my lords.
What design products?
My lords, so the allegation in the complaint is that the company, the complainant company, my lords, had certain products which were helical gear systems, my lords, which was
Gases.
Gears. My lords, this was protected under a designs certificate, which is produced in page number 70, my lords. It's Chachi.
ಅಷ್ಟೇ ಇದೆಯಾ?
There is an interim order.
There are connected matters, my
ಕೊಡಿ,
lord.
ಎಲ್ಲ ಕೊಡಿ.
The 4 cases, charge sheet is challenged.
My lord, charge is under section 22 of Designs Act, which is a civil remedy. my lord.
Patent Act is also there, criminal offences 420
My lord,
and
if I may
other
submit.
manipulation of documents, all those are.
My lord, if I may submit, designs, what is defined as design is what is not a copyright, what is not a trademark, what is not a, et cetera, et cetera. Section 22 of Designs Act gives for a civil remedy. my lords. It talks about, it says that if there is any contravention.
ಆಯ್ತು, connected matters ಕೊಡಿ, ಯಾವ್ದು?
What is in some? There are other 4 matters, my lord. Kindly fix the date.
Tag these petitions, list them on Wednesday, madam, 25th.
Much of.
List on 25th for admission, along with any application that is pending.
And connected matters.
Connected, ಎಲ್ಲ. It will come in admission.
Much of.
Sirajuddin,
76
Yes, my lordship.
for the victim, your lordship.
Give me a short date, my lordship.
recalling the order.
Yes, your lordship.
ಈಗ what is happening, ಈಗ ಕ್ವಾಶ್ ಮಾಡ್ಬಿಟ್ಟಿದೀವಾ?
ಆಗ್ಬಿಟ್ಟಿದೆ ಲಾರ್ಡ್ಶಿಪ್. ಕಂಪ್ಲೇನೆಂಟ್ ಮತ್ತೆ ಅಕ್ಯೂಸ್ಡ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿರೋದು. ನನ್ಗೆ ಯಾವ್ದೇ ತರದ
Offense ಏನು?
ಇನ್ಫಾರ್ಮೇಶನ್ ಗ್ರೀವಿಯಸ್ ಹರ್ಟ್, your lordship.
ಹೌದಾ?
Offenses under 115 clause 2, 126
Oh,
clause 2, 3.
not, is it an order by me?
No, your lordship.
Grievous hurt ಅಲ್ಲ ನಾನು ಹೆಂಗ್ ಮಾಡಿದೆ ಅಂತ ನಾನೇ ಯೋಚನೆ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. It's not my order.
My lordship, ಇದೆಲ್ಲ family dispute, my lordship.
Family grievous hurt ಮಾಡ್ಬೋದಾ? And without making the victim a party, how did you get it quashed by settlement? Should not the victim be made a party? The coordinate bench has closed this. Till nonetheless order. Grievous hurt. 118.
Wound certificate ಇದೆ ಲಾರ್ಡ್ಶಿಪ್ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ. ಆರ್ಡರ್ ಕೃಷ್ಣ ಕುಮಾರ್.
Wound certificate ಎಲ್ಲಿದೆಯಮ್ಮ?
ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಇದೆ.
Injury number 1 is grievous. Fracture upper shaft. ಒಂದು grievous ಇದೆ. But ಅಲೀಜ್ ಮಾಡಿರೋದು 115, 324 ಇಲ್ಲ? ಇಲ್ಲಿದೆ ಇಲ್ಲಿ grievous hurt. Anyway, let her be heard in the matter.
On short date,
I'll take it on Tuesday.
Sure.
List on Tuesday for admission, recalling ಅಲ್ವಾ ಇದು? In the same stage ಬರ್ಲಿ.
Great.
Grateful.
Yes, next. ಇದು recalling.
77.
Who has filed his application?
This was disposed of, my lords, in pursuance of, my lords, the affidavit filed by us.
Ah.
The complainant, my lords, son, my lords, the one who has made an investment, my lords, online. My lords, subsequently, my lords, one person.
Where is the file ಕೊಡಿ madam? File ಕೊಡಿ. File order sheet ಕೊಡಿ.
Lordship, I recall, my lord, and I said that multiple.
ಅದೇ ಬೇರೆಯವ್ರದೆಲ್ಲ ಮಾಡ್ಬೇಕು ಅಂತ.
In fact, I've been told that even this person is also not been.
Lords, it's been persuaded, my lords, by
One minute, order sheet sign ಮಾಡಿದ್ರಾ?
No, my lords.
You move ಮಾಡ್ಬೇಕಾದ್ರೆ you said order sheet is signed?
My lords, it is
Day
not.
before yesterday when you moved the matter, you said, I asked you,
No, my lords. I
order
said
sheet sign ಆಗಿದೆಯಾ ಅಂತ. You said order sheet is signed.
No, I said it's not signed.
Sir, you are live, sir.
No, my lords, it's not signed, my lords. That was
You,
mistake that day also.
you said order sheet is signed.
No, my lords, it's not signed, my lords. That's
ಸ್ವಲ್ಪ
what the submission I made.
ಹೋಗ್ಬಿಟ್ಟು ಆಫೀಸ್ಗೆ ರಿವೈಂಡ್ ಮಾಡಿ ನೋಡಿ what you have said ಅಂತ. You said order sheet is signed.
Lord, before moving itself, my lords, I verified, my lords, it's not signed, my lords. That's what the submission.
Why
I made.
did you make a submission like that?
My lords, I'm sorry, my lords. If in case.
I don't forget, sir. Yes.
I think order sheet is signed, my lord, if I'm
My
correct.
lords, that
Order
day-
sheet is signed.
My lords, because.
ಇಲ್ಲ ಇಲ್ಲಿ.
My lords, the matter was disposed of, my lords, not allowed in total. The crime is still alive, my lords. That's the reason, my lords, it is not allowed to be signed.
We'll recall this order.
Please, my lords.
Yes.
The criminal petition was disposed, my lords, not allowed.
The subject petition was disposed on recording. Sign ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್ order sheet ಅಲ್ಲಿ ಇಲ್ಲ. On recording the submissions of the parties that the settlement has been arrived at. The parties to the list have gone out of the court without signing the settlement, signing the order sheet which records the settlement. Therefore, it is not a settlement that, there's not a case where it can be closed by way of the settlement, be on its merit or otherwise. Therefore, the order dated 10th February 2026 solely on the act of the parties to the list who have refused to sign on the order sheet stands recalled.
Please.
Matter be list the matter on 18th in fresh matters list.
Please.
Yes. Yes.
Obliged.
78.
My lords, I appear for the petitioners, my lords. My lords, I seek some extension, my lords. What had happened is after your lordships had set an outer limit of 8 weeks, the learned trial judge had referred the matter for amicable settlement. And thereafter, there was some boundary dispute and a commissioner was appointed. That is why the delay, my lords.
Another 8 weeks, ಮಾಡಿದ್ದೀನಿ 25.
Thereafter, my lords. Thereafter, I had sought one other settlement.
Sir, Chetan, 2711 copy ಮಾಡಿ. This court so and so had passed the following order. Another 8 weeks from today.
Very well, my lords.
Now you take the password. But ಇಲ್ಲಿ sign ಮಾಡುವ. Affidavit sign ಮಾಡಿದಾರಾ? ಅದೇ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ sign ಮಾಡಿಲ್ದಾರೆ recall ಬರ್ಲಿಬೇಕಲ್ಲ. They can't run away like that. Yes, call that password.
Password, Matt.
Hearing for the petitioner, my lords. Petitioners are the victim and the victim's mother, my lord. The statement of the victim recorded by the magistrate.
Now, ಇದರಲ್ಲಿ statement of the victim is not recorded in the presence of the mother in a POCSO proceeding, which the act mandates. Now, we cannot permit it to proceed further on the basis of that evidence, unless I decide.
Lord, even the accused has been granted bail on this ground, my lord. That there is no corroboration between the statement.
How can the court act?
77.
But
the
medical records also state, my lords, that the hymen is stone. There is medical evidence, my lords, to the contrary.
Now, what are you seeking?
I seek re-recording of the.
We will direct. Wait. Let Friday ತಗೊಳ್ಳ Monday ತಗೊಳ್ಳ.
As well as the stay, my lords. Matters.
That I will stay, sir. Wait.
Monday, man.
List the matter on Tuesday ತಗೊಂತೆ. Tuesday ಇದಿರಲ್ಲ. Tuesday fresh matters list. Further proceedings before the concerned court in special case 1188 of 2025 shall remain stayed solely on the score of the folly of the concerned court in recording the statement of the victim in the absence of the mother, which the law mandates otherwise. Yes.
My lord, hand delivery, my lord. Matters listed on 13th.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ ನೋಡಿ. ಚೇತನ್ ಇದೊಂದು ಎಂಟರ್ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಮಾಡು. ಎಸ್
52.
Correspondent number 2 in this case.
My lord, case is about 498 atrocity.
498 atrocity. Atrocities Act.
Atrocity Act 498. On January 13th, partly heard regarding SC Atrocity Act. FIR delayed for 7 months. I believe you convinced to quash Atrocity Act. Now I will come
Atrocity between husband and wife, is it?
Yes, my lord.
That will go.
One submission. One of the neighbors saw this happen. Her statement, your lordship.
Husband and wife atrocity ಬಿಟ್ಬಿಟ್ರೆ ಮುಗಿದೋಯ್ತು ಆಮೇಲೆ. Yes. ಮಿಕ್ಕಿದ್ದೆಲ್ಲ will see.
I'll leave it to your lordship.
Now I will come on 498A.
Come.
I will read documents of R2 statements, my lord.
No statement, straight away go to the charge sheet. I am not here to decipher the statement. I am not sitting in appeal. It is only 482.
Charge sheet statements only.
Charge sheet statement alla. Where is the complaint? 25/11/22.
Page 20. Column 17.
ಬಂದೆ.
You offend again. Against you.
Page 26, sir. Yes.
Very
11.
Oh, yes.
Yes, sir.
Permit to share judgment and comparison table I created with Achin Gupta judgment, my lord.
Judgment, no problem. Yes, sir.
Ma'am,
Ah,
I prepared one comparison table with Achin Gupta. Achin Gupta allegations and my allegations, if we read, my allegations 30% or 40% more allegations in Achin Gupta, my lord. Unexplained delay, Supreme Court observations is there. And in my case also delayed for 7 months. And vague omnibus allegations are there. Supreme Court observations is there. In my case also complaint lacks specific date, specific cruelty or specific things missing, my lord. And Achin Gupta observation is that fair opportunity got complainant, they can file cases anytime. First time in Achin Gupta, divorce case filed by Achin Gupta, Achin Gupta mother filed domestic violence. In my case, I filed first FIR, my lord. In Achin Gupta is dispute like civil property. In my case also civil dispute. Every time whenever they're asking about the laptop, old laptop 5,000 worth and Splendor bike, my lord. And counter blast like Achin Gupta, in my case also counter blast is there, my lord. Lack of independent evidence in Achin Gupta, in my case also no witness, my lord. Only one witness is 161 statement given by Rambabu PW9. He's friend of R2 father. 15 years old friendship is there. In his statement, nothing is there, my lord, about dowry or cruelty or anything. He's from starting onwards to last, every event he's present. He stays in Hyderabad. Every event he's present, my lord. And in Achin Gupta, Quirk is dropped. In my case also, Quirk is dropped, my lord. My lord, I want, please, third page. In cross-examination statement given by R2, 8th April, they did not complain any. On 8th April, incident happened, they said, but not given any complaint in cross-examination, she said.
When did the charge framed?
On 10th April, visited police station, but not given any complaint about cruelty or atrocity or anything, not given complaint. On 12th April, I had a call with her father. On that day also not questioned anything about cruelty or anything. And their friend, sorry, the relative Shiva threatened me many calls.
Shiva?
The relative. He threatened me, abusing me, he will kill me or something like that. On 24th, their father visited Hyderabad. She said that on that day they asked about bike, old bike and laptop, but not questioned about cruelty or anything. On 28th April, I received WhatsApp message. Her mother asked me to send this laptop, bike, or serious action will be taken. All these things, it is in cross-examination, my lord. And 4th
cross-examination charge frame ಆಗಿದೆಯಾ?
No, in MC case.
MC case.
On 4th May, her mother and R2 visited police station. They given complaint only about bike, laptop, my lord. On August 1st, they visited Hyderabad police station. On that day also, they given complaint only bike, laptop, my lord. On 2nd November, I filed FIR in Hyderabad. On 6th November, I received call from her dad for settlement, he said. And 16th November, they visited Hyderabad for station bail. And 25th, they filed a FIR. It's showing like the counter blast. I filed FIR on November 2nd, and they filed FIR on November 25th. And also last page, my lord, Thermal Limited versus KM Johnny judgment.
Johnny?
Yeah, sir.
Yes.
Last page.
All right.
In this also, where earlier complaints on the same allegations were investigated and closed as being civil in nature, and the complainant suppressing those facts, again invokes the criminal process. Such proceedings amount to abuse all process of law and liable to be caused. Here also, they filed a complaint in Bangalore police station in KG Halli on May 4th. That one not taken cognizance. In Hyderabad, they filed a case, not taken cognizance. Then they filed with these allegations. This is about thermoplast I am relying. And Bhajanlal category AE I am relying, my lord.
No settlement, is it?
No. Bhajanlal category A. Bhajanlal category AE, even if the complaint is accepted as true for the purpose of this petition, it does not describe any specific act of cruelty with date, place, and manner are required for section 498. The narration is of insults, dowry, dissatisfaction, payments, and quarrels without the legal particulars required for the offense. Therefore, the ingredients of the section 498 are not made out. This attracts Bhajanlal category A, my lord. My lord, next page. Harassed, tortured, insulted for years. It is keywords in complaint. No particular of date, place, and manner. It is in complaint copy, my lord. Demanded 5 lakhs dowry not sufficient. In complaint it is there. Demand alleged no cruelty act linked to it. 1.25 lakhs transport payments. Payments shown no cruelty linked to them. I transferred 3 lakhs. Permit me to share bank statements.
Not necessary. You submit. So you are Achin Gupta's brother.
Yes, sir. Yeah, it is like that only. I seen everything is like that only.
Oh.
But my allegations are less comparing to Achin
What's
Gupta.
your name? Sachin Gupta?
What, sir?
What's your name?
My name is Manikiran.
Oh, so no, Samandha.
So in Achin Gupta, he asked car, but they given money. Here they're saying that I am asked car. In MC, she says that I'm scared with driving car. She only said I'm asking car. And
You don't know to drive.
Means I'm scared, my lord.
You're scared.
I will drive very slowly. So like that. So if allow me 2-3 audio recordings, transcripts.
No, that's enough.
Okay, then I will close with my lord judgments.
No, that I know. Yes.
This one, my lord, Abuzar Ahmed and Vimla N. I created this one also comparison table, my lord. In Abuzar Ahmed is also petitioner. It is also 498 case, my lord. And it is also married in 2017 only, my lord. Complaint registered after several years. Here also. What?
You should only Achin Gupta.
They are supporting me, my lord. All brothers are.
Right.
With judgments.
Wait, yes, madam.
Your Lordship,
Mic on madidira.
it's on. Family dispute, arranged marriage. Husband is from Andhra Pradesh. Now, husband and wife had gone on a trip to his hometown. there was some incident that has happened. Then he filed a complaint against the wife saying attempt to murder. And this dentist, the respondent number
wife,
2,
wife attempted to kill the husband.
allegedly, with a knife. That is the knife that dentists use.
Oh.
Because she carried it with her. That is the allegation that the petitioner has as against the respondent in this particular case. Simultaneously, over there, no cognizance is taken. The husband, her father and the mother bring her back to Bangalore. Then counter complaints were filed, and then domestic violence, all of that started. The entire barrage of family court cases.
So what made the filing of the case attempt to murder? Why? Relationship had floundered?
Yes. Yes, with various allegations. At present, there is an MC case that is pending. It is listed on 15/4. As against this complaint, there is a special CC65 that is pending. That's also on 15/4.
That is atrocities. I will quash.
Please.
Definitely.
The MC case is posted for his cross-examination.
All that. Now 498A.
There has been violence, Your Honor. The fact that he takes her saying under false pretense, saying that I'll take you out for a trip. Take you out for a trip to my hometown, and then acts in such a way that this thing happens. It's not like he is the one who committed the offense by himself, by hurting himself. That is number one. And number two, Your Honors, he is a budding lawyer in Andhra Pradesh. His fee is paid by the mother-in-law. He lives with his mother-in-law and father-in-law in the respondent's house. So everything that he has, it is through his in-laws, and they have always been
parents of the complainant.
parents of the respondent.
The complainant.
Yes, yes.
Wait. Finish. Yes.
They have given him everything that he could possibly want. His submissions that there is a bike that was taken, that belonged to them. The laptop belonged to the father and the mother, and it was their work laptop, which is why.
That's all the demand. That's all the demand.
And there has been various other allegations also.
Money has been paid.
Money has been
Money
paid.
has been.
How much?
Page
Wait,
20,
I'll come
Manoj.
back to you.
Okay. Page 20. The instance of incident and dates are also mentioned.
Page 20.
20. The second para, my lord, just from the bottom, your lordship finds the date, my lord, on 24/11/2021 to 27/3/2022.
Correct.
He received 1.25 lakhs through Google Pay. Then further demanded the dowry. Again on 8/4/2022, there was a fight.
What do you work as?
Sorry, my lord.
What is your avocation?
My lord, I am.
Not vacation.
Sorry.
Avocation.
I didn't get it, my lord.
What do you work as?
Past, I used to do software sales, my lord.
Pasha Institute.
Past, I used to work in software sales. I
Now?
used to do. Now, after this one, I have to start practice advocacy.
Oh.
Permit to share bank statements. I sent more than 3 lakhs to R2.
For why? For what purpose?
I helped them loan. I given loan to them.
They demanded dowry.
Yes, my lord. You can see bank statements.
All right. Yes, we'll see. We'll answer. Ashana?
My
If
lord.
I may, one submission. Applications pending, Your Honors, for CBI inquiry.
CBI?
Yes, my lord.
For what?
I
filed FIR February last week in trial
CBI
court.
inquiry against whom?
IO in Bangalore against me. Charge sheet he filed February last week. But February first week, he shared case documents with retired DIG and retired SP, my lord. Before filing, he shared documents with
That's
them.
why CBI should come in, huh?
Well, because
You don't want FBI? Yes. Heard reserved, yes.
Group 79.
My lord,
Yes, sir.
2 submissions from audio recording.
No, it's enough.
Only 2 submissions, please.
This is enough.
Light.
79.
ಪೃಥ್ವೇಶ್ ನಿಮ್ದೊಂದು ಸೈಂಟಿಸ್ಟ್ ಇತ್ತಲ್ಲ ಏನಾಯ್ತದ? ಡಿಸ್ಪೋಸ್ ಆಯ್ತಲ್ಲ?
Acquitted.
ಅಲ್ಲ ಡಿಸ್ಪೋಸ್ ನಾನ್ ಮಾಡಿದೆ ತಾನೆ?
Your lord.
Yes.
That matter relates to IMM.
ಇದಾ?
IMM.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ವಾಪಸ್ ಬಂದಿರೋದ?
ಇಲ್ಲ. That your lordship.
ಡಿಸ್ಚಾರ್ಜ್ ರಿಜೆಕ್ಟ್ ಆಗಿರೋದ?
ಇಲ್ಲ.
ಮತ್ತೆ ಏನಿದೆ? ಅಕ್ಯೂಸ್ ನಂಬರ್ 2.
Yes, that was the accused number 2.
CBI ಬರ್ಲಿ. ಇವತ್ತು ಅವ್ರಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡಂಗಿಲ್ಲ.
One day.
Same.
Can I just?
Tuesday. 17th.
Please. Oblige. Could it be in fresh matter or very?
Already 18 my lord, I have request for weeks time I will grant it.
20 ಅಂದ್ರೆ 25th ಬೇಡ. 8th April. 8th or 7th madam?
81.
8th April.
Note serial number 81. The magistrate notes drops the DV proceedings against the parents-in-law, referring to the Shamlal Devda case, holding there is no clear allegation against the parents-in-law, and the relief sought is only a monetary compensation. But the session judge not set aside the order, observing that they are residing in the very same building. Therefore, it's a matter of trial, and it is dropped before the issuance of notice. Recalls the orders.
I'm for respond number 2, madam.
We'll take it on 25th.
Interim order ಇದೆಯಲ್ಲ? Interim order ಇದೆ. Kindly see the order dated 6/2/2026 minutes.
ಏನಾಗಿದೆ?
ಅದರಲ್ಲಿ ಅವತ್ತು court observed my lord, if the other side are not present, the matter would be heard.
ಇದರಲ್ಲ ಅದರ
I'm for respond number 2, respond number 1.
ಅದು ಇವತ್ತು ಬೇಡ.
Let it come in the admission.
It will come. List the matter. ಏನ್ WP ಇದು? List the matter on 24 ಅಲ್ವಾ? 25th for a preliminary hearing.
Yes.
Even today there is no representation on behalf of the second respondent.
Second respondent.
First respondent. This court had already indicated that in the event the first respondent would not be present, orders would be passed on hearing the other parties. In that light, as a last chance, list the matter on 25th. In the event the first respondent would not be present, the petition would be disposed on hearing the parties. Interim order stands extended to the next date of hearing.
My lord, 82. My lord, section 7A and C, my lord. My lord, ಇದರಲ್ಲಿ 16/7/2025 ಗೆ petition transfer ಆಗಿ ಬಂದಿರೋದು my lord. Only 1 month 10 days before charge ತಗೊಂಡಿದ್ದಾರೆ. 28
ಬ್ರದರ್ ಜೊತೆ ಹೇಳಿ ಮೇಡಮ್.
FIR lord, kindly see page number 14 my lord. ನಾನು ದಿನಾಂಕ 26/8/2025 ರಂದು ನನ್ನ ಮೊಬೈಲ್ ಫೋನ್ ಇಂದ ವಾಯ್ಸ್ ರೆಕಾರ್ಡ್ ಆನ್ ಮಾಡಿಕೊಂಡು ಪುತ್ತೂರು ತಹಸೀಲ್ದಾರ್ ಅವರ ಕಚೇರಿಗೆ ಹೋಗಿರುತ್ತೇನೆ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರ್ಲಿ ಮೇಡಮ್.
ಮೇಡಮ್ ಪ್ಲೀಸ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ. ಇಲ್ಲ ಇದು 3 days ಅಲ್ಲಿ ಇದು ಇಶ್ಯೂ ನೋಟಿಸ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾರು?
ಇದು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಇಲ್ಲ ಅಮಾನತು ಮಾಡ್ತೀವಿ ಅಂತ ಸಿನ್ಸಿಯರ್ ಆಫೀಸರ್.
ಅಮಾನತಿನ ಸಿನ್ಸಿಯರ್
ಅಲ್ಲ ನಿಜ ರಿಯಲಿ ಮೇಡಮ್ ಪ್ಲೀಸ್ ಮೇಡಮ್ ನೋ ರಿಕವರಿ ನೋ ಪ್ರಿಲಿಮಿನರಿ ಇನ್ಕ್ವೈರಿ ಮೇಡಮ್.
ಅಲಿಗೇಷನ್ 7A ಸಿನ್ಸಿಯರ್ ಆಫೀಸರ್. ಎಸ್ ಎನಿವೇ ಪ್ರಸನ್ನ ಶೆಟ್ಟಿ ಬರ್ಲಿ. ಅರ್ಬಿಟ್ ನೀವು ಇಲ್ವಾ ಲೋಕಾಯುಕ್ತಾಗ ಈಗ?
ಈ ತರ ಕೊಟ್ಟು ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ.
ನೀವು ಇದ್ದೀರಾ?
ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಮೇಡಮ್.
ಪ್ರಸನ್ನ ಶೆಟ್ಟಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ದಾರೆ. ಐ ಥಾಟ್ ಯು ಆರ್ ನಾಟ್ ದೇರ್ ನೌ. ಎಸ್ ಏನದು ನೋಟಿಸ್ ಕೊಡಿ. ಏನಮ್ಮ ಇದು ಅಟ್ಯಾಚ್ ಮಾಡ್ತೀರಾ ಪ್ರಾಪರ್ಟೀಸ್ ಈವನ್ ಬಿಫೋರ್ ದಿ ಪ್ರೊಸೀಡಿಂಗ್?
NOC ಕೊಡಬೇಕು ಏನಿಲ್ಲ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ.
List the matter on 26th in the fresh matters list. ಅಲ್ಬೇಡ ಬಿ ಗ್ರೂಪ್ ತಾನೆ ಇದು. 26th the notice dated 9/3/2026 shall remain state till the next date. Yes. ನೀವು ಕಾಯ್ತಾ ಇರೋದು ಯಾವುದಕ್ಕೆ?
87
ಮುಗಿನಿ ಫ್ರೈಡೆ.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್
1 month ಆಯ್ತು ಅದಕ್ಕೋಸ್ಕರ.
ಗೊತ್ತಾಯ್ತು ಫ್ರೈಡೆ.
6 months ಆಯ್ತು ಮೇಡಮ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್.
ನಿಮ್ದಲ್ಲ ಮೇಡಮ್ ಅವ್ರದ್ದು ಬೇರೆ.
fresh matter
87 I'm appearing for.
Appearing for the respondent number 2.
ಇದು ಮದುವೆ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, ಮದುವೆ ಆಗಿಲ್ಲ. Section 9 and 10 of child marriage.
ಏನಿದೆ 80?
87 my lordship. Parties,
Settlement.
both are present my lordship.
Offense ಏನು?
9
and 10 of child marriage.
Child marriage. ಇದು ಆಗಿಲ್ಲ ಸ್ವಾಮಿ, but there is no marriage has not happened my lordship.
Marriage at all?
Marriage has not happened.
ಮತ್ತೆ ಸುಮ್ನೆ ಯಾಕೆ ಮಾಡಿದ್ರು?
Yes my lordship. There is a vengeance between the husband and wife my lordship. Petition number 2 is a wife my lordship.
Let's see, let Jagdish secure instructions.
My lordship.
ಈಗ ಯಾಕೆ ಬಂದ್ರಿ ಮೇಡಮ್?
Last petition also.
ಮೇಡಮ್ ಕ್ಲೈಮ್ಯಾಕ್ಸ್ ಅಲ್ಲಿ ಯಾಕೆ ಬಂದ್ರಿ?
My lordship.
Yes.
No, settlement.
No. Wait.
Can you peruse
Child Marriage Act, I am not going to settle at all.
My lordship, can you peruse the
Marriage ಆಗಿದೆ ಇಲ್ವಾ ಅಂತ ನೋಡ್ಕೊಂಡ್ ಬರ್ಲಿ ಅವರು. Child Marriage Act don't expect settlement at all.
Yes my lordship.
ಅದು ಪೇರೆಂಟ್ಸ್ ಯಾರ ಮೇಲೆ?
Parents my lordship. The petitioner number 2 is a mother my lordship of the victim. Petitioner respondent number 2 is the husband my lordship.
What was the age of the child?
17 my lordship.
16?
17.
At the time of marriage?
16 my lordship. 17 my lordship. 17.
Yeah, get the instruction. I am not settling
My
any.
lordship, one submission. Can you peruse 1 second my lordship for the
Yesterday I have
complaint, my
written an
lordship.
order. ನೀವು ಇರ್ಲಿಲ್ಲ.
My lordship.
ಇನ್ಮೇಲೆ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ಸೆಟ್ಲು ಇಲ್ಲ, ಇಂಟರ್ಫರೆನ್ಸ್ ಇಲ್ಲ.
Can you peruse the 1 for second my lordship? Can you peruse the page number 12 my lordship? ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ತಮ್ಮಲ್ಲಿ ಕೇಳಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ಸ್ವಯಂಸು ನಾನು ಈ ಸುಮಾರು 17 ವರ್ಷ ಹಿಂದೆ ಸಾಹಿರಾ ಎಂಬ ಬಾನು ಎಂಬಾಕೆಯನ್ನು ಮದುವೆ ಆಗಿದ್ದು ನನಗೆ 2 ಮಕ್ಕಳು ಇರುತ್ತಾರೆ. ನಾನು ಸುಮಾರು 8 ವರ್ಷಗಳ ಹಿಂದೆ ನನ್ನ ಹೆಂಡತಿಯೊಂದಿಗೆ ಗಲಾಟೆ ಮಾಡಿಕೊಂಡಿದ್ದು ನನ್ನ ಗಂಡನ ಮಕ್ಕಳೊಂದಿಗೆ ಬೇರೆ ಕಡೆ ವಾಸವಾಗಿದ್ದು ನನ್ನ ಹೆಂಡತಿಯು ನೀಲಸಂದ್ರ ಸದ್ದಾಂ ಪಾಷಾ ಜೊತೆ ವಾಸವಾಗಿದ್ದು.
ನೋಡ್ಕೊಳ್ಳಿ ಯಾವತ್ತು ಹಾಕ್ಲಿ?
Tuesday.
List on Tuesday.
Stay my lordship.
No stay. Child marriage?
My lordship.
No stay. Yes.
Mother hearing?
Election to the pharmacy council.
ಯಾವ್ದಿದು?
Election to the pharmacy council.
Oh, yes sir. ಹೇಳಿ.
Hearing for the state, my lord. I seek
So
a
you are here. All right.
I seek a short accommodation.
Hey, no madam. Election stay ಆಗಿದೆ ಅಂತ ಗಲಾಟೆ
My lord,
ಮಾಡ್ತಿದ್ದಾರೆ.
Since from 2 years, my lord, the administrator has been appointed.
ನಾಳೆ ಹಾಕ್ಲಾ?
Next week, my lord.
Oh, no.
I've just been.
How long will the administrator go on?
The entire
My
pharmacy
submission is
council has
next week,
stalled
my lord.
because of administrator appointment.
Why is it further hearing ಹಾಕಿದೀನಾ?
One matter lordships have heard and further
Election
connected matters ಎಲ್ಲ ಈಗ ತಮ್ಮ ಮುಂದೆ ಬಂದಿದೆ ನಾವು ಹಾಕಿದ ಮ್ಯಾಟರ್ಗಳು.
ಓ ಅದಾಗೆ ಬಂದಿದ್ಯಾ? By special order. I can't send it also now. I thought I'll send it before the appropriate court. Bench having roster ಕಳ್ಸೋಣ ಅಂದ್ರೆ ಅದು ಆಗಲ್ಲ. Yes.
Next week, my lord.
No madam. When are you free? GM court ಅಲ್ಲಿ ಇದ್ದೀರಾ ಈಗ? When are you free?
My lord's next week, beginning of
ಇದು
next
ಕೋರ್ಟ್ ಮೇಡಮ್, ಪ್ರಯಾರಿಟಿ ಕೊಡ್ಬೇಕು ನೀವು.
Any day next week, my lord, at 4 o'clock, if your lordships will.
Tuesday?
Make my Tuesday.
Tuesday we'll close it. Tuesday at
2:30 p.m. That's urgency.
Later you finish all your work and come.
Please.
4 o'clock.
4 o'clock. 4 o'clock, my lord.
4 o'clock. 4 p.m. Madam, I won't adjourn it. I would mugspoon because election matter whether it should stay or not. That's all.
The payments, salary has been not paid by the employees.
Aye. Ella will close it.
End of the list 20, Saravana is.
Reporting settlement laws.
Yes, sir.
Offense under section 420. One partner files complaint against another partner. Dispute arose in the course of the transaction, partnership business transaction.
Buds ಅವೆಲ್ಲ ಕಲೆಕ್ಷನ್ ಅವೆಲ್ಲ ಏನು ತಾನೆ?
ಏನಿಲ್ಲ.
Indenture participant. Yes.
Comes of the joint memo it may be.
ಎಲ್ಲಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
The joint memo ಕೊಟ್ಟಿದ್ದೀನಿ.
ಬಂದಿದ್ದಕ್ಕೆ ಒಂದಾದ್ರೂ ಆಗ್ಬೇಕಲ್ಲ. Yes.
Order sheet.
Sign ಮಾಡಿ. Yes.
Sorry, my lords, I made a wrong submission that day stating, thinking that my lords affidavit we had filed. I'm so sorry, my lords.
ಏನ್ ಹೇಳಿದ್ರಿ?
I'm sorry, my lords. That's I am.
Sign ಅಂತ ಹೇಳಿದಿರಾ ಇಲ್ವಾ? I told you I don't forget. Yes.
Not affidavit, my lords. Since my lords, it's
That's
still my
all
mistake.
right.
Still my mistake. I apologize.
I'm sorry, my lord, one submission, my lord. But one matter for the settlement, my lord, for tomorrow, my lord. Yesterday I moved the matter, my lord, but date has not been given, my lord.
ಸೆಟಲ್ಮೆಂಟ್ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಕೊಡ್ತೇನೆ ಸಾಯಂಕಾಲಕ್ಕೆ.
Parties are coming from the villages.
ರಾತ್ರಿ ಸೆಟಲ್ ಮಾಡ್ಬೇಕು.
No, my lord.
ಮತ್ತೆ 2:30 ತಗೊಂತೀನಿ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಸರ್.